Good morning, everyone. Good morning, Advocate Noko. Good morning, Ndate Chauke. Advocate Hoe. You remember where we ended yesterday when we adjourned? I think we were around paragraph 32 of the affidavit of the witness. Before we proceed, Advocate Noko, you are still under oath.
Yes, Chair.
Thank you, ma'am. If my recollection is correct, we had just been dealing with MN3. But you can start where you consider it fit. Reference to MN3 is at page 10, paragraph 32. You may begin, madam.
Thank you, Chair. Advocate Noko, yesterday when we adjourned, you had just gone through paragraph 32, which is on page 10. We were dealing with annexure MN3, and the Chair had asked whether all the cases that you listed on page MN 00005, MN3, were all relevant. And you had responded that not all of them were relevant. And for purposes of this inquiry, number 5 is Katomana. And in the document, if you go to page MN 00027, bold red.
Oh, yes, I have it. I have it.
Can you read that into the record?
Okay. Thank you. It's about, it says, titled Katomena Prosecution. It says, this case reportedly started around 2011 and dealt with by the IPIT, DPCI, and the NPA. From the NPA, the prosecution team comprised of Advocate Sello Maema, the lead prosecutor, Advocate Raymond Matenjo, co-lead prosecutor, Mahlubin Tlagaza, Patience Moliko, Jabulane Mlojwa, Pumeza Fuchani, and overseen by DPP South Gauteng, Johannesburg, Advocate Andrew Chauke. Then, in consultation with the acting DPP KZN Advocate Simpiwe Mlojwa, the then acting NDPP Nomgcobo Jiba and Advocate Chauke formulated this prosecution team to deal with this case. Please find an affidavit by Advocate Sello Maema in this regard that sheds further light into the background of this case and what led to the prosecution team's memorandum for the application for the issuing of fresh racketeering authorization by NDPP Advocate Sean Abrams. This is attached as Annexure CC. I was invited to a meeting at head office with the NDPP, Mr. Mxolisi Nxasana, DNDPP, Dr. Silas Ramaite, Advocate Andrew Chauke, and the prosecution team. This meeting was for the prosecution team to brief the NDPP and DNDPP about this case. At this meeting, Mr. Nxasana instructed that I am to be the DPP that must oversee this case and not Advocate Chauke anymore, as this case falls within my KZN jurisdiction. This case still remained mainly dealt with by the prosecution team and handled from head office in the Priority Crimes Litigation Unit, PCLU, where the lead prosecutors, the deputies, were then based. with Advocate Tori Pretorius as the then acting head, acting unit head of the PCLU. The case dockets, documents, and all other information in this case were kept by the prosecuting team at DPP South Gauteng, Johannesburg, and the PCLU office at head office, respectively, as informed by the prosecution team. I relied on the briefings and prosecution memoranda by the prosecution team about what the cases were all about. I had confidence in the prosecution team comprising of senior and experienced prosecutors led by 3 deputies, being Matenjwa, Maema, and Mlojo, supported by 3 senior state advocates, being Fuchani, Muleko, and Tlagaza. I thus had no reason to doubt their briefings and memoranda to me, hence my reliance thereon. During July 2015, I attended a briefing. I'm sorry, Chair, to interrupt myself. I've already read all this from my affidavit. I feel like I'm repeating. Should I still go on? But maybe I would start with the cases, maybe.
The reference to MN3 at paragraph 32 is covering part of what you are stating in your affidavit.
Yes.
Perhaps you can go back, Advocate Kowe, and see if we are not repeating that which she has said and or covered in the affidavit, because the annexure seem to be giving some details. I don't know whether you look to check whether the details that is in the annexure is not covered in the affidavit. If not, you can lead the witness on that, so that you don't repeat, she doesn't repeat herself.
All right, Chair. They are. I think basically what I was doing was to just make sure that whatever she had left out in her affidavit is also captured on record. But I see the parts that she says she has repeated, and I am comfortable to move on to the next paragraph of her statement.
Yes.
The cases. Okay.
Okay, you may continue.
Thank you, Chair.
You are better placed to assist us
Yes.
with those aspects of your evidence that are not covered in your affidavit,
Yes.
that appear in the annexures.
Yes, Chair.
Thanks.
Thank you, Chair. I will then go straight to the cases, which is on still MN 00030 on page 26. The prosecution team unpacked and presented these various case dockets as follows. 1, Kwaduguza case 39 of 9/2008. The deceased is Lindelani Buthelezi, a taxi owner at Kwamaphumulo Taxi Association. The incident happened on the 3rd of September 2008. In the indictment, it involves counts 3 to 7.
I beg your pardon, where are you reading now?
On page 25 of MN 00030.
25.
Page 25, at the bottom it's written 25, yes.
Are you referring to the bolded rates?
Yes, the MN, yes, in bold red.
Can council assist us?
Where is the witness really?
MN 00030.
30.
Okay, Chair, can I help? I realize the report that was attached is dated 27 October 2020. As far as the cases are concerned, it's exactly the same as the 15 September 2021. 2020. So I can read from MN quadruple 05 then. I think that is what you have.
No. The
Yes.
council should lead you. I know that you are also an advocate, so but allow her to lead you, so that we know we are together.
Yes, Chair.
You are referring to the Katomena cases.
Yes, Chair.
And those cases in this annexure MN3 starts at MN 000030. Am I correct? With the case of one Kwaduguza, case 39 stroke dash 09 dash 2008 at that page.
Yes, that is the one, Chair.
That is the cases that we want to refer to.
Yes, Chair.
You have that, Council?
Yes, Chair.
Perhaps we must stick to the document that we are all having here. That is the October document.
Oh, yes. That is the one I have, Chair.
Yes.
Okay. Can I proceed?
Yes, you can proceed
Okay.
with the cases.
Okay. Number one, Kwaduguza, case 39 of 9/2008. In this case, the deceased is Lindelani Buthelezi, a taxi owner at Kwamapumulo Taxi Association. The deceased was suspected of involvement in killing of Superintendent Konko, allegedly in the presence of his girlfriend, Tandega Sokulu, whose statement is filed in the case docket as 821. While asleep, accused 4, 8, 13, and 22 broke and opened the door, while accused 6 kept guard outside. The deceased lifted both his hands up. His girlfriend was placed in a separate room where she was assaulted with open hands and kicked with booted feet. And count 4 was opened for that assault. Accused had 7.65 millimeter firearm with serial number obliterated, and this firearm was placed next to the deceased to create an impression that the deceased was armed and or would have used the firearm to shoot and endanger their lives. That is just a summary of this case.
Yes, I'm sorry to interrupt you, so that we recap and remember
Yes, Chair.
why we are here
Yes,
in
Chair.
respect of these cases.
Yes, Chair.
You were responding to the letter by Advocate Batoi.
Yes, Chair.
You said that letter was dated August 2020.
Yes.
Do you have a copy of that letter that requested you to report?
I don't have it anymore. I don't have access to emails of the NPA anymore.
And in this report,
Yes.
you were informing Advocate Batoi of these cases that involved the Katomena members.
Yes, Chair.
What appears from page MN 00030
Yes.
up to quite a number of cases.
Yes.
Is it 39? I think up to 39
Yes, Chair.
are the summaries. What you
Yes.
provide there are the summaries of the cases that involved the Katomena members.
Yes, Chair. That is correct, Chair.
Kirkoe. If I may, the second case is the one involving Mr. Ndimande.
Yes, Chair, as the deceased.
the Howick case.
Yes, Chair.
You may briefly go through that.
Yes, Chair. In Howick case 106 of 9/2008, the deceased are Mr. Magojela Ndimande, who was a taxi owner for Kwamaphumulo Taxi Association, and his bodyguard, Mr. Sibusiso Tembe. Allegedly, the deceased was previously handed to organized crime unit members during August 2008 for questioning regarding the killing of Superintendent Qonqo, but was released as not linked. On 16 September 2008, the accused pursued the deceased on the N3 highway near Howick and were killed. Accused 4, 5, 6, 8, and 15 and 16 were allegedly present and falsely alleged that the second deceased, who is Tembe, shot at them and they returned fire. Accused 1 and 9 allegedly arrived at the scene in a helicopter. They were present as managers of the enterprise. It is alleged that the scene was tampered with and an AK-47 with serial numbers 1975, 8491, 754 was placed to create the same impression of attack from the deceased. And AK-47 cartridges placed on top of the blood inside the car. The ballistic expert, Mr. Stale, which is his statement is A41 in the case docket, stated that the car's windows were closed and no indication that shots were fired through the closed windows. A43 allegedly accused 4 warned security company to remove the guard. So that was the guard that was at the scene and removed.
Sorry, Madam Chair,
Can I-
I just wonder whether the witness cannot tell us when he says accused 1.
I was actually going to,
Oh, I
to
see.
address that, yes. Throughout this document,
Yes, Chair.
you refer to accused, I think frequently 2, 4, and others.
Yes,
And
Chair.
it is not clear to us who are these accused people. Where do we find their names? I do know
Yeah.
that accused 2 was Padayaki. Do you have the names of this accused elsewhere, or can you, at a later stage, give us full details of these accused people, accused persons?
Yes, Chef. The details of who's accused number 1 then are in the indictment, and I don't have a copy of the indictment. But I know accused 1 is Major General Poison. I remember he's accused number 1, but the rest I don't know who's who. The indictment should be able to provide that.
And you were summarizing
Yes.
from the indictment of each of these cases,
From the prosecution memorandum.
from the prosecution.
Yes, which was
memorandum.
compiled by the prosecutors.
Had you had a sight of the indictment
Yes.
in respect of these cases, other than looking at the memorandum?
I had sight of the witness statements. The witness that I'm referring to in my affidavit.
Yes.
I was given those statements.
Yes.
Yes, so I had sight of some of the witness statements, the prosecution memorandum, the indictment, the slide presentation document, and others that may have been sent to me. But not all the witness statements I read, but I have what I've read.
Yes, it seems to me, Advocate Poe and your team, Advocate Skosana, Advocate Mtweni, you'd have to assist us there. We have a number of dockets that have been filed of record. We may have to go through those dockets to ascertain who these accused persons are. I'm not sure whether that can be done today. Advocate Halley, I'm sure your junior can also assist us.
Madam Chair, they are in the witness's own documents from page MN 00062.
62.
Yes, and then the first accused appears at MN 00068. My concern was simply that when he says accused one, we don't know who he's talking about, but they are in the witness's own documents.
Yes.
Sorry, it starts at 00062.
That would be Miami's memorandum.
Memorandum, yes, madam.
Memorandum.
And then the first name of the accused is at 68. Well, actually, all of the accused start from 68 up to 71.
My apology, Chair. Yes, the memorandum is here with the names. Thank you.
Oh, yes, this is helpful,
Yes.
Advocate Toby. Would you please, all of you, put your mobile phones on silent? Yes. Yes, indeed.
Yes, it does.
No, thank you very much. We will cross-refer, understanding that those accused that you are referring to are exactly the accused who appear
Yes.
from those pages, pages 68, as Advocate Toby has assisted us.
Yes.
Yes.
Yes, Chair. And my apology, yes, the memorandum is here with the names. Now I'm thinking only of the indictment, whereas they're here. I apologize for that.
Yes, thank you.
Okay, so should I proceed to? Okay. And then number 3 is Mandini case 76 of 9/2008. The deceased are Mzameni Johannes Sintuli, Nkosinati Wilson Mtembu, they were both taxi owners at Komapumulo Taxi Association. And the incident happened on 18 September 2008 in respect of counts 13 to 18. It is alleged that under the pretext of intending to arrest the 2 deceased persons for killing Superintendent Konko, accused 3, who is Stoltz Adrian Jacobus Fick, and 4 and 13, who are Mr. Mostert Paul Johan, and 13 is Mr. Rubendran Naidu. Allegedly, they entered the bedroom and fired shots at the deceased, while accused 6, 8, 10, 11, 12, and 15 guarded the house for escapees. 6, 8, 10, 11, 12, and 15 are 6 is Eric Alfred Nell. No, that's there's no 6 now here. Don't know whether it's a typo or what. But then there's 8, 10, 11, 12. I don't know. 8 is Pumelela Makanya. 11 is Mdlalose Tata Ipi Enoch. Chair, the prosecution memorandum does not, it jumps other numbers. So we will need the indictment to check and verify the names. I can also do that, verify and see whether I get all the names according to the numbers
Yes, I
and
think
provide them later.
you can compile
Yes.
a list of those accused persons according to your understanding,
Yes, Chair.
and then provide it to the evidence leading team,
Yes.
because when you cross-refer like that, then you can at least have a list of those accused persons,
Yes.
and then compare them
Yes, Chair.
with the list that appears in the memorandum of Advocate Maema.
Yes, Chair.
Then if a need to correct, then you can correct from your list
Yes.
according to your testimony,
Yes.
remembering that you speak under oath.
Yes, Chair.
Will that be helpful, Advocate Kwaitobi?
Yes, Madam Chair. I see also that 6. Well, they're missing accused in the memorandum.
Yes.
So I
Yes.
think the witness is correct. Thank you.
For instance, number 6 is not there.
I will
Let's just do
Chair.
that
Yes, Chair.
later in the day.
Yes, I will do that, Chair.
Before we move on, if we go to paragraph 26 of your affidavit, in your quotation, we don't have accused number 6, number 12, 17 to 25. We don't have them in the quotation at paragraph 26 of your affidavit. That is page 8 of your affidavit. So when you listed, you said the state has evidence linking the entire members of the enterprise, including accused, and then you listed the numbers, but there is no 6, there is no 12, and 17 to 24.
I will verify. However, now I think I remember some of the accused have passed away. They are deceased. And in the initial indictment, they had already been labeled like that. So even though some had moved out because of being deceased, the numbers allocated to the accused persons remained. I remember, but I will see how I verify this.
Thank you.
Yes, Chair.
Can pause. My researcher tells me
Yes, Chair.
the bundle of Major General Boysons has a list of all the accused persons.
Oh,
And there we have number 6, that is Eva Neville, deceased.
He has passed away, yes.
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 So when you prepare that list, you can
Yes.
do that list and speak to it later in the day.
Yes, Chair.
You will have this volume
Yes,
in
Chair.
respect of which the accused people are properly,
Yes, Chair.
and full details is given as regards those who are deceased. For instance, number 6,
Yes.
and I see there's also 12 there. Zondi Bongani. When I read the document, it seems that Bongi also passed on, but you will check.
Yes, I will check, Chair.
Maybe we should leave it there. You have the list, then you
Yes.
can speak to it later.
Yes, I will do that, Chair. Okay. Should I proceed? Okay. And then the ballistic experts in that case, being Stale, who's 837, stated that deceased one was shot from the back whilst lying on the floor with exit wound on the carpet under the head. Deceased 2 was shot at 5 times while in a standing and lying positions. This negate any danger posed by the deceased. The case number 4, Umko Mask has 325 of 10/2008. The deceased is Mduduzi Mkize on 18 October 2008, and it relates to count 19. It is alleged that the deceased was arrested in Pietermaritzburg on a suspicion that he was involved in the killing of Superintendent Zetembe Tonko and was then transported to Scottsbury for questioning. Allegedly, the deceased was willing to point out Nati Kumalo, and while en route to do so, whilst handcuffed at the back of a police sedan vehicle, the deceased was shot by accused 17 as he allegedly tried to grab a firearm of accused 18. The prosecution team viewed this as improbable. Case number 5, Durban Central Case 185 of 2 of 2009. The deceased is Bongani Mkize, who was the chairman of the KwaMaphumulo Taxi Association, and it allegedly happened on the 3rd of February 2009, and this pertains to counts 20 to 24. It is alleged that after the killings of Lindelani Buthelezi, Chair, am I allowed to keep on elaborating as I read, or must I just read? I wanted to elaborate something here. I may. Okay, Chair. Yes. Yes, Chair. Okay. Okay. First of all, Mr. Bongani Mkhize, who was the chairman of the Goma Phumule Taxi Association, the deceased in this case, allegedly had made a high court application through his lawyers, Mr. Nkosinathi Shozi, after the killing of some of the members of the Goma Phumule Taxi Association. Allegedly, he made an application to the High Court for an interdict to interdict the police from endangering his life or killing him because he had heard that he was next in line. Statements of witnesses that I've summarized and also attached here will also talk to the planning of the killing of Mr. Bongani. So apparently it leaked out to him somehow, and then he made a High Court interdict to say the police must not kill him, and if they need him for any questioning or even arresting him, they must inform his lawyers. And the police responded through Major General Boysen in his affidavit to this High Court interdict application saying, yes, we will go through the lawyers, we will not endanger his life, things will be done properly as per the interdict. However, he was killed without the police having done that. So this is just one of the incidents. So Lindelani Buthelezi is one of those that the witnesses are saying their murders were planned, but that will be clear from their statements as we go to the witness statements. I just wanted to elaborate that. So it is alleged that after the killings of Lindelani Buthelezi, Magojela Timson Dimande, Mzameni Johannes Ntuli, Nkosinathi Wilson Tembu, and Mduduzi Mkhize, who were all members of the Goma Phumule Taxi Association. The deceased approached the High Court on 14 November 2008 and successfully obtained an interdict against the police not to kill him, averring that he was the next in line to be killed. The attorney of the deceased made an undertaking to hand over the deceased if sought by the police. Nevertheless, allegedly, the accused, being accused 2, 3, 14, 19, and 20 on 3 February 2009 waylaid the deceased, thus contravening the court interdict. There was no warrant of arrest for the deceased. The deceased was shot in a rain of bullets while driving along Umgeni Road in Durban. Allegedly, a firearm with obliterated serial numbers was placed on the floor of the front passenger seat of the Lexus car that the deceased was driving to create the same impression of attack or danger. None of the cartridges found on the scene matched the firearm found inside the deceased vehicle. It is further alleged that the deceased 2 cell phones were stolen. Those relate to count 24. Case number 6, Pinetown case 668 of 5, 2009. The deceased is Sibongiseni Ndimande, who was a member of the Goma Phumule Taxi Association and allegedly took place on the 23rd of May, 2009. It relates to counts 25 to 30. Allegedly, accused 2, 3, 16 forcefully entered the deceased house while accused 9 and 13 guarded outside for escapees. Accused pointed firearm at Zanele Madaba, which is in count 26, and stole her cell phone, which is count 13. It is alleged further that the deceased had a child in his hands and that the accused removed the child from him and threw the child to the deceased wife, who was instructed to leave the room. Then accused 2, 3, and 16 fatally shot at the deceased and placed the firearm next to him to create the impression that their lives were endangered. Case number 7, Rustenburg case 1098 of 9, 2008. The deceased is in demand. This is the case where Advocate Johan Smith, the then DPP of the Northwest, issued a consent for centralization in terms of Section 111 of the Criminal Procedure Act that we spoke about yesterday. The deceased is Fison Dimande. He was a member of the Goma Phumule Taxi Association, and it allegedly took place on the 20th of September 2009, and it relates to counts 31 to 34. It is alleged that accused 2, 4, and 6 traveled to Rustenburg to the deceased hideout, where the deceased has hidden himself. where accused 2 and 4 entered and fired shots at the deceased, fatally wounding him, while accused 6 kept guard outside. Firearm is alleged to have been placed next to the deceased. Case number 8, Berea case 288 of 5/2008. The deceased is Thabo Msimang, allegedly took place on May 24, 2008. Allegedly accused 4, 5, 6, and 13 forcefully opened with a crowbar and entered the deceased apartment, then fired shots at the deceased, who ran to the balcony and fell down or was pushed to the ground floor, and further shots fired as he laid on the ground. Accused 7, 8, and 11 allegedly secured the ground floor area for possible escapees. Firearm was placed next to the deceased to create the threat impression. Docket number 9, Melmoth case 142 of 11/2008. The deceased are Bongani Biela, Kanyisani Biela, allegedly took place on the 23rd of November 2008. Allegedly, the deceased were awakened by a loud bang early in the morning while sleeping, as doors and windows were broken. That is count 45, malicious damage to property and others. Accused 2 and 4 allegedly entered the rondavel of Richard Biela and pointed him with firearms, and those relate to count 42, assaulted him, that's count 41, and dragged him out of the room. Baba Biela Soma Kozazana, his brother's wife, being assaulted, that is count 43, and pointed with a firearm, that is count 44. He allegedly saw his 17-year-old son, Kanyisani Biela, lying inside his rondavel in a pool of blood, that is count 40. Bongani Biela was also killed, count 39. Firearms were placed next to the deceased to create the threat impression. Allegedly accused 2 and 4 fired shots, while accused 5, 7, 13, 14, 19, 25, 27, 28, and 30 were present. Docket number 10, Kwamashu case 629 of 2009. The deceased is Thokozani Njaba and allegedly took place on 27 April 2009. It is alleged that in the early morning of 27 April 2009, accused 2, 4, 5, and 6 forcefully entered the deceased premises at G section Kwamashu and fatally shot at the deceased in his bedroom. That is count 53. The deceased was a section 204 witness in a cash in transit robbery in KwaMaphumulo. It is further alleged that the accused stole cash and cell phone of the deceased and his wife, those constitute count 57, and placed a firearm next to the deceased to create a threat impression. The deceased wife and son are eyewitnesses. The ballistic expert, Stale, stated that the deceased sat on the bed facing the dressing table and the shooting was in a standing position to the left of the deceased, which dispels the notion that the accused were under attack. Docket number 11, Phoenix case 377 of 2009. The deceased is Lindo Gutlen Zuza, allegedly took place on the 10th of August 2009. It is alleged that the deceased was accosted by accused 4, 13, and 15 as he was driving along the M25 in Phoenix, who drove parallel his car and fired shots at him. Further, that the deceased car stalled, the accused alighted and fired further shots at the deceased as he lay defenseless. Then the accused placed a firearm next to the deceased to create the threat impression. Captain Mangena, whose statement is 822 in the docket, finding that the deceased was shot 4 times. It is alleged further that the deceased was first shot in the cheek, he became unconscious and fell back on the seat, then other wounds were inflicted whilst the deceased was lying backwards with his head on the headrest. That is according to the ballistic report. Docket number 12. Docket number 12 is Kwamashu case 698 of 11/2009. The deceased is Prince Tabete. Allegedly took place on the 26th of November 2008. It is alleged that in the early morning, accused 2, 3, and 4 proceeded to the deceased's house, broke open, entered, and fired shots at the deceased, fatally wounding him. The girlfriend of the deceased is an eyewitness who saw the shooting. Nkanyiso Ntenza, whose statement is A22, and Ngaba Mdluli, A21, alleged to have seen a Bombay spook firearm taken from the quantum vehicle and placed by accused 4 on the scene. The accused placed the firearm next to the deceased to create a threat impression. This firearm, the revolver, was defective. That was according to the ballistic expert. Ballistic expert Stay Lewis, 826, found multiple gunshots and that the deceased was lying on the bed when he was shot. The defective firearm dispels the myth that the accused were under attack. Docket number 13 is Kaweni case 3/4/2010. The deceased is Kwazin Ndlovu, a 16-year-old boy, which allegedly took place on the 1st of April 2010. It is alleged that in the early morning, accused 2, 4, 7, 8, 9, 11, 16, 23, and 24 broke open and entered the house of Mr. Ndlovu whilst looking for escaped prisoners, Tili and Dumisani Shandu. It is further alleged that accused 2 fired shots with R5 rifle at the 16-year-old boy as he was asleep on the couch in front of a switch-on TV set. The deceased posed no danger at all to the accused. Ballistic expert Captain Mangena, who is 831, found that the 3 bullet wounds, the blood stain pattern, and bullet holes all confirmed that the deceased was shot at while in a lying position on the sofa. Firearm was planted to create the impression that the deceased was a threat to the accused. Docket 14, Becky Temba, case 44/5/2010. The deceased are Musa Ngobo, Xolisani Ngobo, and Simpiwe Shozi. Allegedly happened on the 10th of May 2012. Allegedly in the early morning at J section in Begitemba, accused 6, 7, and 13 asked for the whereabouts of deceased 3. They kicked and broke open the door of the room where the deceased was sleeping. Deceased 3 was looked for in connection with the killing of Captain Reddy. Eyewitness is Sibongiseni Ngobo, whose statement is A6 in the docket. Docket number 15, Durban North case 67/7/2011. It's 3 of them. Durban North case 69/7/2011. Durban North case 71/7/2011. It has 3 deceased people: Jabulani Bengu, Dumisani Mgobozi, and Boyiswe Mbonambi, which allegedly happened on the 4th of July 2011. It is alleged that the deceased number 1 was spotted driving around Durban North. Accused 4 fired shots at the deceased whilst he was outside the vehicle. Ballistic expert Staley, A43, found multiple gunshots. Deceased 1 was lying or bending when he was shot at whilst outside the vehicle. Further, it's alleged that the accused proceeded to Mhlanga and shot at deceased number 2. Eyewitnesses are Tepiso Mbonambi, who's A4, and Wandile Mbonambi, who's A6, who allegedly saw deceased 2 raising his hands asking Ngenzeni, which means what did I do? And he was shot at by accused 13. Deceased number 3.
Before you proceed,
Yes.
okay, finish that one.
Okay. Thank you, Chair. Deceased number 3, who had been in the house, ran through the bedroom sliding door to the outside where he hid himself in the dustbin. The eyewitnesses saw the deceased jumping into the dustbin and alerted the accused. She witnessed the accused, shooting the deceased a number of times through the dustbin. Firearms were allegedly planted at these 3 scenes to create the threat impression. Ballistic expert Staley, whose statement is A57 in the docket, said that in respect of deceased number 2, gunshots. There were 2 gunshots. Deceased 2 head must have been on the floor or close to the floor when shot. Deceased 2 was falling or lying on his back when shot. Blood spatter on skirting showed that the firearm was not there at the time of firing, confirming the subsequent planting of the firearm. And then number 2, in respect of deceased number 3, 4 indirect gunshots entered the dustbin, irregular entry. Yes, Chair.
Yes, but when you look at the case of Isikaweni, CAS 3-4 2010, in respect of deceased Kwazi Ndlovu,
Yes, Chair.
what were the alleged offenses that had been committed by Kwazi Ndlovu? Do you know?
According to what I found from the prosecution memorandum was that they were looking for somebody who had escaped from prison. Tili, Dumisani, something like that. Okay, Tili and Dumisani Shandu. Apparently they had escaped from prison. So the police were looking for these two people.
And they erroneously, from the look of things, entered the house of Mr. Ndlovu and found Kwazi on the lounge.
Yes.
Is it safe to say Kwazi was mistaken as one of those people or escapees?
I don't think so, Chair. Because according to the facts, Kwazi Ndlovu was sleeping. So even if it was an issue of mistaken identity, why start by firing shots? So I don't know. If it was indeed a mistaken identity, why fire shots at somebody who's sleeping? And then the firearm is found there at the scene, and it shows the deceased did not fire any shots at them, and it shows the deceased was shot at while lying, sleeping on the sofa. It shows the deceased, whoever he is, was not posing any danger to the deceased, to the accused, for them to have returned fire. So mistaken identity or not, according to me, I don't think the killing was justified.
But the point that I'm making is they were looking for those two escapees,
Yes,
and they entered Mr. Ndlovu's house.
yes,
They shot at this young boy who was lying on the sofa.
yes.
Could they have mistaken Kwazi to have been one of those people? We don't know whether at that time they formed the view, but because they were looking for the escapees.
Yes,
So
sir.
why would then, if they are looking for the escapees, would they just shoot at the young boy?
Exactly. Why would they shoot at the young boy, Chair? That is what we are saying. Even if it was the people whom they're looking for, that Tili and Dumisani, they were not under those circumstances still allowed to shoot and kill at them because they were
Well,
not
yes,
under
that's
any
I
attack.
beg your pardon, that's a different matter.
Oh,
I'm just trying to understand why, if they were looking for somebody who would have committed an offense of escaping,
yes.
would they enter this specific house and then shoot this young boy? You remember in all the cases, almost
Yes.
all of them,
Yes.
the deceased people were alleged to have done something. For instance, in respect of a number of them, including Mr. Mkize, the allegation is that they shot at Superintendent
Konko.
Chonto
Yes.
in most of those instances.
Mm.
In respect of Kwazi, the allegation is that they were looking for the two escapees. And they went into this house, of Mr. Ndlovu's house, and found this young man lying. Could they have mistaken him to be one of those people?
Under the circumstances, I don't think so. Why couldn't they verify that? I don't know, really. They may say so,
Yes.
but yeah.
In your view, it could have just been a rampant killing or shooting.
Yes, based on the history of all these cases. And with regards to the killing of Superintendent Gongo, the witnesses are saying something else about who really killed him. We will hear from their statements.
Yes. In respect of case 15, the Durban North case, you're referring to at page MN 00036,
Yes, Chair.
those deceased people,
Yes, Chair.
what were the allegations against them? I don't see any such allegations made against these people.
There were not allegations like highlighted in each of the cases. Some were apprehended for, we don't know. For example, the witnesses, the eyewitnesses who were there, said they saw one of the deceased two raising his hands and asking, "Ngenzeni, what did I do?" Well, he may have said that anyway, but then there's nothing that is being said to mean these are the reasons why we were seeking these people or arresting them. So it's not in all cases where it's indicated that this person was sought for this reason. Although most of them is in respect of the killing of Superintendent Zetembe Gongo, but the witnesses are saying allegedly the Ketomena group knew exactly who killed Zetembe Gongo, but that was used as a reason to apprehend people like that, to say you killed Gongo, you killed Gongo. That is what the witnesses are saying.
Could these deceased persons, Bengu, Ngobozi, and Bonani,
Yes, Chair.
also have been part of those people who were killed during the rampant shooting?
From the facts, yes, it appears so, because there's no reason indicated to say they were sought in connection with this crime.
Yes, thank you. You may proceed.
Yes, thank you, Chair. Docket number 16, Esikaweni case 50 of 9/2011. The deceased is Qinisani Gwala, allegedly happened on the 4th of September 2011. Allegedly, accused 4, 8, 11, 25, and 26 went to the community hall looking for Pilani Ba Ndlovu. Despite mistaken identity and witnesses who confirmed that the deceased was not Ba, the accused handcuffed him and took him to the residence handcuffed. Accused 8, 25, and 26 alleged that they entered the room to search, uncuffed the deceased, and the latter went ahead of them and took a gun from the bed. Then accused 26 shot him fatally. The deceased brother Zakele, whose statement is 824, was present, but his head was covered with a washing basin by the accused. Ballistic expert Captain Mangena, 826, found one gunshot wound on top of the head, which meant the shooter was standing in front of the deceased, who was in a seated position when shot at. Another modus operandi is alleged here as well, but that will be seen also, will be heard in the statement of Tandega Nompumelelo Sokulu, who was the wife of Lindelani Buthelezi, who was also killed, where her head was covered with a blanket. So this one, the deceased brother's head was covered with a washing basin, and then immediately the deceased was shot at. Docket number 17, Kwamashu case 116 of 8/2008. The deceased is Mfana Futi Zwane, allegedly took place on 31 July 2008. Allegedly accused 4, 8, 10, 11, and 15 proceeded to the deceased home in Kwamashu and found the deceased sitting with his girlfriend in a vehicle and ordered them out of the car, separated deceased from his girlfriend, and moved the former, meaning the girlfriend, the deceased, meaning the deceased, they moved the deceased towards the boot of his car. Accused 4 then shot at the deceased, alleging that the deceased was trying to grab a firearm from the car boot. The deceased girlfriend refutes that the deceased was armed. Docket number 18, escort case 34/8/2008. The deceased is Sanele Majola, allegedly took place on the 6th of August 2008. It is alleged that accused 4, 5, 13, and 30 were escorting the deceased to their offices in Devon when they stopped at Midway Caltex garage in Escort to use a toilet. The deceased, who was cuffed, went into the toilet with accused 5 and 13, who alleged that the deceased asked to be uncuffed to use the toilet. Then he tried to disarm accused 13, then accused 5 shot and killed him. Firearm was placed to create the threat impression. An inquest was held and the magistrate found accused 5 criminally responsible for the deceased's death. The second suspect, who was escorted, Celimpilo Mgomezulu, made a confession implicating 9 others who were systemically killed, except Mgomezulu and Mavundla, who are serving life sentences in prison as a result of Mgomezulu's confession. That's another matter. Docket number 19, Kwamashu case 314 of 11/2008. The deceased is in Ntlanhla Masondo, allegedly took place on 12 November 2008. Allegedly, accused 5, 6, and 27 went to the deceased home in Ntuzuma. They entered the house, took the deceased into his bedroom and closed the bedroom door. The deceased's mother pleaded with the accused to enter the bedroom with her son, but her entry was refused. Further alleged that the accused stole the deceased's cell phone, wristwatch, and bank cards. Those constitute count number 108. The accused then fired shots at the deceased while in the bedroom, fatally wounding him, and placed the firearm next to the deceased to create a threat impression. Witnesses are the deceased's mother and the deceased's younger brother, who were in the house at the time. Docket number 20, Tongat, case 357 of 3/2009. The deceased is then Piri, allegedly took place on the 18th of March 2009. It is alleged that accused 5, 15, and 25 spotted the deceased motor vehicle and cornered it along Nuremberg Road in Tongat. The deceased had company in the car, who were ordered to lie down on the road as the deceased was still inside the vehicle. Accused 5 then allegedly shot and killed the deceased whilst the latter was inside the motor vehicle, then placed the firearm next to the body of the deceased to create the threat impression. Witnesses are Mavundla and Skumbuzo Zikali, who were later killed by the Ketomena unit. Captain Mangena's ballistic reconstruction findings are that the shooter was standing about 60 centimeters from the deceased when he shot him. Gunshot entry on the right ear entry below the chin and re-entering the left arm. Docket number 21, Kwaduguza case 115 of 3/2010. The deceased is in Ntlanhla Mhlongo, allegedly took place on the 6th of March 2010. Allegedly accused 13 and 15 proceeded to the deceased house in Stenga. The deceased opened the door for them, whereupon accused 13 fired shots at him, wounding him fatally. Accused placed the firearm next to the deceased to create a threat impression.
If you may pause there. These summaries, the summary in your memo dated 15 September 2020,
Yes, Chair.
which you directed or sent to Advocate Batoi in response to her letter,
Yes.
are almost the same as the summaries which you provided in your memo directed to all your colleagues dated October 2020.
Yes.
Save with regard to few of those summaries, most of them are detailed.
Yes, Chair.
Some of the September summaries are quite brief. Do you agree?
Yes, yes, Chair. I'm expanding more in the October 2021. Yes.
But they do set out sufficient details, and do correct me if I'm wrong,
Yes.
which informs Advocate Batoi of what this Katomena team is alleged to have done.
Yes, Chair. Actually, as far as the Ketomena and all the other cases are concerned, the details are the same. The October 2020 doesn't have more details in respect, for example, the Ketomena case than the 15 September one to Advocate Batohi. The only further details that are there in the 27 October 2020 report is with regards to other matters that I was just venting on. But with regards to the Ketomena one, it's exactly as it appears.
Yes, that's the point I'm making.
Yes.
Which then means, as at September 2020, Advocate Batoi was aware of the relevant contents of the dockets in respect of the Katomena cases.
Yes, she was, and I also attached annexures. It was not only my report, yes. Witness statements as well.
I asked you this question because Advocate Batoi testified before this inquiry that she never read the dockets.
Yes, Chair.
Nonetheless, if she was made aware of the contents of those dockets in summarized form, as far back as September 2020, she would have been in a position to form a view whether a prima facie case existed in respect of which the Katomena members could have been prosecuted.
Definitely, Chair, and she could have verified from the dockets. My report was clear as it is now, yes.
According to her, she only relied on the memorandum that was provided by first of all, the DCOC team, in which dockets were not summarized, if my recollection is correct. But already in September 2020, she was or ought to have been aware of the contents or summarized contents of those dockets.
Yes, Chair.
May I through you, Chair? Thank you, Advocate Miponi. Noko. I have two questions. The first one relates to docket 18, Escort Castre for /8 of 2008,
Yes.
where the deceased is Sanele Majola. In the next page, there is an allegation that the second suspect who was escorted, I think together with Sanele Majola, Limpilo Mngomezulu, made a confession implicating 9 others who were systematically killed except Mngomezulu and Mavundla, who are now serving a life sentence at Kokstad as a result of Mngomezulu's confession. But what I want you to expatiate on, if you can, is on where where the memorandum say the 9 others who were implicated were systematically killed. Do you have information on who killed him or what happened? Was it the Katomena?
I am not sure. The prosecutors will have more information on that, really. It seems so, but I cannot assume, really. I'm not sure who killed them.
Meaning that the death of these 9 people were never investigated.
Yes, because I think so, yes, because none of them are mentioned in anyway in the case. Like it was a separate thing. I'm not sure about that.
But as it is put here, we can assume that they did not die naturally, they were killed.
As it appears as they were systematically killed, it's alleged like that.
Okay, thank you. Then let's go to docket 20, Tongat,
Yes.
CAS 356
Yes.
/3 of 2009.
Yes.
You also say Skhumbuzo Zikali was later killed by the Katomena unit.
Yes, that's the
Just down there, I think 4 lines from the last paragraph, last line. Was this Skhumbuzo Zikali's murder investigated, and is it included in the charges against the Katomena units?
It doesn't seem so. It doesn't seem so. I don't know if it was investigated or what, but that's the allegation. as
So
it
it
is.
suffered the same fate as the 9 others.
It appears so in docket number 18, yes.
Would I be correct to assume that the people who are killed or the dockets that were opened do not cover all the people that would have been allegedly killed by the Katomena unit?
Yes, you will be correct, ma'am, because even when you look at the statement of Mr. Aristides Danikas, he's mentioning incidents that happened even prior to the dates that are covered by the indictment, which is May 2008 to September 2011. He mentions that is why the prosecution team was also using the similar fact evidence, which is allowed in terms of POCA Section 2, because there were incidents that happened prior that are not even covered in the indictment.
Thank you, ma'am.
Yeah, thank you.
Before you proceed to the analysis of the evidence, it is apparent from those summaries, if my reading is correct, Major General Boyson is not directly implicated. You refer to accused 2, 3, all those accused persons. There is no mention of accused number 1 in all those summaries.
In the summaries, yes, ma'am, he's not directly mentioned like that.
Yes.
But as we go to what racketeering is, what POCA legislation provides,
Well, that
and
was
why.
going to be my next question. I just wanted to make clear
Oh, yes.
as to how then Major General Boyson
Yes.
comes into the picture.
Oh, yes.
And you start dealing with that part when you deal with the analysis.
Yes. Oh, yes. The Chair, I think I've analyzed the statements better in my affidavit. Should I read them from my affidavit than from the report?
Yes, you are testifying. You can guide us what is best in the circumstances.
Yes, I will do that.
Take us to those paragraphs.
Okay.
If we have questions, we will ask you because we have
Yes.
also read those memoranda.
Oh, yes, Chair. Okay, thank you, Chair. It's on page 10 of my affidavit from paragraph 34. I'm saying there, some of these statements were of Mr. Okay, maybe can I start on paragraph 33 so that it gives context? paragraph 33 is, apart from the prosecution memorandum and other documents, I was also provided with statements of some of the witnesses as per a memorandum from Advocate K.R. Matenjwa, a deputy DPP who was a member of the prosecution team in the Katomena case. The memorandum signed by the lead prosecutor, Advocate Sello Maema, is attached here to and marked as Annexure MN4. In paragraph 34,
Where that will be your NMN 00062, which you will include as one of the exhibits. But for now, it is marked MN4.
no, Chair, it is not. It is not the memorandum. It is the memorandum, but it doesn't have the cover letter of Advocate Matenjwa as well.
If you look at the next page, if you look at the next page, NMN 00063.
Oh, memorandum. Yes. Yeah. Oh.
Hello, please don't rise. What are you telling the witness?
The mic was off.
Yes, the people who are standing there, you are an officer.
They said when they rise.
You are an officer.
Yes.
So just sit there, don't go closer to the witness, because the witness is under oath. You can't say anything to the witness. The people who are sitting over there, if we are making mistakes, do come down, or any one of the lawyers will assist, but don't rise. Yes, thank you. I was referring to 000.
Yes.
I was referring to 00063.
Yes. Yes, Chair.
And that is the memorandum of Advocate Maema. If you look at 00113, MN 00113.
Yes.
Even if it is not, it doesn't have the covering letter, it is clear to us that that's a prosecution memorandum and the signature of Advocate Maema.
Oh, yes, Chair.
Yes.
Yes, Chair. Okay. Okay. Then paragraph 34. Some of these witnesses.
May I just come
Oh.
in? I thought the chair was still busy.
Yes.
Yeah. We have been told by Advocate Batohi that prosecutors, when they assess the evidence before them in order to decide whether to prosecute or whether to continue with prosecution or whether to stop prosecution, they look at the quality of evidence before them. And she spoke about, or she indicated that sufficient evidence is required for one to decide to proceed to prosecution. And it is not conclusive evidence that is required. It is sufficient evidence. Do you know that, and do you agree with that?
I partly agree with that, because even if there's prima facie case does not necessarily mean sufficient, but they overlap. But the criteria I know of prima facie case, and the case must have reasonable prospects of a successful prosecution. So if you have that, then the matter must be enrolled and then be prosecuted.
Right. Looking at these Katomena cases, you say you are the prosecutor that signed a recommendation that was made to the NDPP that racketeering charges should be preferred against the particular police officers.
Yes.
It is you.
Yes.
Now, when you signed or made a recommendation that racketeering charges be preferred, what was your understanding of the evidence? Or rather, let me put it this way. Were you satisfied that there is sufficient evidence on which one can charge or not?
Yes, I was satisfied that there is prima facie case, there's sufficient evidence that was provided because I had sight of the witness statements, I had sight of the prosecutor's memorandum, they briefed me even verbally, I had sight of their slide presentations, they were explaining to me that this is the case. I read the statements that I had sent by Advocate Matenjwa, and this memorandum, I was satisfied. I still am.
Now, based on your recommendation and maybe other information presented, then Advocate Sean Abrams then signed the certificates in 2016.
Yes, February 2016.
February 2016.
Yes, he also satisfied himself the same way.
Right. And then you continued to occupy the position of the director KwaZulu-Natal
Yes.
until Advocate Batohi became the National Director of Public Prosecutions.
In 2019, yes, February, I think she came in, but I left to be the DPP for Northwest in, I left in May, acted there, but permanently appointed in July 2019.
Okay. According to your knowledge about these dockets, between the time when the certificates authorizing charging the police officers with racketeering and the time that Advocate Batohi took or got appointed to the position of the NDPP, do you know as to whether there are any further developments that took place that could have brought about the need to revise or to review the decision to issue the racketeering certificates?
My understanding was that Advocate Batohi revised and ended up withdrawing this case based on the concerns in the media that was there about the case, General Boysen complaining that he's been targeted and all of that. I'm not aware of anything, or perhaps they send her representations. I'm not aware of that. But that's my understanding that based on what is being said out there about this case and others. Yeah.
Now, at the time when you were requested to furnish more information to the NDPP, that request that you responded to on the 15th day of September.
Yes.
And the focus of my question is just the Katomena cases. The rest don't be concerned about them.
Yes.
Now, at that time when you were invited to respond to the inquiry by the NDPP, do you know as to whether by then the decision to issue the racketeering certificates by Advocate Abrams had been reviewed or not? Do you know whether it had been reviewed or not?
She had already done that. She did that in 2019. So the case was already withdrawn in 2019.
And she sought for further information.
And then
in
only
2020.
after then she sought explanations, which I supplied as per the 15 September 2020 report, explaining what the case is all about.
And do you know as to whether there is anything that she did in response to receipt of the information that you brought to her attention about these cases?
Yes, she wanted an inquiry to be held for me. That was her response.
Against you?
Yes.
Okay. Thank you, Chair.
Yes, I think when we interrupted you, you were then, in addition to the summaries in relation to the dockets, you referred to the further statement that bolsters the evidence provided for in the dockets.
Yes, Chair.
And you start in your affidavit with the summary of the statement of Mr. Danikas.
Yes, yes, Chair.
I think it is at page 11 of your affidavit.
Yes, Chair. Oh, I can read it.
You can read that part of the summary into the record.
Yes, Chair. Thank you.
We have already read the statement of Mr. Danikas, but because you are testifying, you can put it the way you want to put it.
Yes, Chair. Thank you. Mr. Aristides Danikas' statement was one of those that I had sight of, but the witnesses mentioned here are not all the witnesses in the case dockets. So he said that he was a member of the Ketomena SVC unit and worked with this unit. In his statement, among others, Mr. Danikas mentioned that a standardized method was always used. That is, they shot to kill, had, tortured, altered the scenes of crime. Major General Boysen was called by his members to the crime scene to confirm and manipulate the scene. He further stated that, I'm quoting him, I was present in some of the cases I mentioned earlier when I was accompanying Major General Boysen to the crime scene, and I think there's some grammar error here, but I didn't want to change it because I was quoting, and ordered Major General Boysen in front of me to his members to collect all the spent police rifle cartridge casings and hand them over to the responsible officer investigating the case. This usually happened after Major General Boysen had arrived at the scene of crime. Mr. Danikas further mentioned that in one of the incidents that he went to in Malvern with Major General Boysen and Adele Sonekas, who was a police officer and secretary at the Provincial Organized Crime Unit, they found several members of the Ketomena unit at the scene, and 2 African men were in the garage of a house. One of them was shot and killed in the car, and the other was injured and still alive, but was in great pain and bleeding heavily. Mr. Danikas mentioned that Major General Boysen said to him that they would call the ambulance and the Independent Complaints Directorate only if the second suspect died. So everyone waited around the second suspect to succumb to his wounds. Then the suspect died after a few minutes. He mentioned that he had requested Major General Boysen 3 times before the suspect died to call the ambulance. His statement is attached here to and marked as Annexure MN 5. The second witness statement that I also read is of Mr. Begingosi Mtinyane Dlondlo. He was a taxi owner and chairman. He was a taxi owner and chairman of the disciplinary department at Stenger Taxi Association, STA. He stated that he knew every secret and would always have secret meetings with other members of the association, even sensitive meetings to discuss the person who must be killed. He mentioned Inkosi Zondi, who was a police officer working for the Ketomena unit and to whom information about the Maphumulo Taxi Association, MTA, having killed Mr. Qongqo was taken. Then Inkosi Zondi arranged with his unit Ketomena and also poisoned his commander. Then members of MTA were assassinated, the first being Lindelani Buthelezi, killed by the Ketomena unit. He stated that he was present when a lot of money was arranged to pay the Ketomena for the job well done. People who became next to be killed by Ketomena unit were Kopolo Tantuli and Natim Tembu, killed in Mandeni in a house. Him and 4 others, being Mr. Kanyile Ngobo, Sanele and Bongizwe, took out a lot of cash and tasked Sanele and Bongizwe to go pay the Ketomena for the job well done, which payment he had took place at the Tonga Toll Plaza. He mentioned that the person who was killed next by the police was Mdum Kize, and money was paid to those police officers. He said that the 4th incident was the killing of Mr. Ndimande by the Ketomena unit in the Hawik area. Thereafter, he had a secret meeting with the other 4 members to arrange payment to the Ketomena unit, and an amount of 750,000 rand was raised. This money was given to Sanele and Bongizwe to go pay Ketomena, and the former, being Sanele, would tell them that the money was going to be given to the boss, referring to Mr. Boysens. He further stated that the last person to be killed from the MTA by the Ketomena was Mr. Bongani Mkhize, who was the chairman of the MTA, and they raised about 1 million rand and gave Sanele and Bongizwe to pay Ketomena. He said that Sanele told them that that money would be paid to Boysen, big boss of Ketomena unit. His statement is attached here too and marked as Annexure MN6. The 3rd witness statement was of Mr. Bongani Mandla Mkhize. He stated that he was employed by a company that was providing security service to the members of STA. He was always assigned to be a bodyguard of Mr. Bongizo Mhlongo, a PRO at STA, and whom he was close to. During conflicts and after the killing of Qongqo, if the owners of STA hated somebody, they will supply their names to Ketomena unit as being responsible for Qongqo's death.
Paragraph 35.8 refers to annexure NN6. Whose statement is that?
Paragraph 35
35.8?
is a statement of the previous witness, which is Mr. Begingo Simtiani Dlondlo.
Yes, thank you.
Thank you, Chair.
Before you proceed, can we also ask the leader, Ms. Hue, to make sure that the annexures that are referred to are marked and as evidence? You have already referred to a number of annexures up to annexure MN6.
Yes.
I hope you are keeping record. Thank you, Chair.
Thank you. You may proceed.
Yes, no, thank you, Chair. Okay, maybe let me finish, and then I just wanted to elaborate on this statement after I read it.
Which part?
Up to the end of 25, paragraph 25. Then I will elaborate a little bit on it.
Paragraph 25 of your affidavit.
At the end of it, yes.
25 or
I'm about to read 25.7, I'm sorry, 25.7 and 25.8. And I'm saying when I'm done with that, I'll elaborate a little bit.
the numbering of the paragraphs is confusing.
Oh, on page 40.
You see, you dealt with 35.7, 35.8, now 25.6.
My apologies for that. It was when I was preparing, I accidentally didn't see this part.
You made some errors there.
Yes, I did.
You made some errors, Council.
Yes.
You can correct the numbering as you go along.
Yes,
The main paragraph is paragraph 35,
oh, yes.
and I see at page 12, you have, just start maybe at page 11. 35, 35.1, 2, 3, 4, 5, 6, 7, 8. And then at page 13, as regards Mr. Bongani Mandla Mkhize, you say 25.6. I think the correction should start there.
Yes, I apologize, Chair. I also did not pick it up. It should be
Paragraph- it should be
35.9.
nine.
Yes.
You can make it 9, and then you keep on correcting as you go
Yeah.
along.
Yes, Chair. Okay, Chair. I'm then about to read on page 14, which will be 35.10.
35.10, correct?
Yes.
Yes.
Okay, yes, it reads thus. Mr. Mkhize further stated that some of the victims on the list was Kopolota and Mtembu. Bongizo Mhlongo had received photos on his cell phone depicting that Kopolota and Mtembu had been killed, and Bongizo said that he was sent those photos by Mostert from the Ketomena unit. He said that then Bongizo reported that he was going to the Ketomena members who sent him the photos, and as his bodyguard, him and Bongizo drove to Tonga Toll Plaza, where they met Mr. Mostert and another white man in a silver BMW sedan. There, Bongizo took out a transparent plastic bag with a lot of money in banknotes from his car's boot and got into Mr. Mostert's car. Later, he came out of Mr. Mostert's car without that plastic of money. His statement is attached here too and marked as Annexure MN7.
That paragraph will be 35.11.
Yes, Chair. Yes.
Annexure MN7 is MN 00135. Which I suppose will be properly marked MN7. It is not marked Advocate Kowe. And you will later then provide a list of those exhibits.
We will do so, Chair.
Proceed, ma'am.
Yes, thank you, Chair. My little bit of elaboration that I wanted to mention was that according to Mr. Bongani Mandla Mkhize, they know who killed Mr. Tonto. And it's definitely not the people who were being sought allegedly for killing Superintendent Tonto. Because hitmen were allegedly arranged to kill Mr. Tonto, and everybody else was blamed for that, whom they wanted killed, and they would say they killed. So the reason would be people are taken because they killed Tonto. They killed Tonto. Although the real people who killed him are known. So that's what he's highlighting. That's what I gathered from his statement.
Yes, thank you.
Yes, thank you,
Before
Chair.
you move on, at paragraph 35.6, 35.7, and 35.8, 35.9, you refer to money being paid, and the allegation is that the money will be given to the big boss. Is it where did the money come from? Was it from the taxi association?
Yes, according to Mr. Bongani Mkhize, him and others, actually it's Mr. Bekingozi Mtiani Dlondlo. He says him and Mr. Kanyile, Mr. Ngobo Sanele and Bongizwe took out a lot of cash. They gathered money and they went to pay Ketomena unit for having killed Kopolota Ntuli and not Tim Tembu. That's what he's saying in his statement.
Thank you.
Please just give me a second. Now, in relation to the gathered money that you have just mentioned, mention is also made of monetary awards to the officers who allegedly killed people.
Yes, Chair.
If you look at your September 2020 memorandum to Advocate Batoi, it doesn't have a page numbering, or it's page 38 of 56,
Yes, Chair.
the September memorandum.
Yes, Chair.
At the bottom there, paragraph 5, monetary awards.
Yes, Chair.
Can you read that paragraph, please?
Okay, thank you, Chair. The South African Police Service accepted that the SVC Ketomena section was honest in combating the taxi violence in the province and rewarded all officers who were involved in the taxi violence task team, including Boysen. The reward was in the form of cash and certificates. The motivation for the reward states the role of Boysen in the operation, hence he was rewarded. Boysen further motivated for payment of sources, informers, who provided information that led to the killing of the KwaMaphumulo Taxi Association members. Boysen, as the provincial commander of organized crime, had intimate knowledge of the operations of the Ketomena SVC section when it was eliminating the KwaMaphumulo Taxi Association members instead of arresting them for any alleged offenses. As a manager, he did nothing to stop this killing spree because it was fulfilling their arrangement with the Stenga Taxi Association as stated in Matonzi's statement.
Advocate Kowe and your team, perhaps you can assist here. In our records, the document that we read last year, the records are voluminous, but there is an annexure that shows that members of the Katomena unit were paid a certain amount of money. If my recollection is correct, it was 10,000 rand per head. Would you remember where in the records would we find that? You can look into that so that I can ask the witness about it. If not, we can park it and deal with it later, after my researcher has picked the page.
Can I, as a follow-up to your question, so when one looks at what you have in your memorandum of September,
Yes, sir.
which talks about monetary awards, this would obviously come from SAPS. What you're referring to in your September memorandum,
Yes, those are performance
performance sort
Yes.
of awards.
Yes.
Meaning that they got their performance awards and the reward from the taxi association for having eliminated these people.
Yes, according to the witnesses, they were paid the monies, and also on the other hand, the employer SAPS reward them for good performance.
Thank you.
Yes.
Good performance in this case, meaning for the killing of the deceased.
Well, that's what it is, but obviously it's not mentioned like that, Chair. It's mentioned as eliminating or combating taxi violence in the area. Whereas, according to the witnesses who were members of the Stenger Taxi Association, they allege in their statements that as members of the Stenger Taxi Association, they colluded or they agreed with the Ketomena unit to deal with the Kwamaphumulo Taxi Association. Hence, all the people that were killed were members of the Kwamaphumulo Taxi Association. However, to the employer, it appears to have been portrayed as having quelled taxi violence in the province. Hence, the employer rewarded them for that.
Thank you. Just give me a second.
Chair,
Yes,
I'm told it's on page SB 1A.
SB.
1A. SB 1A 082.
Some of our bundles are stored elsewhere because there's just a lot of documents and we don't have space. We will look into that. You can proceed. I will just pass
Yes,
the
Chair.
question because we also we have another one. I beg your pardon. Thank you. Yes, our bundles are kept elsewhere because we don't have a space here. They will bring those documents. We have the Boyson's bundle 1 of 11. In that bundle, there are pages B00014 to B00015, 16 and 16. Those 3 pages show list of officers, their surnames, their initials, and the awards, and the total amounts of money. We will compare that with the one that you've just referred to us. But in most instances, we will tick the names. If you look at the one that appears at B00016, most of those people were given 10,000 rand awards. And they are officers. If you look at B00015, you will see all of them are officers. Some were given 10,000 rand awards. In fact, most of them, and others, few of them, 15,000 rand. On the first page of that award list, B00014, the first one there is Major General Boyson, then Brigadier, JW, 10,000 rand. Warrant Officer Padayachi, nothing. And the list follows. But most of them were given higher amounts. I think the highest paid there is 95,000 to Warrant Officer Mostert. What I want to ascertain regarding these monetary awards that you are referring to is whether the money that was collected, the 750,000 and the million rand, is the money that was used to pay these awards, which I've referred to in these 3 pages. If you know, if you don't, we will understand.
Yes, Chair. No, my understanding from the reading of the witness statements was that the 750,000 for the murder of Kopolotan Tulu and somebody else, and the 1 million rand for the murder of Mr. Bongani Elfas Mukize, who was the chairman of the Stenga Taxi Association, those are separate. That is what the Stenga Taxi Association gathered to pay the Ketomena, as per the witnesses' statements, to say you have done well by killing these people because their deaths were planned. And according to the witnesses, they were working from the Stenga Taxi Association. They were working together with the Ketomena police officers. And they had asked them to kill these people. After killing them, they paid them to say thank you. That is why one of the witnesses here, I don't know whether it's Bongizo Mkize, he says he was even sent photos. He was told that Bongizo was sent photos on his cell phone showing that some people, Kopolota and somebody else, were killed. And he was sent those photos by Mostert. Mostert is from where? From the Katomena. He's the one who allegedly received 95,000 rand from the police side. So they are separate here. The awards, monetary awards, is by the employer.
Yes. That's what I want to understand.
Yes, it's separate.
Yes.
Chair. I'm sorry for going the long way.
Yes.
I was trying to elaborate and make it clear.
The monetary awards you are referring to in your documents,
Yes, Chair.
was that awards in respect of the killing of those people, the 10,000 rand each per head, or separate from the employer awards?
The 10,000 and other amounts from the employer, SAPS, was the awards to the employees, the Ketomena unit members, for having quelled, combated taxi violence in the province, because that's how they presented to the employer, to say they have dealt with taxi violence in the province. Whereas the witnesses are saying something else, that they actually were killing these people from a rival taxi association, being the Kwama Pumulo.
Yes. We have a file here containing the statement and attachments to the statement,
Yes.
the statement of Advocate Batoi.
Okay, sure.
Now, one of the annexes in the statement, to the statement, is SB 1A082. It's headed Monetary and Non-Monetary Awards.
Yes, Chair.
Yes. Now, in this annexure SB1 A082, annexed to Advocate Batoi's affidavit, a list of candidates who qualified for awards included the first one, Major General Boissons. I know you don't have that, but I have a document.
Yes,
Before I ask you a question, I just want to let you know the basis why I'm going to ask you this question.
Yes, Chair.
In the affidavit of Advocate Batoi, she refers to the affidavit of Advocate Jiba. The relevant part of that affidavit of Advocate Jiba make mentions of the monetary awards.
Yes.
Paragraph 16.7 of the extract from the affidavit of Advocate Jiba reads as follows. The information further revealed that the unlawful activities of the killing suspects and or civilians were in certain instances motivated by the applicants and members of his unit. The applicant here referring to Major General Boissons. And members of his unit's desire to enrich themselves by means of state monetary awards and or certificates for excellent performance. In this regard, I annexed a copy of an example of such a monetary award, claim documented as NJ1, and in which inter alia, the applicant is recommended for such an award resulting from the deaths of suspects. The point made there refers to that SB1A 082, where Major General Boissons and others are listed as candidates who received the awards.
Yes.
Now, these awards, in relation to this paragraph, are not the employer's awards that we read in those 3 pages earlier in the Boissons document. This, if my understanding is correct, are the awards for the killing of those people. Is my understanding correct? Or if you know, if you don't know?
Yeah, I don't know, Chair.
I ask this question because there seem to have been 2 separate awards. One by the employer for having subdued the criminality
Yes.
in KZN in those areas. The second part of the awards, as I understand the statement
Yes.
by Advocate Jiba, referred to by Advocate Batoi, which they call trophies, in respect of the monetary payment for killing the suspects or the civilians.
Okay, Chair. What I understand is the payments from the Stenger Taxi Association rewarding or paying the Ketomena unit as per the witnesses for having killed certain people whose deaths were planned and the names given to Ketomena to kill under the pretext that they had killed Superintendent Zetembe Tongo. That's the what, the 750,000, the 1 million rand. I don't know if there's any more, but from the statements, it's only those two. And the second monetary rewards or payments was from the employer under the pretext that they have quelled taxi violence in the province of KwaZulu-Natal. Then they gave them monetary and non-monetary awards, the 10,000, the whatever, different amounts, and the certificates for excellent performance. That's how I understand. And I have seen the copies of those monetary awards and the certificates. I've seen them. Those were provided to me as well. I just don't have them now anymore, as I don't have access to those documents.
And those, the monetary awards for killing the suspect. Thank you. I beg your pardon. The monetary awards for killing the suspects would be in relation to the few listed people, not the long list of the employer, the 3-page document, because here, the monetary and non-monetary awards, which would have been included certificate, were in respect of about 18 members of the Katomena, as listed in this annexure. But the amounts do not appear in the list. So your understanding is that the million rand and the 750,000 collected from the taxi association people in Stanger was to reward those people who killed the people that they had identified,
Yes, Chair.
according to you,
Yes, Chair.
and separate and quite distinct from the employer monetary awards.
Yes, those are separate, yes.
Yes, thank you.
Thank you, Chair.
So that took a little bit long. We have 5 minutes to go and have tea, but you can proceed for 5 minutes.
Yes,
Just
sure.
wanted to get clarity because we had these 2 different statements in relation to awarding people.
Yes, Chair. Okay. Okay, I will be, it's number 25.9, but the correct one is paragraph 35.12. It's the statement of Mr. Simpiwe Cyprian Matonzi. It's on page 14 still. He stated that he was a bodyguard of the vice chairman of the STA. Vice chairman of the Stanger Taxi Association was Mr. Bongizwe Elphas Mkhize, whose death was allegedly planned. As per this witness, as per Mr. Mutiani, Mr. Bongani Elphas Mkhize's death was planned by the Stanger Taxi Association, and after he was killed, he alleges that they paid the Ketomena 1 million rand for his death. So here, Mr. Matonzi was the bodyguard of the vice chairman. Oh no, the vice chairman is a separate one. This is Mr. I'm sorry, I'm confusing the record now. Mr. Bongani Elphas Mkhize was the chairman of the Kwama Phumulo Taxi Association. It's a different one here. I apologize for that. So Mr. Simpiwe Cyprian Matonzi stated that he was a bodyguard of the vice chairman of the Stanger Taxi Association and was trusted by all executive members of STA, and they would even plan to hire a hitman to kill someone in his presence. Some members of STA, Sanele and Bongizwe, were close to a unit called Ketomena. He said that he had accompanied Sanele Zondi and Bongizwe Mhlongo to meet Mr. Mostert and now General Boysen, near Gateway Shopping Mall by the Shell garage behind the private hospital. The purpose of which he had was to have Mostert and Boysen cover up if police wanted to arrest members of STA. He further said that after a week, he
Before
again.
you proceed,
Okay,
the sentence,
yes,
the last sentence of 35.12 that you've just read,
yes, Chair.
he said that he accompanied Sanele Zondi and Bongiziwe Mhlongo to meet Mr. Mostert and now General Boysen. And now General Boysen. You mean now? You mean now General?
No, my understanding was that the rank had changed.
Yes, that's what I'm asking.
Yes,
He was a brigadier.
yes, yes,
and
then.
he was now, or
Now.
is now general.
Yes, Chair. He further said that after a week, he again accompanied Sanele and Bongizwe to Gateway Shopping Mall at McDonald Parking, where they met now General Boysen and Mostert traveling in a grey BMW 5 Series. There, Sanele and Bongizwe went into the BMW with an envelope that contained a lot of money. They stayed in the BMW for about 45 minutes to an hour. He mentioned that he had Sanele and Bongizwe saying that Kongo was trouble and they will talk to senior officers referring to Boysen and Mostert to sort Kongo. Kongo was gunned down and thereafter Ketomena started to kill all hitmen who were behind the killing of Kongo. He stated that he...
Those paragraphs will be renumbered according.
Oh, yes. The one that I've just read, 25.10, is supposed to be 35.13. And the next one I'm reading must be 35.14.
Yes, ma'am.
Yes, thank you, Chair. He stated that he had Sanele saying that he had a list of people that need to be killed by Ketomena, and that Bongani Mkhize, the chairman of the KwaMaphumulo Taxi Association, was on that list. Bongani Mkhize was killed by Ketomena, then money was collected and paid to Ketomena. His statement is attached here to and marked as Annexure MN8. This Mr. Bongani Mkhize is the one who had obtained a High Court interdict in desperation to say, because people are being killed, and he heard that he is on that list, which Mr. Matonzis mentioned that indeed Mr. Bongani Elfas Mkhize was on that list of the people to be killed. He was pleading with the Ketomena through his lawyers. They obtained an interdict to say he must not be killed. If the police, the Ketomena, needs him for anything, questioning, even arrest, they must just go through the lawyers and then he'll be handed over to the police. But instead, he was waylaid and killed around Umgeni Road. And General Boysen had deposed of an affidavit wherein he stated that Mr. Bongani Mkhize must not worry about anything, and if they seek him for any reason, they will contact his lawyers, meaning that they will comply with what the High Court interdict mentioned, that whenever they need him, they must go through his lawyers. His lawyer statement is there as well, Mr. Nkosinathi Hopewell Shozi of Hlapani Attorneys. He's the one who launched the interdict. So he was not contacted, but instead the Ketomena just killed Mr. Mkhize, despite the interdict saying if they need him for whatever reason, they must please go through the lawyers as per the interdict.
The statement of the attorney, Mr. Shozi, is it attached to your affidavit or referred to in your memorandum of September 2020?
I think I am referring to it, yes. It's one of the statements that I also read, part of the other statements, but I'm referring to it in page 40 of my 15 September document as paragraph 8.
Is it one of the annexures here, Council.
Sorry, Chair, it is one of the annexes. Just trying to find the index.
I think it's
MN 13.
Yeah. Okay, thank you,
You may
Chair.
proceed.
Thank you, Chair. Paragraph,
I beg your pardon. Where are you now?
35.15, that is the next witness.
Yes. I know that is tea time, but let's finish this sub-paragraphs before we go to paragraph 36 at page 16.
Yes, Chair.
You are now dealing with Thandeka Sekulu.
Yes, Chair.
Yes.
Okay, the right one is 35.15. Thandeka Nompumelelo Sekulu's statement, she mentioned that she was present at their home when her husband is one of the people who was killed, his Lindelani Buteles. So her and her husband were at home, and her husband was subdued, shot, and killed in the adjoining room to the one she was in. She states in her affidavit that, I quote her, there were approximately 20 policemen. When I emerged from the house, there were approximately 6 or 8 inside the house when they arrested my husband. When he disappeared from my sight, he was already subdued and under their effective control. There would thus have been no opportunity in respectful submission for him to have obtained or secured a weapon to threaten the lives of the policemen. She further stated that, I quote her as well, I believe that the police had executed my husband on that night as they had behaved in very high-handed fashion. I too had been assaulted for no reason whatsoever and had a blanket thrown over my head. I verily believe that this was done by the police in order to make double sure that I did not witness the unlawful actions. There is no other explanation why a blanket would be put over my head immediately prior to the sound of a gunshot and it being removed immediately thereafter. Her affidavit is attached here too and marked as Annexure MN9. This is the one I had referred to earlier when a brother to the deceased in one of the cases that I mentioned, the case dockets, a washing basin was put over his head and then immediately his brother was shot so that he cannot see. So the same style was allegedly used here as per Thandeka Sekulu's statement, that she was covered with a blanket over her head and then immediately her husband was shot.
This affidavit.
Yes, Chair.
This affidavit of Ms. Sekulu
Yes, Chair.
is actually a replying affidavit in the High Court proceedings in respect of the matter of Mr. Mkhize.
Yes, it
I
is.
think it is that application where he sought an interdict.
Yes, it is, Chair. But my understanding is that there's another statement, the initial statement that she made to the police after the killing of her husband.
Please wait a
And-
minute.
Oh.
Let me finish because
sorry,
you're confusing me now.
I'm sorry, Chair.
The replying affidavit of Ms. Thandeka Sekulu, Annexure 9, MN9,
Yes.
is at page MN 00171.
Yes, Chair.
What is her standing there? She's deposing to this affidavit in her capacity as who?
My understanding was to substantiate or to corroborate the fact that people were being harassed and killed by the Ketomena unit, and that her husband, Lindelani Buthelezi, had been killed because Mr. Bongani Mkhize launched an affidavit application after Mr. Lindelani Buthelezi and others have been killed. And he had heard that he's also on the list. So she was a witness in the matter of Lindelani Buthelezi, and she was making this affidavit to support the interdict by Mr. Mkhize, as I understood.
Because in paragraph 3, she refers to her husband.
Yes, yes, Chair.
And I was wondering as to whether she is the wife to Mr. Mkhize or to Mr. Buthelezi. It's not very clear to me.
Yes. It is not clear here, but I got it from the prosecution team that the husband she's referring to is as per her initial statement in the docket with regards to the murder of her husband, who is Mr. Lindelani Buthelezi.
Proceed with the last paragraph, subparagraph.
That was the last
That was
paragraph.
the
Chair.
last
Yes.
paragraph. Subparagraph. Yes, the next paragraph is erroneously marked as 26. It should be 36.
Yes.
And the numbering will be corrected accordingly up to the end.
Yes, Chair.
We will take a T adjournment. We will adjourn for tea until quarter to 12. We adjourn now. Good afternoon, everyone.
Afternoon, Chair.
Advocate Noko, I did not warn you, but you know what is the right thing. You are still under oath.
Yes, Chair.
Jen, you were to begin with paragraph 36 at page 16 of your affidavit.
Yes, Chair. May I please, before I go to this, because these are not extracts from statements or anymore, answer your question, the previous question about the direct involvement or so, or something along those lines of General Poison, Major General Poison, in the dockets. Yes, okay. Chair, when this...
Sorry, Chair. Can I have an audience? I just omitted to mention that Mr. Harley asked to be excused for a moment. He's busy attending to certain evidence that the witness is currently testifying about. He's still in the building, but he's just stepped out to attend to some aspects of the evidence.
Relating to what she has testified about
Correct, Chair.
in particular?
He didn't convey what it is.
Advocate, do you have an idea? Is he preparing those exhibits?
No, Madam Chair.
I'm not putting you on a spot.
No, Madam Chair, he isn't. He's just trying to put up some notes that can assist.
Yes. Yes, thank you.
Okay, thank you, Chair. What I need to state is that when I was brought into the case and provided with a prosecution memorandum, the statements of some of the witnesses, the indictment, the slide presentation, all the documents that the prosecution team provided to me, and their verbal presentations and our verbal engagements as well. And upon me reading all those documents and the statements, I gathered that there's an enterprise in this case that existed because it met all the requirements in terms of there being that pattern of committing illegal activities, that is the killing of the 28 people and the commission of other offenses, the assault, the pointing of firearms and malicious property and all of those things. And it was continuing because it continued for many years, even prior to the May 2008 that is mentioned in the indictment. It started even prior to that, as per Mr. Danikas, who was working in the very same unit. And further that there was a system of authority and management. And Major General Boysen was one of those that were managing the enterprise, as it was labeled. So there was that pattern of racketeering. Hence, they were charged in terms of POCA legislation, the Prevention of Organized Crime Act 121 of 1988, because there was that pattern of racketeering. And POCA legislation, as we all know, Chair, is that it was promulgated to deal with matters like this, where some people are not directly implicated, but it's induced from the circumstances. Hence, the POCA legislation permits circumstantial evidence to be used. It also permits similar fact evidence. In this case, with regards to similar fact evidence, we can go to the statement of Mr. Aristides Danikas. For example, in one of the incidents, he says, during 2007, which happened, it's outside the indictment. It was prior to the indictment. He says, for example, in one of the incidents, he mentions in his statement that during 2007, when he was having lunch with Major General Boysen in one of the cafes, cafe or restaurant in Musgrave. Mr. Boysen told him and showed him a picture of a person on his cell phone whom he said his name was Jabulani, and allegedly he had escaped or whatever and had done some wrong things, I don't know. And Mr. Danica said, Major General Boysen told him that if he sees that Jabulani, he's going to plant a bullet in his head. Then Mr. Danikas goes on to say, later he was invited by Major General Boysen to go look for Jabulani, and they went to Umlazi. I forgot the name of the section, but they proceeded to Umlazi with Major General Boysen along with the other members of the Ketomena. And Mr. Danica says when they got to Umlazi, Major General Boysen remained in the car that had parked where all other members had parked their cars. He stayed in the car while everyone else, including Danikas, they alighted from their cars, and he said they went into a house which was just there by where they had parked. And then one person who was called Jabulani, whom they were looking for, was dragged out. It was raining. He was outside in the rain wearing only a dark underwear. And he was assaulted and kicked, handcuffed, lying on the floor, and he was shot and killed there. So Major General Boysen was not there with them, but he was in the car, according to Mr. Danikas. And according to Mr. Danikas, Major General Boysen had told him that a bullet will be planted in this Jabulani's head. And indeed it was, because they went to that scene, but he remained in the car. So when you check in all these dockets, he is not there physically, but he knows about these incidents. And that's what the POCA legislation provides for. It's hard to really pin someone to say you took this bottle and put it here. But circumstantially, it can be induced that this person knows. So he apparently, he knew about all these incidents because Mr. Danikas further says he would go to this, he gets called after the incident is like the murders are committed. And according to Mr. Danikas, then the scenes will be altered. Cartridges removed or swapped or whatever, but the murder scenes will be messed up before the forensics and the IP and all of that are called. That's what Mr. Danica said. So that is what the similar fact evidence, which happened, just one incident, he mentions more, just one incident that happened in 2007. So that is a similar fact evidence that is allowed in terms of POCA legislation to be used in racketeering offenses. Then we put the similar fact evidence. We go to hearsay evidence. There is hearsay evidence here as well. In terms of, for example, some of the witnesses who have deposed of statements and affidavits have passed away. But the Criminal Law Amendment Act 45 of 1988, it allows the prosecution to use statements of deceased people, as long as they meet the criteria, of course, of being reliable and being in the interest of justice. So when I looked at these statements, according to me, not being a presiding officer, of course, but in my prosecutorial discretion, they were reliable, and it was definitely in the interest of justice because so many people have been massacred under similar circumstances. A blind eye can be turned onto this. People are all killed under similar circumstances. What does that mean? They don't even arrest any one of them. All of them are killed. I do not deny the fact that police are being killed, threatened by people who are being sought for criminal offenses. But it can never be the position that in every case, 28 reported and clearly there is more. All of them are killed and all of them were allegedly trying to endanger the police's lives, even where it doesn't make sense, according to ballistic reports, experts reports. So all those. So that is circumstantial evidence. It can be inferred from that one. And also, when we look at the murder of Mr. Bongani Elfas Mkhize, who was a chairperson of the KwaMaphumulo Taxi Association, whose murder was planned according to Mr. Mtiani Dlondlo. it was planned within the Stenga Taxi Association, and his name with others were given to the Ketomena to kill them. And indeed, he was killed by Ketomena. So as far as Mr. Bongani Mkhize is concerned, he had, out of desperation, asked for help not to be killed, although he was killed after the interdict, but he was killed. But his mother was killed, was planned, according to the witness, and the Ketomena was paid for that. And according to the witness, Mr. Boysen, General Boysen was one of those who were paid at somewhere in Gateway or something like that for his mother. That's what the witness is saying. So you can see from that after making an affidavit to say, no, Mr. Mkhize won't be killed, he won't be harmed or anything like that, the interdict will be complied with, he will be requested through his lawyer, he was killed afterwards. So General Boysen was aware of that as well. But also, I'm not aware of anything that is mentioned to have been done against those members of Ketomena unit who shot at Mr. Bongani Mkhize, because it was not him directly who shot at him, but he knows the circumstances. So it's inferred circumstantially from that. Yeah, so that is what I wanted to illustrate, to say I was convinced on that basis that there's a pattern of racketeering in this case, and these people are linked like that. So Major General Boysen is charged in terms of Section 21F of the POCA, which is managing the operations, because he was the head of the serious violent crime in Ketomena, and he was managing its activities. And those activities, unfortunately, included the murder of these people, because he was aware that these people are being killed and all of that, but nothing was done, one after the other, 28 in number. It can't be how the police operate. Yeah, that's what I wanted to elaborate on, sir. Chair.
You make a point in your memorandum to Advocate Batoyi in closing.
Yes.
At page 39 of 56, under that rubric, monetary awards, the last paragraph, the next page. You can read it again. I know you read it into the record, but it tallies with what you're saying. You can read that paragraph.
Yes, Chair. I said to Advocate Batoyi that this...
No, that's...
yes, I'm reading.
Are you reading there?
Yes.
The sentence, the paragraph that starts with Boysens as the provincial commander. You see paragraph 5, headed, monetary awards. The next page is on page 39 of 56 at the bottom of page numbering.
Yes, I can see that.
That last paragraph before paragraph 6, statements of Andrew Cousin.
Yes.
That last paragraph speaks to what you have just said. You can read it into the record again?
Yes, Chair. It reads thus: Boysen, as the provincial commander of organized crime, had intimate knowledge of the operations of the Ketomena SVC section when it was eliminating the KwaMaphumulo Taxi Association members instead of arresting them for any alleged offenses. As a manager, he did nothing to stop this killing spree because it was fulfilling the arrangement with Stenga Taxi Association as stated in Matonzi's statement.
Among others, according to you, what you are reading then links General Boysen's with those activities by virtue of the POCA provision, section 2, 1F.
Yes,
Chair.
Yes, managing the operations.
You have earlier referred us to the High Court application and then to the statement of the attorney, Attorney Solji. You found it in the record. Do you want to add anything? Or you just referring to them as forming part of the record? You also make a point at paragraph 6 in relation to the one who was flying General Boysons to the scenes. You can read paragraph 6 of 39 of 56.
Yes, Chair. It's statement of Andrew Carson Cochrane, dated 16 May 2013. He will state that he was a crew member to the pilot who flew Boysen to the scene where Magojela, the Kwamo Pumulo taxi boss, was killed. It is the prosecution team's view that this helicopter was on standby to carry Boysen pending the notification by his foot soldiers that the execution of Magojela has been fulfilled.
Sorry, you look at page 41 of 56 of that memorandum to Advocate Batoi
Yes,
under paragraph 9.
yes, Chair.
It's a statement of the Provincial Deputy Commissioner Brown.
Yes, Chair.
The last part, the hanging paragraph, after the last bullet. Can you read those few lines?
Yes, Chair. It reads as thus: during the daily crime reports at the province, when crime intelligence would present crime reports, Boysen would confirm the contents of the shooting incident reports and provide additional information.
Is this hanging paragraph part of the statement of Commissioner Brown?
No, it is the analysis by the prosecution team from the prosecution memorandum.
It is the analysis.
Yes, yes, Chair.
Now, in terms of the reporting lines, as explained by Provincial Deputy Commissioner Brown, who was the head there? I see he's referring to Captain Van Tonde, Colonel Olivier, Colonel Ayer, Director Boysons. Who was the head?
My understanding was that Colonel Ayer, Rajendran Ayer, was the head, and the other members were reporting to him. However, there was sort of an impasse or something like that, as I was made to understand, and then Major General Boysen was the one to whom members who supposed to report to Colonel Ayer reported directly to in relation to Ketomena.
And in 10, he reported to Commissioner Brown.
Yes, Chair.
You may proceed.
May I just come in here, Chair?
Yes, yeah.
Advocate Noku, for now, the purpose of my questions will be to deal with the delivery and receipt of the exchange of information or request for information between yourself and Advocate Batohi.
Yes, ma'am.
Now, you say that you received a request for information from Advocate Batohi in August. We don't have the copy, we don't have the precise date on which the request was made. But the question is, how was that request delivered to you?
Okay. It was on the 27th of August 2020. I received it via email through my PA, who was then Ms. Tertia van Billion. She gave me the document. It was through email. Dated, actually it was dated 25 August 2020, but it was emailed and received by me through my PA on the 27th of August 2020. And I just don't have it, unfortunately. But then it was saying concerns are raised or something to that effect regarding these following cases. Then explain like your decisions or something like that. Clearly, I don't remember the contents, but it wanted me to explain what happened in each of those cases. Was there evidence for people to be charged? Were there reasons for people not to be charged or for cases to be withdrawn? Something to that effect. That's why I got to be so detailed in my elaboration and explanation to her.
Yeah. So, Advocate Noku, generally I don't ask complex questions or compound questions. I'll ask one at a time. So you say it was delivered to you by electronic mail via your PA.
Yes, ma'am.
And it was directly from Advocate Batohi, or what is the position?
It was from Advocate Batohi, hence even my report is addressed to her directly.
Yeah, now let's talk about your response.
Yes.
How was your response conveyed to Advocate Batohi?
I remember because it was very voluminous. It was scanned and emailed, and it was also hand delivered to her office. So it was in twofold, manually and electronically.
Let's talk about electronic delivery. Was it delivered to her email address? And if so, is it directly to her or via the PA or both?
It was both. She was copied, her PA and herself.
Who was copied? Who was the addressee of the email? When you send an email, it will be to so and so, and then copy so and so. Do you remember?
I don't quite remember how it was put, but then I know it was sent to her and her PA, and I know it was delivered.
Do you know whether your response reached her?
I know it reached her because as much as she did not, I don't know, did she acknowledge receipt or what? It's just unfortunate I don't have access to my emails anymore or any records. But I don't know whether she acknowledged or what, but to show that she had received it. The next thing I received were reasons, me to finish reasons why I should not be suspended. She was not asking about the response to her 25 August 2020 letter. I know she received those. She received my response.
Okay. Yeah, that's what I wanted to establish as to whether you know whether she received your response or not. Thank you.
Yes, thank you, ma'am.
636.
Okay, thank you, Chair. The above are just extracts from some of the witness statements, ballistic experts' reports, the prosecution memorandum, and other relevant documents that I had access to from the prosecution team, explaining the commission of various crimes, including the killing of 28 people. A prima facie case and reasonable prospects of a successful prosecution exist in this case. It is on this basis that I do not agree with the decisions to withdraw charges against the accused persons in the Katomena cases by Advocate Shamila Batohi, Advocate Elaine Harrison, who was formerly Zungu, her team, the DICOC panel, and all others who were involved in the withdrawal of charges against these people. I further disagree that any prosecutor who supported the prosecution of this case as it stands, or any case like this one, has acted improperly. Furthermore,
Before you proceed,
yes,
am I correct that the charges against Major General Boyson was withdrawn in 2019, somewhere there?
Yes, Chair, because it was Section 21E and 21F, which are racketeering authorizations that can only be issued or withdrawn by an NDPP. So those two, yeah. And the others, I think it was later, whether in the same year or 2020, I'm not sure.
When the request was made in August 2020,
Yes.
the racketeering charges were already withdrawn.
Yes, my understanding, because it was in the previous year, 2020, 2019, around June or so, yes.
Are you in a position to explain why then were the charges, why then was the explanation sought post the withdrawal of the charges?
Chair, it was clear to me. The seeking of explanation and clarification from me was just a formality, because nothing was done about it as far as maybe reinstating the case or anything like that. It was just a formality to follow processes, to have an inquiry or a disciplinary action against me, because nothing was done about that. So that is my understanding. It doesn't make sense to make a decision. You don't seek clarification, you don't seek explanations from the people who were involved in the case. You withdraw it, and after that, you want explanations. They give you clear, detailed explanations, and you still don't do anything about it in the interest of justice. You do nothing about the case. So it was clearly a formality that was just being followed to follow the processes that she wanted to follow against me, that she wanted to pursue against me.
But why do you think that she wanted to pursue you with an inquiry?
Chair, there were a lot of things that were happening. I don't know whether to say it or not to say it, and how I'm going to prove it, but it was something that was said to my ears, not what I heard somebody saying, somebody said, somebody, no. I was told to my face when I was still DPP in KZN. That was 2019. I went for an interview for NDPP, so did Advocate Chauke, and others as well. And then I was told there in KZN that Advocate Batohi will come and will deal with me, Advocate Chauke, and the other people. And I asked why, and I was told no. One of the reasons was that I came all the way from Pretoria. I landed in KZN. I shouldn't be there. They don't agree with some of the decisions I made. Like I don't know, like it's a lot of hearsay politics that you can even call gossip, that I wouldn't even have put in my affidavit, because it's not something that I can prove, but I was told. I know I was told. And the treatment that I got from her confirmed what I had when I was in KZN. And the reason why I even wanted to move from KZN, I wanted to leave KZN to the KZNers and come back home in Gauteng. It's just that there was no relevant or same position as DPP in Gauteng. So the closest I asked to go to the Northwest. And it was on that basis that I asked for a transfer to go to Northwest, because I was running away and thinking, perhaps if I'm away from KZN, people will be happy that I'm out of their hair, and then I'm away. So I moved because she was not treating me well. That is something I know, and she knows it. But it's not something that I can tangibly prove. For example, one day there was this conference, I think it was in Irene Centurion or something like that, where DPPs, we volunteered to say, okay, I will do this task, I will do this task. I also volunteered to say I will do a particular task. I don't remember the task, but it was coordinating some project countrywide. And so were other DPPs as well. Okay, so we did that. So one day after that, one day now we were at head office, we were in a meeting. During lunchtime, I was sitting in the boardroom. It was in the AEF, okay, I think it was in the Asset for Future Unit boardroom, which I think was on the first or second floor of the VGM building in head office. Then she came to me and she said to me, no, I don't want you doing that project. I will take it away. I'll give it to somebody else. And I asked her why. And that is just one of the incidents. She was not treating me well. So I realized she was not okay with me. And
So
I
maybe
don't
we
know
can
why.
pause there.
Yeah.
Maybe we can pause there. It shouldn't be like you are testifying against
Yes.
all these people, including Advocate Batoi,
Yes.
because probably you are bitter. Maybe we shouldn't get into those nitty-gritties of your relationship that became sour.
Yes.
Let's focus on the matters we assist with.
Yes,
But
Chair.
we hear you. You had just
Yes.
Advocate Nogu, you say in your opening sentence on paragraph 7 that you do not agree with the decision to withdraw charges against the accused person in the Katomana cases
Yes.
by Advocate Batohi and Advocate Harrison and the DCOG team and everybody else.
Yes.
Can you just quickly maybe run through your reasons why you do not agree with that decision?
As elaborated earlier, that there is a prima facie case and there are reasonable prospects of a successful prosecution. There is direct evidence in relation to other accused. There is circumstantial evidence in relation to the other accused, like Major General Boysen. There is circumstantial evidence. There is evidence of similar fact. And hearsay evidence can also be used in respect of the statements of the deceased people and all of those. So meaning that there is a case that the accused must answer to. And I do not agree with the withdrawal of this case because there is a prima facie case. So it is wrong, according to me, to have withdrawn it. It's not in the interest of justice to have done so in a case like this.
You earlier on testified that you were overseeing these prosecutions.
Yes.
Now, is it normal practice that the NDPP would withdraw a case where the DPP is overseeing those cases and the cases are within your jurisdiction? Is it normal for the NDPP to withdraw? Or is there a procedure or a process that is followed by the NDPP to withdraw a case that is being overseen by a DPP and they are in that DPP's jurisdiction?
Okay, thank you. The NDPP can withdraw any case within the NPA in any division of the country, in any province, because the NDPP is a national director. He or she oversees prosecutions in the entire country. So she had a right to withdraw it if there were valid reasons for that. My gripe is because of the fact that I believe there's a prima facie case and it should not have been withdrawn, as it's not in the interest of justice to do so, but not with regards to her authority to do that. Only a DPP cannot withdraw a case of another DPP's jurisdiction, but NDPP can throughout the country.
Just as a follow-up, before these cases were withdrawn, were you informed as the DPP in that jurisdiction?
No, I learned from the media about it.
Thank you, Chair.
I'll reserve this question towards the end
Okay.
of your testimony. Paragraph 38. You seem to have alluded to poker.
Oh, yes, I have. I must go to 38. Okay.
Read it into the record. It's
Okay,
part of your
thank you,
statement.
Chair. Furthermore, with the available prima facie case and the east burden of proof by the Prevention of Organized Crime Act 121 of 1998 in poker prosecutions, due to the fact that evidence that would ordinarily not be admitted in ordinary prosecutions are, however, admitted in poker prosecutions, like similar fact evidence, hearsay evidence, joining in, etc. The need for the prosecution of the Ketomena case becomes more glaring and obvious because the prospect of its successful prosecution had become heightened as a result. Its withdrawal is unfortunate.
That part takes you to the point that I asked you earlier in relation to the Zondo Commission. You may
Yes.
also read it into the record,
Okay,
to the
thank you,
extent
Chair.
relevant.
Yeah, thank you, Chair. During early 2019, I was contacted by one of the evidence leaders at the Zondo Commission of Inquiry into State Capture regarding a document that had been compiled in my name and my office letterhead of DPP KZN. This document was then emailed to me by the said evidence leader. Upon receipt and perusal of that document, I gathered that it was a memo or covering letter that was for an application for racketeering authorizations during 2012 in the Ketomena case. The evidence leader asked me if the signature at the bottom of that document was mine. In response, I informed the evidence leader that it was not mine because it was not. The evidence leader asked me if I knew whose signature it was, and I answered that I think that the signature looked like that of Advocate Andrew Chauke.
As at 2012,
Yes,
were
Chair.
you in KZN? As at 2012, were you already in KZN?
Yes, I went to KZN in 2009
2009.
as a deputy DPP, yes.
And you were appointed as a DPP when?
Permanently in 2013 to act in 2012.
2012. Signature that you identified as that of Advocate Chauke
Yes.
was on the application for racketeering authorization certificate
Yes, Chair.
in 2012.
Yes, Chair.
Who was the DPP then?
I think when that application was made, I was the acting DPP. Shortly after Advocate Simpiwe Mloja was the acting DPP. I became acting DPP in July 2012.
You may proceed.
Thank you, Chair. The various Ketomena cases were subsequently withdrawn in 2019 by Advocate Shamila Batoyi and Advocate Elaine Harrison, respectively. I was informed by the prosecution team that their response reports were not sought before the withdrawals, nor did the DCOG panel seek the prosecutor's views or reports. It had always been a practice of fairness and justice in the NPA, which conforms to the rule of natural justice of Audi et al. Taram Partem rule, that whenever there's a need to review a case, the views of the prosecutor or prosecutors who dealt with that particular case or cases be sought first before a decision is made on whether or not to confirm or review the decision. Unfortunately, those rules and practice were not applied in the Ketomena cases. My report on the Ketomena case was only requested from me by Advocate Shamila Batohi during August 2020, while the case was withdrawn already during the previous year, 2019, and not even for the purpose of relooking at the withdrawal of this case for justice sake, but for other reasons. As far as I was involved and knew, the one and only
I
reason...
beg your pardon?
Yeah,
For other reasons?
yes.
What reasons were those?
To charge me with an inquiry or something like that.
To charge?
To have an inquiry, to say I'm unfit for office because of the decisions in those cases. Because nothing was done after my thorough and detailed explanation about the case. All those cases, actually, not just Ketomena.
Proceed, ma'am.
Thank you, Chair. As far as I was involved and knew, the one and only reason why Major General Boysen and the Ketomena unit members have been charged in the Ketomena case is due to the prima facie case and reasonable prospects of a successful prosecution that exists in that case. As I have explained the basis supra, I'm not aware of the existence of any plot or plots to derail anyone from any investigation of anyone by charging them in the Ketomena case or any other case. I have supra referred to some cases, Case 466 and Case 781, as related to the Ketomena because it has been mentioned by Major General Boysen that he was being charged in the Ketomena unit because he was investigating Mr. Toshan Pandey, who was the accused in the 466 and the 781 cases, and that the latter, being Mr. Toshan Pandey, was a business partner of the former president's son. I know nothing of those. I do not know who is or was whose business partner of whose son. That did not and still does not concern me in my prosecutorial duties and in any way. During my tenure...
Does that, the former president's son, does that refers to President Zuma's son?
Yes, Chair. During my tenure as DPP in KZN, I was not aware of any case or cases that Major General Boysen was investigating for which he claimed to have been targeted and thus charged in the Ketomena case. Upon hearing this claim, I inquired from Advocate Bulelwa Vimbani, who was then the head of the Specialized Commercial Crimes Unit in Durban, and she indicated that she also did not have any case in her unit, the SCCU, that Major General Boysen was investigating then. My reasons and those of Advocates Vimbani and Litolo in respect of these cases being the 466 and the 781 are in our various reports.
In your report or memorandum addressed to all colleagues,
Yes, Chair.
MN4, NM3.
Yes, Chair.
If you look at MN 00057, the second paragraph or the third paragraph that starts with, it cannot be wrong. Please read that into the record.
Yes, Chair. It cannot be wrong for a DPP to sign an indictment or memoranda or other correspondence in cases that resort within their own of jurisdiction, in whose names such prosecutions are instituted, and especially that these are so signed by the DPP for the purpose of forwarding such correspondence to their superiors, being the NDPPs. It would not be proper for such to be signed by anyone below the DPP when such is destined for the NDPP, and when the relevant DPP is available and legally able to sign such by virtue of the powers, duties and functions conferred on a DPP in terms of Section 24 of the NPA Act 32 of 1998.
You reiterate those remarks? Do you reiterate those remarks?
Yes, I do, Chair.
The next, last but one paragraph?
Yes, Chair. As a matter of fact, even those who are not,
No.
oh,
The last but one.
Oh, last
that-
but- okay.
Yes, because that part deals with those who are not NDPPs. So I don't think it's very relevant.
okay.
But you may read it for completeness.
Oh, okay. Thank you, Chair. As a matter of fact, even those who are not the NDPP themselves, but based at head office, often demand that the DPP must be the one who signs correspondence to head office that is not even addressed to the NDPP. What more if that is addressed to the NDPP directly? On what basis is it seen to be wrong when signed by the DPP for their own jurisdiction? I did not have reason to doubt what the prosecution team presented to me in the above cases, leading to decisions that were ultimately made in such cases, especially considering their levels of seniority and experience, being deputy DPPs, senior state advocates, and state advocate. They read the case dockets and compiled their prosecution memoranda, which I relied on. This is the practice within the NPA and for practical reasons as well, that prosecutors, especially DPPs and head office, being the NDPP and DNDPP, will confirm to being applicable that we rely on the presentations by the prosecutors or prosecution teams, especially being high-ranking and experienced as in these cases. For example, in this very Katomena case, the DICOC panel appointed by Advocate Batohi compiled their report, although without consultation with myself and the prosecution team, and advised her thereon. Advocate Batohi then relied and acted on the basis of this report and withdrew charges in this case. Therefore, it cannot be wrong for me as DPP when I relied on prosecution memoranda from senior or high-ranking and experienced prosecutors as it happened in the above cases, then labeled as targeting certain people and protecting others, as if I worked alone and with hidden agendas in those cases. Anyway, not that it is wrong to deal with a case alone. As prosecutors in the Katomena cases, we simply believe in these cases and the appropriateness of their prosecution, hence our decision. There is no ulterior motives or malafides that I am aware of or part of in the decision to prosecute the accused in all these cases. I have no other interest except of justice in these cases. I need to be shown evidence of protecting and targeting some people. Some claim to have been investigating some high-profile cases and that being the reason of them being targeted and prosecuted to allegedly derail them. I'm not aware of any big or high-profile case that those people were dealing with for which they claim victimization, and I could have known if such existed when I was DPP KZN.
Before you conclude, the previous page, you referred to the DPP signing indictments, memos, and other correspondence.
Yes, Chair.
Are you aware of any occasion or of any matter for that matter, a case, in respect of which Advocate Chauke signed the indictment in KZN?
I'm not aware of that, Chair.
Any correspondence that you may be aware of that might have been suggestive of the fact that Advocate Chauke took a prosecutorial decision in respect of the Katomena cases in KZN?
I'm not aware of that, Chair.
What role, if you know, did Advocate Chauke play after being asked by Advocate Jiba to organize a team of prosecutors?
I heard from
Or
the
to coordinate a team, if the word is correct?
Yes. No, I heard from the prosecution team that they would brief him the same way they did to me. They would brief him on the case, what is happening, update him as the DPP who was overseeing or coordinating the case. And furthermore, other than the meeting that we had with the judge president for requesting a judge from outside of KZN, and this memo that was shown to me by the evidence leader in the Zondo Commission, which was a covering memo for request for authorization for racketeering certificates in 2012, which I also did in 2016. Then I'm not aware of any other really role that he played. I see his role as the same one that I played, being updated, and you sign whatever you need to sign because protocol and practice requires you to sign that, and you get updated by the prosecution team. But the decisions and everything are done by the prosecutors and the prosecution teams. And we just there as DPPs because every case must have a DPP. Can't just be prosecutors.
Are you correct, though, to suggest that he played the same role as you did? Because you were the DPP KZN. He was the DPP South Gauteng. So for him to do what you did does not necessarily mean that he had authority to do what you did, or is my understanding correct?
No, you are correct, Chair. But issue of authority is a different issue now. I was just answering on the role he played, and whether he had authority or not, by virtue of him not being DPP KZN, is a separate one. So I'm not sure about authority.
A suggestion is made that he acted unlawfully by straddling, being a DPP South Gauteng and going to KZN and performing prosecutorial decisions. That's why I'm asking all these questions, because I need to understand precisely what is it that he did as he oversaw, as Advocate Jiba had allocated him that role. What is it specifically that he might have done that suggests that he acted unlawfully? If you know?
I'm not sure what those who are alleging that he acted unlawfully, improperly, or wrong have to back the allegation. He who alleges must prove. So they are alleging, I think they will know better, Chair. Really, I don't know where that is based on, because my understanding was that he was instructed, like it was an instruction that he was carrying over from the acting NDPP then to say, go and oversee this case. That's how I understood it. That's why I found no wrong in that. But if it's wrong and it's alleged it's wrong, perhaps those know why they are saying it was wrong. Really, I don't know, Chair, I'm sorry.
In your view, him having been asked to oversee the work of the prosecution team,
Yes.
and asking you to accompany him to approach the judge president with the request that you presented to him to appoint an outside judge.
Yes.
Could that role that he played be considered, given the totality of the evidence and the circumstances that prevailed at that time? Could such a conduct on his part be considered to be unlawful?
It can be unlawful. It can be unlawful because, as I said, my understanding was that he was mandated to go oversee that case in KZN from Johannesburg to KZN. So it can be unlawful or improper if it's within the mandate, command, or instruction given by his superior then.
As a DPP at that time,
Yes.
you had no disagreement with that kind of a conduct, or you are not opposed to him approaching you, coming from South Gauteng, and requesting you to do the things that he suggested that you should do together, for instance, approaching the judge president in relation to those matters?
No, I did not have any objection or concern about it because my understanding was that the person who was heading the entire NPA then, who was the acting NDPP advocate Jiba then, had authority regarding everything that is happening within the NPA countrywide. And if she had decided to mandate a DPP from another province to deal with a matter in another province, I did not see it wrong or to have a problem with it. Really, I did not have any concern. I assisted as I was requested. I did not have a problem, really.
I think you are better placed to understand the prosecutor's policies, internal policies, and of course the relevant provisions of the enabling legislation. As far as the law is concerned, is there any legal provision or even policies for that matter that would have made Advocate Chauke's presence or whatever he did in KZN following the request by Advocate Jiba to be illegal or unlawful?
Chair, I think it's Section 24 of the NPA Act, 32 of 1998, that appoints or describes, I think it's, well, appointment is in terms of Section 13, but the duties, responsibilities of DPPs, I think it's in Section 24, if I'm not mistaken, of the NPA Act. It says nothing about a DPP forbidden from doing a job in another jurisdiction. It's silent on that. And I don't think it can be imputed to say you cannot go do that. My understanding, if I'm wrong, then I am wrong. But even now, my understanding is that as much as I'm appointed to be a DPP in Pretoria, I do conduct my duties as a DPP in Pretoria, for example. It does not mean that if my superiors say I'm tasked, that's what we call ad hoc duties. You get tasked to say, okay, there's this one project that we want you to go do somewhere else. The same way as prosecutors below the DPPs are being tasked on ad hoc basis. Go do this in this province, and they get delegations for that. My understanding, and even now it's still like that, that even DPPs can be tasked by their superior, which is the NDPP, despite the fact that they are stationed or appointed for a particular division. The NDPP, as the overall head of the prosecution service in the entire country, it's my understanding that they can say, go do this there, go do, even though you are, yes, that's how I understand. As a result, I'm not aware of any provision in any legislation that forbids that from happening as far as the DPP is concerned.
Yes. Now, the concluding paragraph of your memorandum to all your colleagues, and I suppose what you read earlier,
Yes, Chair.
you read it as incorporated in your affidavit. This is a statement
Yes,
that
Chair.
you just read in, and it was not written under oath. It was not commissioned, so you are repeating those in your evidence.
Yes, under oath. Yes,
And the
Chair.
conclusion, if you are minded to read it, it is long, but it may just be relevant that you read the entire part.
Yes,
It says
Chair.
that in the record, if it is of relevance.
Okay, I'll just read up to where it's relevant to the Ketomena case,
Yes.
which is up to page 56. That's just the 2 lines on top, on page 56, I think that is what is relevant. Or maybe I can just finish off, it's just 1.5 page extra, because I may miss some that are maybe relevant. May I proceed?
Proceed, madam.
Thank you, Chair. The prosecution teams in various cases, myself and various NDPPs and DNDPPs in these cases, acted in good faith, and we exercised our prosecutorial discretion and independence to decide on cases without fear, favor, or prejudice. However, it appears that I and the prosecution teams and others are expected to have acted differently in those cases, despite the status of cases that determine whether or not we prosecute, not who is being prosecuted or who is not. This is eroding the prosecutorial independence that prosecutors must enjoy in terms of Section 179 of the Constitution when executing their prosecutorial duties, because fear and pressure is instilled in prosecutors. Some of us are already experiencing the negative consequences of this fear in prosecutors. They tend to be scared to deal with any case that has any issue or issues around it for fear of being labeled and crucified at the later stage for their prosecutorial decisions, which position did not exist previously. There has to be accountability for decisions that prosecutors make with their reasons for such decisions. However, being insulted and labeled for simply holding one's views in cases that one dealt with and while advancing their reasons for their decisions is neither good nor fair to me and other prosecutors who are part of these various prosecution teams. Neither is this good, nor does it augur well for an independent prosecution service that has to execute its prosecutorial duties without fear, favor, or prejudice as the Constitution requires. I have no problem at all to be hated. I'm not here to be laughed anyway. Oops. However, it is something else to be defamed, vilified, insulted, and called rogue element, rotten apple, saboteur, controversial, etc. I need to be shown who I have sabotaged and made them fail to do their duties. As much as we are rightfully expected to prosecute without fear, favor, or prejudice, sadly, on the other hand, we are ridiculed for doing so when our prosecutorial independence and discretion have been exercised in situations that appear to be unfavorable to some. Criminal cases are even opened against us for doing our job as prosecutors. One wonders if this is being allowed, that those who are not happy that prosecutors are prosecuting them, as if anyone would be happy for that, may open criminal cases against these prosecutors, and whether or not prosecutors must start to accept this as part of what comes with their job as prosecutors. In 2015, a criminal case was opened against me for my role as explained above in the Ketomena case. It was then allocated to a certain DPP who declined to prosecute it, as obviously rightfully expected. However, despite the decision to decline to prosecute, this case is still left to hang up to now, unfairly so, over my head, like I'm some criminal and is still being decided upon, even though a DPP has already decided and declined to prosecute me for executing my prosecutorial duties without fear, favor, or prejudice. Perhaps it is relevant to indicate here that I have been repeatedly falsely accused in the past for reasons known to the accusers. For example, on 9 February 2014, City Press published an article that I have been busted on video footage dumping files on the high-profile case of Mpisani in the parking area of the Pietermaritzburg High Court. This false story was widely published against me. The reporter indicated that his report was based on information supplied by at least 3 sources who are employed by the National Prosecuting Authority, NPA, who met with him and confirmed this false story to him, and because he had used them before, he trusted them to be telling the truth, whereas he realized later that the story was false and he was being used by his own NPA sources who had doctored the whole story and files had not been dumped there as he was made to believe. There was no CCTV footage, and that Noku, myself, was not even in the building at the time of the alleged incident. Further, the reporter said that his trusted NPA sources played him for a fool and used him, he assumed, as part of a bid to make Noku look incompetent. He apologized for that. This City Press article is attached here to as Annexure GG. Myself and some managers in my previous Pietermaritzburg office in KZN were at some stage subjected to some unfair and humiliating process of investigations authorized by Advocate Karen van Rensburg and the then NDPP. A lot of money and state resources were spent in this futile exercise where a firm of attorneys was contracted and paid for pure internal NPA issues that should have just simply been internally dealt with, being issues of racism and others that had long been in existence from the time when Advocate Mphe and Advocate Batohi were DPPs in KZN, respectively. In the same way, again, millions were spent fruitlessly in the so-called work study exercise, which up to now has yielded no positive results to the NPA, which exercise we as DPPs could have simply and most efficiently dealt with in our divisions, as we are au fait with the operations and dynamics of our divisions more than any person contracted for millions of rands coming from outside to attempt to do it. No one is saying anything about all these wrongs and injustices. Instead, I am being continuously harassed for my prosecutorial decisions. I just mentioned the above as some of the examples of how dangerous some of our own colleagues within the NPA are, and are unfortunately even sources to the media against some of us. In the same vein, we have very good and credible colleagues within the NPA to whom I feel obliged to write these explanations so that they get to know my version. I cannot control what those with agendas plot and say, as they have been against me for a number of years now. The same stories that puts me in a bad light continue to prevail despite my clarifications and explanations. I have integrity and adhere to the values of the NPA, and I live daily walking tall and sleep well every night with a clear conscience, knowing that I execute my prosecutorial duties by the book. However, I cannot continue to be insulted like this in silence with the hope that justice will be done. My living God will ensure justice for me. He surely will.
That is read as being incorporated in your statement, in your affidavit?
Yes, Chair.
Today?
Yes, Chair.
Thank you, Chair. Advocate Noku, I want to take you just 1 or 2 steps back.
Yes, Chair.
And the questions, are you in conference? Okay, thank you.
Yes, ma'am.
What I'd like you to please assist the inquiry with, and especially myself, I may not be understanding some things quite well. And it is particularly relating to the prosecution terminology in relation to the functions that get discharged by different designated positions.
Yes,
Now, in this case of the Katomena,
yes, ma'am.
the person who is, or the professional that is designated as the lead prosecutor is Advocate Maema.
Yes.
Now, can you just enlighten us as to what responsibilities rest on the shoulders of the lead prosecutor in general terms?
Yes, ma'am, thank you. The lead prosecutor in any prosecution team will be like, I don't know whether to call it a coordinator. Even let's say, for example, the matter goes to court. He or she is the one who will be speaking mostly, yes, and the others are mostly supporting team. So he or she will be the one talking, putting the charge, but then they can also share the roles. Others may lead other state witnesses, things like that. But the lead prosecutor does most of the work. And when you want anything in that case, you go to the lead prosecutor. That is why Advocate Maema here, for example, in the Katomena case, he's the one who even signs the prosecution memorandum. And that would happen with the concurrence, with the prosecution team having discussed, looked at the case, read the document and all of that. They compile a prosecution manual, but it gets signed by the lead prosecutor. So he or she is the go-to person in the prosecution team, because otherwise, if there's no lead prosecutor, you don't know who to go to in that case. You go to this one, you talk about this issue, things fall within the cracks. So there has to be a particular person that you know as a DPP, whatever I need in this case,
Yeah.
I go to this person, yes.
Right, thanks for that explanation. You know, I think your focus or focal point has been more of what happens at court. But we know that about prosecution, the road is longer.
Yes.
There's a lot that has to be done before a matter is ripe for prosecution,
Yes.
or even where you need to make some reconsiderations whether to proceed or request to stop the prosecutions and so forth. Now, at that point of the investigation of the matter, maybe let me ask this first. Is it correct that once a matter, it has been decided that there should be prosecutions, but the investigation at times continues beyond that decision to prosecute?
Yes.
Is that correct?
That's correct, yes.
Yeah, thank you. Now, in the event that, in cases where there is investigation that is taking place,
Yes.
what is the role of the lead prosecutor?
Yes.
Can you enlighten us about that as to whether he plays any role, and if so, what is the role?
Yes, ma'am. The lead prosecutor plays a more active role there. They will be arranging with investigating officers to bring witnesses for consultation. They'll be the ones directly giving instructions to investigating officers, go do this, 1, 2, 3, 4, things like that. They'll be liaising with the attorneys or the legal teams for the accused, in writing or verbally in meetings. Yeah, all those. They do everything as if they are the only prosecutor in the matter. Physically, they get to be the ones doing that more. However, there's coordination and working together as a team from the entire members of the prosecution team. But yes, that's what the lead prosecutor does.
Would it be correct to describe the lead prosecutor as actually the accounting officer
I would.
who would have to see that everything is done well, and if there is accountability or accounting to be done, it must be done by the accounting officer, and in this case the lead prosecutor? Would that understanding be correct?
Yes, it would be correct, ma'am. Yes.
Right, thank you, Chair.
In 2019, when Advocate Batoyi withdrew the racketeering charges, she had not had a side According to her, she had not had a side of the dockets. Do you know that?
I had that from her, yes. I don't know that.
When did you hear from her?
When she testified, Chair.
In your view, as a DPP or a prosecutor of 23 years of experience, is it normal or is it acceptable for the leader of an institution such as NPA to make decisions without herself or himself reading the dockets in respect of which he makes decisions?
I'm not sure how NDPPs work, but what I expected from NDPP and herself in respect of the Katomena case specifically is for her to have obtained reports of all the prosecutors who were involved in the case, starting with Advocate Chauke, who was the DPP, the first DPP in the case, myself, the second DPP, and the entire prosecution team. That was very, very important because it would have summarized the whole case for her, as I did only the following year when she requested. But before withdrawal, you are supposed to obtain everything from both sides. If you receive representations from the accused person, you must also receive response from prosecutors responding to those representations and rebutting allegations in there, for example. So whether she must have read the whole case dockets or not, I don't know how they review decisions as NDPPs. I don't know what the process is really. I don't know how they work. But I understand they rely on reports. So it's fine relying on reports, but how do you make a decision not having reports from prosecutors who dealt with the case themselves? Because she did not before she withdrew the case. The DICOC panel constituted by Advocate Rodney DICOC, Advocate Ivy Tenga, who's DPP Limpopo, and I think there was one Advocate Riley. Apparently, I don't know who else, but I remember those three. My understanding is that they formed the members of the DICOC panel. They also did not get prosecutors' reports. So on the part of prosecutors' report, really, it doesn't make sense to me, because that would have helped a lot to arrive at a fair decision. We're looking at fairness, yeah. So it can be fair to look at one side and make a decision based on one side.
Have you had a chance to look at the DICOC report? Those two reports by Advocate DICOC?
Yeah, I think I found it from the media, because I was never given a report, yes. But I think I got it and I read it, yes.
As you read the reports, did you see any summaries of the dockets as you have done in your memorandum to Advocate Batoi?
No, not at all. Not even referring to what the cases are, maybe trying to crash what is, nothing like that. There was no mention of the dockets and what they say, evidence per se, no.
We know, as we were made aware by Advocate Batoi, that there were 23 dockets
Yes.
in relation to the Katomena case.
Yes, Chair.
Correct?
Yes, Chair.
And those dockets were not summarized as you did in your memo of 2020 by the DICOC team.
Yes. It wasn't, Chair.
Correct.
Yes.
Thank you.
It wasn't.
You may not be able to answer this question, but I would like to get your views.
Okay.
Had Advocate Batoi been given the summaries you have now presented to us,
Yes.
because she didn't read the docket,
Yes.
had she been aware of those summaries,
Yes.
do you think that she would probably have decided otherwise?
I think so. Any reasonable NDPP, DPP prosecutor would have decided differently had he or she had sight of summaries of case dockets and the witnesses' evidence and all of that. But I don't know whether she had it somewhere or not. Yeah. I myself, if it was me, then I would change, I would reconsider my decision of withdrawing to realize I was wrong. Then no, let us reinstate this case.
Now that she received, and I assume that she did receive your memorandum
Yes,
of September 2020.
20. Yes, Chair.
What would have been the appropriate step to take in those circumstances?
To reconsider her decision and realize, in the interest of justice, she made a mistake and she must re-enroll the cases and withdraw her withdrawal of the section 21F and 21E, the two racketeering, because those are the ones she withdrew.
The withdrawal of the racketeering authorization charges or certificates, as it were, means you can later reinstitute, correct?
Yes, you can. Withdrawal in prosecution environment means the case is taken off for whatever reason, but it can be reinstituted whenever the situation changes complexion. So if, for example, the reason for I withdraw this case because there are insufficient reasons, and later more information comes that gives me more evidence, then I can reinstitute it again. So she could have done the same as well. If her reasons to withdraw the racketeering certificates was based on lack of prima facie case or lack of prospects, reasonable prospects of a successful prosecution, then having had sight of what she had later then, at least from me, then I expect her then to have reconsidered her decision, to say, no. Interest of justice do not allow this kind of injustice to just be left like this. Because now she was made aware of what is happening in these cases. If she withdrew without understanding and she thought there was no evidence, I tried my best to show her that there's evidence in this case. There's similar fact evidence, there's hearsay evidence, there's circumstantial evidence, there's direct evidence in respect of the other accused. The charges are in respect of POGA legislation. POGA legislation allows all those to be used. So there's a prosecutable case. Yes, Chair.
As we speak,
Yes.
the position is still the same, the charges are still hanging there as they have been withdrawn.
Yes, Chair.
Are they capable of being reinstituted?
Yes, definitely, Chair. They have just been withdrawn. It's not an issue of atre for acquis. So they can be reinstituted. It's not like the accused have been acquitted. And in terms of atre for acquis, you can now reinstitute. It's just a withdrawal. A withdrawal means there are reasons why we withdraw, and you can later reinstitute. Plus, most of the cases are murder. Murder don't lapse.
Thank you, Chair. Advocate Noko,
Yes.
it will help us a great deal to just, maybe if you are to explain two concepts.
Yes, ma'am.
The concept of withdrawal of charges and
Yes,
the
ma'am.
concept of declining to prosecute.
Yes, sir. Okay.
Now, is it correct? Well, you have already dealt with the issue of withdrawal, but I'm putting them side by side.
Yes.
You have eloquently and adequately dealt with the implications of a withdrawal.
Yes.
But now let us go to the implications of a declining to prosecute. Once the prosecutor has declined to prosecute, right, what is the effect and impact of the decline to prosecute?
Okay, thank you, ma'am. Declining to prosecute is, I can just make an example. Let's say you have a case of shoplifting. Somebody has stolen some sweets worth 10 rand. And then you say, no, I'll apply de minimis non-curat lex. So as a result, I'm declining to prosecute. That case can never come back based on the facts. So there are some decline to prosecute, which is also nolle prosecute, that apply and it's final, it's decline to prosecute. However, that's where now it overlaps with the withdrawal and almost it's the same thing depending on the facts of the case. So another one will come before you as a prosecutor and you decline to prosecute and your reasons are insufficient evidence.
Yes.
In that one, evidence can still crop up tomorrow and then you do what? You reinstate it. So it's like, it's a withdrawal, but you decline to prosecute. And another a feature of withdrawing a case is, for example, a case that is already on the court roll, and then you pull it, you withdraw it, because you realize now the insufficient evidence or other reasons. That one can still go back. But decline to prosecute mostly is when, at the first instance, a prosecutor receives the docket and makes a decision. And the prosecutorial decision in that case is that I am not prosecuting here. I nolle prosecute. I decline to prosecute for various reasons, like I mentioned the de minimis non-curat lex. I mentioned the insufficient evidence. I mentioned a lot of other reasons. But still, it can come back as well, depending on facts. Yeah.
Yes, you're not the subject of this inquiry.
Yes, ma'am.
But I heard you say you have this hanging over your head because there has been an expression of declining to prosecute by one of the deputy prosecutors, but then it remains like that. So once a deputy a director or anyone with the power to decline
Yes.
makes that recommendation that this matter or a view, forms a view and expresses that it has to be declined, prosecution should be declined, who ultimately issues the nolle prosequi certificate?
The nolle prosequi certificate is issued by the DPP. And it's on that basis where now we talk about private prosecution, for example, if somebody else is not happy with the declining, yes, but yes, the DPP does.
Was declining to prosecute. It's clearly just a withdrawal.
It's a withdrawal.
Thank you,
yes.
ma'am. Thank
Thank you, ma'am.
Advocate Koe and the evidence leaders, Advocate Toby, is 1:25. I think it's, Madam, it's time to pause
Yes, Chair.
and just to stretch our legs and go and have lunch. Yes. I'm not sure whether there is lunch, but I'm told one of the officers is celebrating a birthday. So you'll have a birthday cake for lunch. I've been asked to invite all of you family You remember we are a family, so we're going to share a birthday cake at lunch. We will again advocate Goitobi. Ma'am, we will afford you an opportunity to proceed. And thereafter, if the time will be ripe for Advocate Goitobi to cross-examine. Let's take a lunch break for my sister on the left is admonishing me, but I accept the whipping. We will adjourn for an hour until 2. I must remind you that you are still under oath, madam.
Yes, Chair.
You can join us as we cut the cake, or they will bring a piece of cake to you wherever you are sitting.
Thank you, Chair.
Let's adjourn, grab lunch, share a cake, and come back and work. We adjourn for now.
Good afternoon, Chair.
Good afternoon, everyone. Once again, Advocate Noko, Advocate Chauke, Advocate Kowe. Madam, you are still under oath.
Yes, Chair.
Advocate Kowe,
Thank you,
may
Chair.
proceed where we interrupted you.
Chair, my colleague who's working with me on the matter has a few clarifying questions for the witness. May he have an audience? Mr. Mtsweni.
You don't have anything?
I have nothing. I have nothing.
Yes, Advocate Mchene.
Thank you, Chair. Madam Nuko, I just want us to go through your app. We do this in order to obtain clarification on some of the aspects which came out during your evidence. And you would recall during the course of your evidence yesterday, Madam Ramakaka took you particularly raised the question of what amounts to prosecutorial decisions or acts vis-a-vis oversight. Do you recall that?
Yes, I do.
And I just want to get your comment on Advocate Chauke's conduct so that you are not criticized in future that you have not dealt with that.
Okay.
And I think the starting point would be in relation to the consent between Advocate Chauke and Smith. Do you recall that?
Yes, I do.
And you testified that in terms of section 111 of the CPA. Madam Chair, if I'm too fast, please do alert me.
I think you are steady.
Yes. You testified that that kind of consent is usually done between two DPPs. Am I correct?
Yes.
And it would be one DPP consenting to have a matter that would have otherwise been prosecuted in his or her division to have that matter prosecuted in another division.
Yes.
So
that's
basically, would one classify that kind of conduct as a prosecutorial decision or as an oversight act?
true. That is a prosecutorial decision.
Now, we know that in this case, it was Advocate Chauke who entered into that arrangement with Advocate Smith.
Yes.
And we know that at the time, Advocate Mlochwa was the acting DPP in KZN.
Yes.
And the arrangement was that these matters, the Rustenburg case, would go and be tried in KZN,
Yes.
not in Gauteng.
Not in Rustenburg.
Yes, and not in Gauteng as well.
Yes. Not in Gauteng.
Now, if I might ask, you testified that you had seen the authorizations granted by Advocate Mlochwa to the prosecution team.
The delegations, yes.
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 Did you see one in respect of Advocate Chauke?
No, Advocate Mlochwa was in the same level with Advocate Chauke because Advocate Mlochwa was the acting DPP. So if there were to be any authorization or delegation for Advocate Chauke to prosecute in KZN, that would have come to somebody who's superior, and that would have been the NDPP.
Yes, I'm saying from Advocate Jiba at the time.
Yes.
Did you see one?
No, I've never seen that.
And you say that the consent was a prosecutorial action, the consent between Smith and Chauke.
Section 111, yes, it's a prosecutorial decision because as a prosecutor you decide whether to take the matter that you have to another jurisdiction or to request a DPP in another jurisdiction to give you that case to deal with it. It will depend on the circumstances and facts of the case. But yes, it's a decision that a prosecutor takes.
Now, would you say that it was competent or proper for Advocate Chauke to enter into such an arrangement, notwithstanding the fact that Advocate Mlocha was the DPP of KZN?
I don't know what the arrangement was. That was before I came in.
Yes, I'm
I don't
asking you this, ma'am, so that we get all the facts
Yeah.
clear. You expressed an opinion as to whether towards your engagement, the end of your engagement with the panel,
Yeah.
that there was nothing wrong with one DPP exercising some functions because there was no statute that said he can't do that.
Yes, I'm not aware of that, yes.
Yes, and if, to be fair to you, would I be correct that a prosecutor or a DPP is an organ of state?
Yes.
Would I be correct to say then he can only exercise those powers that are given to him by law?
Obviously, we are creatures of statute. We operate in terms of the law. But my point was that I have nothing that I'm aware of that legally forbids the opposite. It's silent. For example, the NPA Act is silent. It doesn't say a DPP cannot operate in another jurisdiction. So that is why I could not give my opinion whether that was wrong, illegal or not, because I'm not aware of any statute or legislation that prohibits that. For me to say any action contrary to that is a contravention of that legislation. Hence, I could not say it was illegal
Yes.
or unlawful.
I'm not sure whether you would have the bundle or I'm not sure what the witness bundles would be, but I wanted us to also examine Advocate Chauke's involvement in the matter in his own words so that I also get your comment whether was it part of oversight or was it a prosecutorial action.
Okay.
Madam Chair, I think it would be in the LO bundle. You would not have it.
She wouldn't have it. If you want to ask questions, try to make sure that you give it to her. Then she can read it.
I thought there was a witness bundle that had been on standby, Madam Chair.
You would have been, as evidence leaders, be responsible for that evidence bundle, not anybody else. But let us see if I can assist with my copy. It's LO.
LO, it's Advocate Chauke's affidavit in the Zondo Commission. It starts at LO 243. I'm skipping the zeros, Madam Chair.
You must read everything.
It's LO 00243.
LO 00
243.
243.
Unfortunately, yes, 243. I'm not sure whether it's LO1 or not because I've got it in electronic format.
It should be Advocate Mchweni. It's LO1, then 00 something.
Thank you, Madam. Thank you, Madam Chair.
Yes. We will borrow you a copy.
Thanks.
Do you have it, Advocate Nogo?
Yes, I do.
Yes. As you would see, that's the witness statement in terms of Rule 3.4. And it's deposed to by Advocate Chauke in what had become known as the State Capture Commission.
Okay.
Now, I do not think that it would be disputed. That is, in fact, his affidavit. But I just want us to zoom into what Advocate Chauke described in the Zondo Commission as being the extent of his involvement in the Cato Mena prosecution. And you would find that at 265, LO1 200265.
Okay. Yes. Okay, I'm there.
Starting from paragraph 57.
Okay.
Sorry,
have
Madam
it.
Chair. I'm hoping that my learned friend will tell us at some point what is the relevance of these questions to the terms of reference.
Yes, Advocate Mchene, you are clarifying questions with the witness. You can guide all of us as to where you are getting to.
Madam Chair, is to simply, you would have recalled that Advocate Batoi testified that Advocate Chauke's involvement amounted to, was beyond an oversight.
Yes.
And you would have recalled, although there's no response from the President on the amendment, but you would have, in your report to the President, in your ruling, you had foreshadowed that this was not a new event. It is apparent from the, I can't recall the exact part in your ruling.
If you can speak louder,
Oh.
it will help me.
Okay. Where you, in your ruling, where you did not support the amendment, the request for an amendment, that this aspect has always been there. And it would
Which
be
aspect?
the issue of Advocate Chauke traversing, acting out of bounds, of his statutory bounds. But I will just get to the terms of reference where I can point you exactly. I'll just ask my colleague to assist me.
Yeah, it will be helpful, Counsel. You are now referring to the ruling. And you mentioned aspects that I don't remember are written in that ruling. It might have appeared in the application. So it's helpful if you can give us the context and then we can look at all the documents.
I will do so, Chair, later on.
Yes.
If that aspect might just be, if I can just have made note of what
If a need arises, we can adjourn and get the copies of the ruling. Because you are referring to it and we don't have it here. And what you are mentioning, I don't remember that part being mentioned in the ruling itself. But give us the context, and so that you can then proceed with the question. Then we can at least follow as to why you are pursuing that line of clarification.
Madam Chair, basically it also follows upon what Madam Ramakaka took up with the witnesses to the distinction between prosecutorial actions as well as oversight action. It simply follows upon that. But if it's regarded as not being relevant, Chair, we will know, we can abandon that.
Advocate Mshweni, you asked that question earlier, and that was followed by further questions.
Yes.
You sought the response of the witness in relation to those concepts, and he answered, and then you followed that with further questions, and then Advocate Gaitobi says, but where are we going to? And I'm saying to you, I'm not sure what the context of this is. You can just maybe tell us, you seek to clarify something with regard to that. And if it falls within that distinction, make it clear to us so that we can...
That is basically the concept to say whether was Advocate Chauke's conduct and oversight or not. That was just simply on that
You
basis.
may proceed.
Yes. Advocate Nuko, at paragraph 57, I will not read it, but Advocate Chauke tells us of the circumstances which led to him being involved in the matter. In the main, that it was at the instance and at the request of Advocate Jiba, and he provides the reasons why, amongst others, he would be requested to assist and to procure prosecutors outside KZN. But what he then, at paragraph 62 on LO 00267, at paragraph 62, he outlines what his role as the team coordinator was. And in the nutshell, he says, was to deal with logistic and administrative matters of the prosecution team, ensuring the coordination between various stakeholders, and then that he was not involved. 62.3. My involvement excluded taking prosecutorial decision whether to prosecute or not. And then at 62.4, it says feedback and briefing on the team to JIBA, including submission of documents from the prosecution team to the NDPP. And then he then, moving forward, at paragraph 64, he then tells us what then started to happen. He says, on the 3rd May 2012, I attended a briefing meeting with JIBA, during which it was arranged that the prosecution team brief her on the Cato manner on 18 May 2012. And on 15 May 2012, I attended a meeting with the prosecution team for the preparation of advocate or for JIBA's briefing. Now, again, within the context, just to underline whether that conduct amounts to prosecutorial action or oversight. Well, how would you classify that?
You mean the briefing?
Yes, what it says on paragraph 64.
The briefing are actually done by DPPs in every high-profile cases.
Now, which DPP would do that?
The DPP who's in charge of the case.
In charge of the case, would it be in whose jurisdiction the prosecution will take place, or the oversight DPP?
It depends on which under which DPP that case results. So in respect of Katomena, then it was resulting under Advocate Chauke in terms of the instruction from the NDPP, acting NDPP Advocate Jiba. But then it was under jurisdiction of Advocate Simpium Loja, then myself afterwards.
Yes. So you're saying that briefing ought not to have been done by, ideally, it ought to have been done by Advocate Mlojo?
If he was overseeing the case. But if he was not overseeing the case, he could not have been expected to be the one briefing the NDPP, but the one who's overseeing it. Whether he's doing so rightly or wrongly, it's something else. But the one who's in charge of that case then, overseeing it, is the one who's supposed to brief the NDPP.
Yes. And then he goes on paragraph 68. He says, on the 24th May 2012, he attended a briefing meeting with JIBA together with the prosecution team, where Matenja did the briefing. And the briefing entailed possible charges against the suspect, the security of the prosecution team, delegations of the prosecution team, and Part 8 of the Prosecution Manual and Section 17 of the Inquest Act. Do you see that? It's on...
Yes, I saw paragraph 68, yes.
And you still maintain that the briefing still has to be done by the DPP overseeing the matter?
Advocate Msweni, the point here is that Advocate Chauke was overseeing the case.
Yep.
And he had to be the one doing the briefing. It's a different point whether he was overseeing the case rightly or wrong. But if we talk about the briefing, he's the one who's expected to do the briefing. No other DPP was overseeing the case, but he was. So he's the one who was expected to go with the prosecution team, and the prosecution team brief the NDPP in his presence. That's how it worked even with me. And in all other high-profile cases, we had a lot in KZN and we would go with the prosecution team, and the NDPP is briefed by the prosecution team, and the DPP will add here and there wherever is necessary. But the fact of the matter here is, with regards to the briefing, he was overseeing the case. No one else had to brief the NDPP except him.
Yes. And then we go on, thank you for the clarification. Then at L01,
Before you proceed, Council, paragraph 68, were you focusing on the second sentence that says Matenja did the debriefing? Were you making that point?
yes, as well as the in relation to the charges, where the possible charges are being discussed.
Where does it say that?
He said that this briefing entailed charges against the suspect, the security of the prosecution team, delegation of the prosecution teams, Part 8 of the Prosecution Manual and Section 17 of the Inquest Act.
Yes. And with regard to the point that the briefing was done by Advocate Matenja, are you taking issues with that?
No, we're not.
Okay. Yes, the next one.
Now, I just want us to jump further to paragraph 79, where he talks about having held a meeting with Mlochwa, as well as the acting DPP of KZN, as well as the acting judge president about that matter. Would you still classify his attendance of those meetings as part of the oversight duties?
The thing is, I was not in the picture yet, so I don't know what was discussed.
No, I just want to do Advocate Chauke's involvement. Would you classify it as prosecutorial, or would you still classify it as part of the oversight?
It's hard for me to say if I don't know what was being discussed, because what gets discussed determines whether it's prosecutorial or oversight. It could have been that they were discussing security of prosecutors. It could have been they were discussing who to charge with what charges.
Okay.
But if I don't know what they discussed, I can't answer that.
Now, let's go to paragraph 8.
Before that, 79 flows from paragraph 78. It's the 18th of June 2012. Were
Yes.
you the DPP at that time?
Not yet, Chair.
It was Advocate Mlochwa.
Yes, Chair.
Yes. Now, you said the question of whether it's prosecutorial or oversight depends on the discussions. Am I correct?
Partly, yes, it does.
Now, he tells us on paragraph 80 that he had a meeting with the KZN Regional Court President, Mr. Nzimande, to discuss availability of regional court magistrates to hear the bail applications. Is that still part of oversight, or is that now prosecutorial?
This leans more on prosecutorial, because that's what prosecutors do now. You're discussing which presiding officer and all of that. Yeah, it's more prosecutorial, this one.
And would you also classify his involvement in your meeting with the judge president of KZN, where it was about arranging the judges to hear the matter? Would you also classify that as oversight or prosecutorial?
It's prosecutorial, is the same as this one.
Yes. Okay. Now,
Before you move on, Advocate Ntweni, can I, the situation that is described on paragraph 80, that on 19 June 2012, I had a meeting with the KZN Regional Court President. It differs to a certain extent with what happened when Advocate Chauke took you along to see the JP for the allocation of a judge outside the province.
Yes, ma'am.
And you've just said this situation described on paragraph 80 leans more on prosecutorial. While you say you didn't answer the same when in your situation when you went with him to see the KZN JP for the allocation, to request the allocation of a judge from outside the country. Would you care to enlighten us what is the difference?
Okay, thank you, ma'am. I remember being asked whether the request for section 111 for the consent of Advocate Johan Smith was prosecutorial or otherwise, not about going to meet, unless I'm mistaken, but not about going to meet the JP to request for a judge out of KZN. But, okay,
It was not asked.
yes,
Then I'm asking it now.
yes.
Was it prosecutorial or oversight
This
on
is,
the part of Advocate Chauke?
it was prosecutorial, the same with the judge president and the regional court president.
Can I proceed, Madam Jimmer? Now,
Perhaps whilst you are there, in these instances, when I look at the paragraphs that the council has referred to, 68, 79, and also in respect of that part where you indicated that Advocate Chauke approached you and you both approached the Judge President KZN.
Yes, Chair.
In those instances, the DPPs were present. For instance, as regards 79, that meeting, Advocate Mlocha was there as the DPP KZN
Acting DPP then, yes,
then.
true, Chair.
Do we know then who would have taken any decision there? Whatever decision that might have taken, the point is the DPP was there, isn't it?
Yes, the DPP was there.
In
and
your
she-
case, before you
Yes.
proceed, in your case, when you acquiesced to go and see the judge president,
Yes,
it was done on the basis that it was your jurisdiction, hence you were approached to accompany Advocate Chauke. Is my understanding correct?
yes, Chair.
Which means he wouldn't go alone to see the judge president KZN without the DPP.
Yes, Chair.
In respect of paragraph 79, the paragraph where Advocate Mlocha, 79,
Yes, Chair.
the same day, that is the 18th of June, 2012, where a meeting was held between Advocate Chauke and Advocate Mlocha, then ADPP KZN, to go and at the AJP of KZN. The
Yes,
point that
sure.
I'm trying to make there is that in those instances, Advocate Chauke was accompanied by either the acting DPP or the DPP.
Yes, Chair, as far as I'm aware, yes.
thank you, Madam Chair. Advocate Nugo, I just want us to go then further to whether, still within the context of prosecutorial or oversight, as to whose responsibility, which DPP would be responsible, is the submission of an application for authorization in terms of Section 24 of POCA. Is that part of oversight or is it prosecutorial in nature?
That is oversight because the decisions are taken by the prosecutors. The DPP does the administrative part because what the DPP does when you send an application or recommendation to the NDPP is mainly to sign. You sign the cover memo, the prosecution memorandum is made, compiled and signed by the prosecutors. You can sign it as well, but everything is done and decided upon, even what charges to charge who are done by the prosecutors. And the NDPP will just be sort of a conduit pipe to submit those to the NDPP.
DPP.
Yes, the DPP will be that kind of conduit pipe and also approved by signing that because they are from their own jurisdiction and out of protocol as well. The DPP must be the one submitting to the NDPP, not be submitted by those below the NDPP submitting to superiors. So that is purely administrative.
So whether she answers your question, Advocate Mchweni, will you please repeat that question?
Thank you, Madam Chair. Madam Noko, in fact, let's put it within so that I'm clear.
Yeah.
Can you please go to, I'm not sure which part of the LO is this, but 00666.
00666.
Now you're making our life, everybody's life difficult. You can't ask a question and say, I don't know which part of the LO is. What do you expect us to
Because Madam Ramakar, if I might explain, I've got it electronically. My bundles are not subdivided as the panels bundles, so I only have it as one complete document.
I understand that, but who's the navigator here?
I'm the captain, but unfortunately, I inherited this flight because already when I came in, the bundles had already been prepared.
Advocate Mchweni,
Madam,
I think that line is stale. It's very stale. That line of saying I only came in when the plane was already in the air. You came in here before Advocate Kowe, before Advocate Skosana SC. Let us try another line, and maybe let's not even try lines.
I retract that, Madam
Yeah,
Ramakar.
thank you.
I'm told it's LO3.
I beg your pardon?
I'm told it's LO3. It's LO3.
Okay.
And I undertake that from now on, I'll familiarize myself with which LO starts where and ends where.
Thank you very much. It will be very much appreciated.
Yes, thank you. You may proceed, Counsel.
The reason well, you'd see there, Advocate Nuku,
LO3 is what?
665.
661. The application, just tell us what it is, place it on record.
Yes, that's what I wanted to get there so that she knows.
Yes.
Advocate Nuku, that is an application that was submitted to Advocate Jiba on the 15th of August 2012 for authorization in terms of Section 2.4 of POCA. Do you see that?
I don't see it here. I don't know where it is. They give me a laptop. I don't know where it is.
It's also not fair to the witness, Advocate Mchweni. You know very well that this witness doesn't have the bundles. You should have made proper arrangement before we reconvened,
Okay, thank you.
given the fact that this is our witness, she is our witness, you are leading her at our instance, you should have gathered all this information beforehand.
I apologize.
And for you to ask the witness a question about something she doesn't have. It's
Apo-
very unfair.
I was under the impression that there was a witness bundle readily available.
I beg your pardon?
I was under the impression that there was a witness bundle that had been
Well, there
prepared.
can't be a witness bundle which you yourself must compile as the evidence leading team. Who would have prepared that bundle?
I take note of that. I'll make
Yes,
sure
sir.
that in future.
Yes, you cannot expect us to prepare bundles. You are an evidence leading team. You must prepare documents that you are presenting to us, and you should know them better than all of us.
I take note of that, Madam Chair. Do you have the document, Madam Noko?
Yes, I do.
That you would see it's an application for authorization in terms of section 4224 of POCA in relation to General Boysen and others.
Yes,
Do you see that?
I see that.
Now, the question I asked you was this submission of this application, because the authorization must be granted by the national director, am I correct?
Yes.
Now, the submission of this application or the making of this application, is that an oversight or is it the prosecutorial act?
This is oversight.
Now, can we just delve into that? If you look at paragraph 2, it says, I have perused the document and recommend the application. Do you see that?
Yes.
Is that the recommendation? It's something that would I be correct that it's part of what the NDPP would consider when applying his or her mind on the application as to what is the stance by the DPP?
Yes, it is. Those
Now-
are. Oh.
Now, would you still then maintain that where you make recommendations such as this, which are going to have a bearing on the decision, that still amounts to oversight?
That is still oversight, as I'm understanding.
Yes.
You're recommending after a prosecutorial decision has been taken. You are not taking a prosecutorial decision. You are recommending as a DPP and saying NDPP for your consideration.
Okay, thank you, ma'am. Now, I just want us to also consider this document. It appears.
Pardon, Counsel, let me understand this answer. As at August 15, 2012,
Yes, Chair.
when you wrote to Advocate Jiba applying for authorization, did the prosecutorial team, had there been a decision by the prosecutorial team as regards this matter?
I did not write this, Chair.
Oh, because I see
It-
Advocate Noko Mashilu. Who is Noko Mashilu?
It is me, Chair, but this is the document that the evidence leader from the Zondo Commission asked me about. And I said I had not seen it. I mean, that is not my signature. So I did not compile this.
Wait a minute. LO, these are legal opinions, this document, otherwise would have been from ZC. If it is the Zondo Commission document. LO would have been a document coming from legal opinions. Now, I don't understand why it would have been at the Zondo Commission. I'm getting even more confused now. But are you saying this is a document that was brought to our attention
Yes, Chair.
by the evidence leader at the Zondo Commission,
Yes, Chair.
and you then said, this is, I didn't append your signature to this document or something like that, because the signature is that of Advocate Jiba here.
Advocate Chauke.
Advocate Chauke.
Yes.
And then at the bottom there is written Advocate Nomkobo Jiba.
It's written my name, Chair.
Oh, there's a, okay, I'm on the second page. Oh, yeah. I'm sorry, I beg your pardon. I think that's where I got confused. Yes, thank you. And then your answer is that this is not your signature.
Yes, it is not.
Thank you.
It is what I refer to in paragraph 39 and 40 of my affidavit.
May I continue, Madam Chair?
Yes, sir.
In fact, this was the next question that I wanted to ask you. To say that as on the 15th of August 2012, you are already the acting DPP of KZN.
Yes, I was.
And I take it that on the 15th of August 2012, you were not indisposed, otherwise, you were not on leave or indisposed of health, whatever, for health reasons whatsoever. You were in the office.
I don't know whether I don't have my diaries. I don't have my schedule then, so I don't know what was happening really on the 15th of August 2012. It's a long time ago, so
Yes,
I don't know where I was.
I accept it.
Yeah.
But the document purports to come from your office. Do you see that?
Yes, in terms of having my letterhead and my name.
Yes.
Yes, it
And
says.
at the end there, it is signed, and there's no indication whether it is PP or is it your signature or not.
I don't know, but I see this arrow. I don't know. Sometimes other people, when they PP, they put this triangle arrow. I don't know if it's a PP or not.
Now, when this application was submitted, were you briefed about the that is going to be submitted?
I don't remember being briefed, but I had had a meeting with Advocate Chauke the previous week when we were going to meet the NDPP. I mean the acting judge president
Yes.
in Durban.
Now, and you were fully cooperating with Advocate Chauke at the time, whatever his requests were.
Yes.
Now, would I be correct that if this if there was an application of this nature, and which would have been issued on your letterhead, and as emanating from your office, you would have and ought to have been aware of it, that there was going to be this application submitted in my name?
I'm not clear on the
Sorry?
question.
You would have?
Yeah.
She would have been aware or ought to have been aware that there was going to be an application of this nature which was being submitted in her name.
Yeah, I guess so.
Yes. And you now told us that you saw this document for the first time during the Zondo Commission,
Yes.
and you were never told about it anywhere.
No, I wasn't.
Yes. The reason I will get to it, I just want to, because when one looks, there's a document which was an opinion by Dr. Broughton, where he, amongst others, says that apparently it was done with you, it was an arrangement between yourself and Advocate Chauke, but my junior is still finding the relevant portion of it. Now, I just want us then to move on to the memorandum that you received.
I understand the last point that you are putting to the witness, the arrangement between Dr. Broughton and the witness would have been with regard to what?
That from Dr. Broughton's opinion, it says that the submission of this application was it was in terms of an arrangement between Advocate Chauke and Advocate Noko. But they rely on an affidavit by Advocate Mosing. We're just finding the relevant part of that affidavit so that we can just get the question whether is that statement correct or not.
Yes.
Now, Advocate Noko, if we go to the document MN1,
Before, I'm sorry, before we pass that point. This point you are making with regard to the arrangement, would it appear in Dr. Broughton's memo?
yes, it appears in it appears in Dr. Broughton's opinion. In fact, at LO 00197.
LO3, is it 3?
Should be one, I think.
1.
And if I'm
00197.
and if I may read,
Before you read, let's just get our
the
volumes.
Silverton case number, paragraph 98.
Yes, paragraph.
He says at paragraph 77, he says, that's saying, however, in Advocate Mosing's affidavit in Silverton case number, it is noted as following.
Sorry, paragraph. Oh,
Paragraph 77.
Yes.
He quotes from what Advocate Mosing says in his affidavit, and at the bottom, towards the quotation, I think it's 6 or 7 lines, says, what may possibly explain the situation why the application emanated under cover of Advocate Chauke's office that it seems that Advocate Chauke and the DPP of KZN and Advocate Noko had arranged that such an arrangement in order to expedite the matter and avoid any possible delay on account of Advocate Noko being based in KZN. It seems that it was later considered prudent that Noko rather signed the document instead, but the application for centralization signed by Chauke had already been submitted by him as indicated above. And I think you would find that part, Advocate Mosing's, in his footnote, he refers to Advocate Mosing's affidavit at para 98.
Okay, should I respond?
Now, yes, now that we're there, as to whether was this an arrangement between yourself and Advocate Chauke, that he would sign documents because to avoid delays?
What you can see here, he says it seems. Like it's a.
No, I understand. I just want to get your view now. You're here. Was there such an arrangement or not?
I'm trying to answer, and I'm answering based on what Dr. Broughton is saying. He's deducing from, I don't know, from whatever he's deducing. But does he know, as a matter of fact, that that was the position? Because he says it seems as if there was an arrangement, it seems as if, to show that he is not sure about what he's saying. And he was not even part of the case.
Okay, now let me ask then.
Yeah.
Was there an arrangement between yourself and Advocate Chauke that he would sign documents on your behalf?
No, I didn't have that arrangement with Advocate Chauke in that respect.
Okay. Now, I just want us to deal with your support for the decision to institute the racketeering charges.
Yeah.
And the first time,
Before you leave that point, you were just looking at footnote 70 and refer us to paragraph 98 of the affidavit to the SCC.
it's a Silverton case number.
Point with regard to that?
No, I just wanted to say that's where Dr. Broughton gets what you would see there under paragraph 77. It's a quotation from that affidavit.
Yes. Yes.
So I was just trying to show where he gets that from.
Yes. Thank you.
Now, Advocate Nuko, would I be correct that the first time that you got a briefing into the Cato Mena case was when you received Annexure MN1?
Yes.
And that was on the 7th of August, 2012.
2012, yes.
And that was a summary, the summary that was given to you, it was given by Advocate Chauke.
Yes.
And now, he then, at paragraph 6, gives you a number of documents. Paragraph 6 of the internal memorandum, MN1, to Advocate Noko's affidavit, the annexes to Advocate Noko's affidavit. No. Advocate Chauke's memorandum, MN1, Annexure MN1, Madam Chair. I'm told it's it's MN 000. Triple 001. It's got 4 zeros. I'm not sure how to call quadruple zero. Yes, Madam Chair. It looks like it was cut.
Page
Yes.
MN.
Under paragraph 6, Madam Chair.
Of her affidavit.
I'm told it's 0003
Paragraph 6 of what?
of the memorandum from Advocate Chauke to Advocate Nuku. Annexure MN1. This is the one that my colleague said it was cut during the making of copies, and she ended up, I think she ended up a hard copy.
Yes. Yes, I see that.
Madam Nuku, under paragraph 6, that's where Advocate Chauke refers to the documents that were undercover the memorandum.
Yes, the memorandum, yeah, yes.
Yes. And she tells you that what was included was the indictment and then a copy of the memorandum to the NTPP for authorization of racketeering charges together with the draft authorization certificates, as well as a request for centralization and a copy of the consent letter which he received from Advocate Smith.
Yes.
Now, if I might then ask, in your evidence that you gave earlier, and I think it's in your memorandum to Advocate Batoyi and your colleagues, you go to a great length and you summarize each and every statement which informs your view why you believe that the institution of the racketeering charges was justified.
Yes.
Now, if I might ask, when did you for the first time get to come across these statements that you summarize herein?
It was when Advocate Matenjwa sent them to me.
Yes. So,
I think it was in 2014, 2015. It's in my affidavit. I'll quickly tell you. Okay, it's in page 10, paragraph 33, and annexure MN4. There's a covering letter from Advocate Matenjwa that enclosed the prosecution memorandum, the statements from witnesses. But the prosecution memorandum, I had it here from Advocate Chauke. Then in 2012, that was amended. It was different from the one I got in 2014. I think from Advocate Matenjwa.
The reason I'm asking this is because of the impression that is given by the application for authorization that was submitted under your name, where it says, I have perused the documents and recommend the application.
Okay.
It seeks to create an impression that you had applied your mind and you believe that there was a case for General Boysen and the team to answer. Do you agree with me?
Which memorandum are you talking about?
I think they took away the laptop now.
The one in 2012?
Yes.
I did not compile that. I was not in the case yet.
Yeah, but I'm just saying, I just want you to look at it, and that statement that says, because it's submitted under your name, and the impression it creates that it emanates from your office.
Yes,
But the truth-
I think in fairness,
Yeah.
he testified that when he was contacted about this document, if it is the same document,
Yeah. Oh,
he then answered that that was not even his signature. Am I correct?
That was not my signature.
So the fact that her name appears there and there's somebody who has signed there, and she said that this signature looks like the signature of Advocate Chauke. That's how I understood her evidence.
Okay, thank you, Madam Chair, for
And
that.
then paragraph 2 that you read, which says, I have perused the documents and recommend the application. That cannot be imputed to her because she says, I did not sign this document.
I just wanted to highlight the danger that is implied in that statement. It seeks to suggest that.
Yeah, well, it's a matter for argument.
Yeah.
The point is, the witness is testifying that it's not my signature.
Thank you, Madam Chair. May I just get one thing? Just want to get something. Now, Ms. Advocate Nuku, I just want us to zoom in into your support, the basis of your support for the decisions, for the decision that you say the institution was justified. Now, and in particular, the complaint here, it's in relation, I would zoom, there were about 16 accused in this matter. Am I correct?
I don't quite remember how many they were, but there was a number of them around that, yeah.
Yes, because if you look at the way the charge is even in your memo, if you look at the number of the accused, then the highest number is 16.
16, 18.
Respect of which
The Cato Manor charges.
the Katamana case.
Yes. Now, as a prosecutor, when you take a decision to prosecute, the primary consideration is prima facie case. Am I correct?
Yes.
That's the standard.
Correct.
In other words, is there a case for this person to answer to?
Yes.
And in light of the fact that there were 16 accused, you have to be satisfied that each one of them has a case to answer.
Yes.
Meaning that you must ask yourself, is there evidence that implicates or pinpoints this person to the commission of the offense?
Yes.
Yes. Now, let us just zoom into Major General Boyson.
Yeah.
And I can put a disclaimer right now that I do not hold a brief on behalf of Major General Boyson. I'm just simply asking this so that you get an opportunity to comment on this, so that whatever later on you're not criticized that you never dealt with these issues, and so that the inquiry can then be in a position to make an informed report.
Yeah.
Out of the 116 charges that are contained in the indictment, Major General Boyson is implicated in at least 7 of them. That would be 12, 11, 10, 9, 8, 2, and 1.
Please repeat yourself.
It's count 1,
1,
count 2, count 8, count 9, count 10, count 11, and count 12. Now, I just want us to, I don't want, given for the purpose of time, it would take us another 3 weeks for us just to analyze these charges and the evidence, and I don't want to do that. But I just want us to at least, let's look at count 1 and 2. which are the poker-related charges. The first one is in terms
Where
of
are they? Take us to those counts.
just they are in the indictment, Madam Chair.
Suppose your attorney is helping you there, see he's busy on the phone, that doesn't really matter. You're supposed to be helping your counsels, but you are busy on the phone there. We need your assistance as an instructing attorney.
Chair, if that will help, I know what he's talking about, and I can tell him which counts, which charges, and why those charges to shorten the whole thing.
You know, it is to our benefit.
Oh,
We need to know.
you.
We have to go through those documents ourselves
Yes, Chair.
because they are asking questions on them so that we can follow up.
Yes.
Madam Chair, I'm told it's Annexure MN004. MN4. Yes. You'd find them under paragraph 2, just at the end of paragraph 25. I'll just find
Us to
MN008.
you have to refer us to the bolded red.
Yes. It's MN00083. Just for the record, Advocate Nuko, charge 1. It says, you see under I there, it says list of proposed charges and accused involved in them. Count 1, contravention of section 21F, right, with section 22 of the prevention of the, I'm just rushing through them, but it's the enterprise management charge. And you see the accused there is accused 1, 6, and 9. And we know that General Boysen was accused number 1.
Yes.
Right? And then in account 2, it's the participation charge. I'd call it the participation charge, which Advocate Boysen is also implicated in that. And then if you turn over to is MN00085, it's murder. Count 8, it's murder. Read to section 5.1 of Act 105 of 1997.
Wait a minute, please. You have dealt with count 1 and 2. You are now dealing with the predicate offenses.
Yes, the predicate offences. I just wanted so that we were clear as to which charges Major General Boysen was charged in.
It is also important to highlight that count 1 and 2 fell under the proper racketeering charges.
Yes.
The subsequent ones fall under the predicate offenses.
Yes.
It does help.
Thank you, Madam
I'm
Chair.
sure you understand why.
I appreciate that, Madam Chair. And then under the predicate charges, Madam Noko, you see is implicated in count 8, which is murder, count 9, which is murder, and then unlawful possession of firearm, count 10, and then count 11, which is unlawful possession of ammunition, and then count 12, defeating or obstructing the course of justice. Unless I have missed others, those are the charges which were leveled against Major General Boysen.
Council? Proceed.
Now, in relation to the management charge, you would have read from the prosecution memorandum that the prosecution relied on the statement by, in fact, in relation to all to these charges, the poker charges, the prosecution relied on the statements by Colonel Aya, Mr. Dlondlo Mtiane, Bongani Mkize, I summarized them, Matonzi, and Cochrane and Danikas. Those are the documents that they relied on in order to prove the poker charges against Major General Boysen,
The racketeering.
the
charge.
racketeering charges.
Okay, I don't know if there are more statements because I didn't read all the statements. Those are some of those that I read, yes,
Yes.
but they also support those charges, yes.
Now, you'd agree, I just want to comment, you'd agree that the management of an enterprise basically means that one must have been overseeing this enterprise for the purpose of committing offenses. It's not just being the head of the unit. It must be aligned towards the purpose.
I beg your pardon?
Insofar as the management charge, I call it the management charge, that it is not enough for one to simply say he was in charge of the unit. His management must be channeled, must be directed, or with the purpose of that enterprise committing the offenses.
Yes, if circumstantially it's proven that that unit was sort of an enterprise based on the evidence that is here, the killing of people and all of that, then it shows it was an enterprise. And whoever is managing it is managing the enterprise because that unit is the one that has tended to be an enterprise.
Yes, but in this case, especially within SAPS, I just want to ask you this so that to get from you, did these issues come, did you consider them? Or do they have an impact or would they change your view on the existence of a prima facie case? The fact that within SAPS, there are units and those units are under commanders.
Yes, the same applies to Ketomena at
Yes.
head command.
So
yes.
would you say that just because General Boysen was in charge of the serious and violent crimes unit, that overcomes the hurdle of management of an enterprise?
I beg your pardon, Council. I did not understand her testimony to say that. If you look at those paragraphs that she was reading, she then dealt with those statements about management in terms of poker, and she then further, there was evidence by these witnesses. You can go back there.
We will come there, Madam Chair. I'll come to those witnesses.
Okay.
Yes. Now, in
But
relation...
what I would like you to do, don't put it as if the reliance was only on the fact that he was a manager. Maybe you can couple it together so that it is conclusive. Then we know what he's answering.
Yes. Thank you, Madam Chair. Now, if one reads the statement by Colonel Ayer, all that Colonel, if you understand the theme, Colonel Ayer seems to complain about being overthrown by General Boysen, who basically he complains about being undermined by General Boysen because he says, in fact, this unit ought to have resorted under him, but they disregarded him and then they were reported directly to Boysen. Did you understand the statement to mean that?
Yes, he mentions that, yes.
Yes. And then we then come to the statement of Danikas.
Okay.
Danikas refers to a number of incidents that happened at least pre
Council,
the
I'm sorry to interrupt you. The previous statement as regards is that Colonel Aya, you are making it to buttress the point that actually the person who ought to have been a manager was him and not Boyce.
yes, and that's the essence of the complaint
Yes.
in the statement. And I just want, basically, in fact, you're reminding me, just that, does it, in her view, but support the contention that he was a manager or not of an enterprise?
I'm sorry, Madam Chair. Colonel Aya gave 3 statements. They say many things. The witnesses not being correctly put to say that all that he complains about is X. That amounts to misleading a witness. If my learned friend wishes to put the witnesses, the statements of Colonel Aya, they must put all of the 3 statements and go through them.
Thank you, Madam Chair. Just for Advocate Muretobi's comfort, I did not intend misleading the question. To extent that it came across as if I'm seeking to mislead, that was never the intention.
Yes, ma'am.
I just want to comment that I think it is common cause that whenever there's reference to documents, those documents must be available. Okay, can we just subscribe to that and do that, please? Otherwise, there'll be this toing and froing. If you want to make reference to the statement, you make reference to the statement and say the essence of this paragraph in particular, or the essence of the entire statement. It will help us. All of us will be on the same page through and through. Thank you. Thank you, Chair.
Thank you, Madam Chair. Madam Ramachar.
Now, you drew our attention to the statement by Colonel Aya, where he complained apparently that he was overlooked. I'm not quoting him verbatim, but instead of reporting to him, they reported to Major General Boyson. Is that correct?
Yes, that's the first statement. I'm just trying to get to.
This is his saying so.
Yes, I'll just.
Colonel Aya.
That's the theme of the statement.
Yes.
I'll just try and get the next witness. They are in fact in Advocate Batoy's.
And also, as you search, if you can tell us, what do you seek to establish by this question?
We just want to point out these aspects to her as to whether, in light of those, does she still maintain her view that the prosecution was justified? That's just we just want to clarify whether did these aspects cross her mind? Did she pay attention to them? That's all that we're seeking to do, Madam Chair.
By virtue only of a statement by a witness who says, I was actually the boss, but I was overlooked, and instead of them reporting to me, they reported it to Major General Boyson. Could it ever mean that the prosecution was then wrong or improper, just based on that statement alone?
No, Madam Chair. Well, I think, Madam Chair, in view of that, then I think that just.
Yes, but I'm trying to understand. We know on the evidence that we have, at least of several witnesses, is that which up to now has not been refuted, that seemingly General Boyson's played a critical part, be it managerial or otherwise. If it is managerial, that still has to be established under the POCA provisions, Section 2. count 1 and 2. That is where this feature of him having played a managerial aspect may kick in when you look at the concept enterprise. Are you taking issues with those statements that are made by witnesses that advocate, I beg your pardon, Major General Boysons played those parts or those roles?
No, Madam Chair, like I tell you, I don't hold a brief for Major General Poisons for him to come and dispute that.
Yes, would you please repeat that statement in regard to, as regards Colonel Ayer then? Because I'm trying to understand the point
And
that
I
you
think,
are making
well,
there.
what we just wanted to just to say, whether the theme of the statements would they change them? That in light of the themes of the statements, does she still maintain a view? But in light of the fact that those statements have not been disputed, and will not take it further, Madam Chair. And I think on that note, that brings to an end my clarification. Those are the issues that I just wanted clarity on.
In any case, your witness, Colonel Ayer, apparently you're going to call him. Is that Colonel Ayer?
No, it's Poison, I think that's going to be called.
We'll look into that later, but it appears that this witness, if my understanding is correct, on the list of witnesses, because he made several statements, this,
Yes.
This officer. I'm not sure whether you came at the time when you had dealt with the NJs. Those statements, NJ3, NJ4, NJ2, they are attached to Advocate Batoy's affidavit, supplementary affidavit.
Yes, I'm aware of that.
If you can look at the supplementary affidavit and look at those annexes, you'll find those statements there.
Now, I've taken note of that, Madam Chair, but in
Yes.
view of the fact that of the regard that these statements have not been refuted, I don't think that we've got any reason to take them up with the witness.
Yes, I'm
And
not
that-
sure how the witness can help in that regard because she's not a deponent of those
Yes.
statements.
So then I think that would that brings about the end of my clarification, Madam Chair.
Chair, through you, much as Advocate Msweni would like to part with us on this point, it does help just to understand even what the thinking and the understanding of the evidence team is about these statements. It is correct that the statement, we have more than one statement of a general or Mr. Ayer. Is it correct?
Yes, Madam.
Now, when you say that the essence of his statement,
That was the first statement, Madam.
yes, Ayer, you're talking about Ayer. Oh, the essence of the first statement,
Yes,
not the essence
of the
his
entire
statements.
statement. No.
Or now I understand. Maybe I was not listening properly.
Yes.
That's fine. There's no need to ask you further questions.
Thank you. Chair. Thank you for the
Thank you.
indulgence. I've got no further questions.
Clear my mind, Council, as regards the counts. As regards the counts, I want to clear my mind, particularly in relation to the racketeering charges, because most of those questions you raised seem to fall under the poker racketeering, counts 1 and 2.
Yes.
That might take us to the argument point on the law. So I was just wondering why you go that route, because much could be said about those issues. But if a need arises before the witness retires, I'm sure you can come back and re-examine
Thank you, Madam Chair.
on these very issues, because you referred us to documents. I don't think you looked at some of them. In re-examination, if some of the matters might arise in cross-examination, you will re-examine on them.
Thank you, Madam Chair.
Anything else from the evidence leading team?
Chair, just have to pass the message that our leader, Advocate Kosana, has a pupil lecture to give at 4.
I beg your pardon?
Advocate Kosana had requested to be excused as he needs to give a lecture to the pupils at 4. I'm not sure whether we'll still continue beyond this or not, but he had asked that he be excused so that he can attend to provide the lecture. But Advocate Ko and I are more than capable of
I
holding
thought
the
this
fort.
is your gentlemen. For anybody to leave this inquiry to go and lecture students, this is very important. Advocate Kosana, with due respect to you.
Yes, so sorry, Madam Chair. I had been asked by our bar to give the lecture, but actually it's not actually 4 o'clock, it's about 5, Madam Chair. I had put it after hours, assuming that we'd have adjourned around 4:30 or so, then I could rush down to chambers. But I didn't anticipate that would go beyond. And I see now that today it might be that case. I just wanted to
Yes.
ask for that excuse. Yes.
You'll remember in chambers I mentioned that we may have to run late, until late, even tomorrow, because we have lost so much time. And I think all of us must prioritize the matters of this inquiry. I was actually, but I'll ask you when we finish with my colleagues as to whether Advocate Mkaitobi starts or starts tomorrow. Then I will ask you something. Let me just be clear. So you are done with your clarifying questions?
Yes, Madam Chair.
Thank you, Counsel. It's 4 o'clock, Advocate Mkaitobi. If we can make progress maybe with the preliminaries, if you
Yes.
like.
Yes, I'm happy to start, Madam Chair.
Okay. We are agreed that time is of essence, and we will use whatever time, even if it is an hour, to make a start, because this witness is available only until tomorrow. She's practicing, and she has left her practice to come and assist this inquiry. She's not been paid for coming here to assist this inquiry, so we should utilize this time to finish her evidence and to excuse her. Then we can deal with other matters. I'm told that tomorrow afternoon you have to fly back or drive elsewhere, Menoko.
Yes, Chair, but just to clarify, I'm not practicing. I'm busy with other things.
Oh,
Yes.
you are busy with some. You are
With
no
other
longer
things. I'm not
under the
practicing.
NPA though.
Yes, I'm not,
You-
but I'm not practicing yet. Yeah.
Well,
But
that's,
I'm busy with
that's
my
that's
things.
business.
Yes, it is. I'm busy with other things.
Yes. Well, I think we just appreciate the fact that you made time to come
Chair.
to testify.
Yes, Chair.
And you have indicated that you'll be available for the 3 days,
Yes, Chair.
yesterday, today, and tomorrow.
Yes, Chair.
Therefore, let us use whatever time that we have. And Advocate Kosana, I plead with you that you request the bar that you are on a brief here and this matter is running, because it will not be fair to leave your juniors on their own, and Advocate Mutlamonyani is not here, and now you are leaving 2 SCs, leaving the juniors. I think it is important that one of the leaders must be here, at least as far as I'm concerned. So I request that if we go until, say, about 5:30, just explain to them that we may be late, because I consider that this is very important to finalize. The lecturing can be postponed to another day, and your attorney is sitting right next to you. I'm sure he shares my sentiments. That is Melimet. You are an instructing attorney here.
Yes, Chair.
You agree?
To the release. No, I was not approached, Chair, so
You are taken by surprise.
yes, Chair.
I can't. Councillor, you cannot take your attorney by surprise. He's the man who's paying your fees, and please involve him. And I'm sure all of us understand why we have to prioritize this matter to whatever cost and to finish it on time. I'm going to request that we take a comfort break, those who want to go to the clinic, and we come back and start with cross-examination.
How long is the comfort break, Madam Chair?
Let's take 10 minutes. 10 minutes, we can stretch our feet, our legs, and come back. Thank you. We'll adjourn for 10 minutes, let's say until 4:05. We adjourn. Good afternoon again, everyone. Good afternoon, Me Nogu. Ndate Chauke, good afternoon. Advocate Ukaitobi and the evidence leading team, we propose to sit until 5:30.
Thank you, Madam Chair.
Thank you. You may begin.
Yes, Madam Chair, I've been asked by my colleagues in the light of the air conditioner that's apparently stopped working, whether they can take off their jackets.
I see the witness is smiling. Are you also suffering there?
No, actually, I feel bad because I'm the one who asked them to reduce it, but it was because of my throat. I was getting blocked, but they can just switch it on and not too high.
Yes, I think it's all hot for all of us.
Yes, it is.
You can take off your jackets. Madam Chair. You must thank Advocate Kaitobi for raising this. Feel free to take off your jackets. It is. You'll have to make an application every day. No, sir. Those who feel the heat, feel free to take off your jackets. Thank you, Council.
Thank you, Madam Chair. Advocate Nogo, can I just start with this question of the authority of Advocate Chauke in relation to so-called prosecutorial decisions in KZN during the period before you arrived and took over?
Yes.
Now, when I cross-examined Advocate Batohi, and I asked her whether these charges relate to the predicate offences, the charges against Mr. Chauke, or relate to racketeering. And my recollection is that she seems to have confirmed that they are confined to racketeering and only relate to predicate offences as part of racketeering.
Okay.
Yes, not that you should, but I'm just putting that to you.
Yes.
Now, if it is correct that this is a case about racketeering, which jurisdiction does racketeering fall under?
You mean in terms of who can institute such?
Yes, precisely.
It falls under the NDPP only.
Yes. Is there any DPP that has jurisdiction over racketeering?
No, only the NDPP.
Yes. Now, this is for me the one thing I can't really understand with the theory of the evidence leaders about this case. This case is about racketeering. Racketeering is a national jurisdiction. Only the NDPP can make decisions, correct?
Correct, that's my understanding. Even I think the terms of reference say so.
Yes. Now, if the NDPP then says to Advocate Noko from the Northwest, I've got a racketeering case in Gauteng,
Yes.
and I'm asking you to go and coordinate on my behalf. What exactly is the problem?
I don't see any problem because the NDPP oversees the NPA throughout the country.
Yes.
He or she can delegate, go do this, do this, do this, and especially racketeering, resulting under NDPP.
Yes.
He or she is the one who can say, go do this on their behalf.
Yes. Because it seems to me that the alternative option is for the NDPP personally to drive to KZN on a racketeering case and to coordinate it herself.
It seems so, yes.
Yes. But would that be a rational thing?
No, that's not how it works.
Yes.
He or she has to send someone to do that, and the next highest person to send will be a DPP.
Yes. Well, it could be one of the deputy national directors.
Those are mostly in the office. They could be that as well. Maybe let me not go there.
Yes. But the big point really is this. This is a case about national jurisdiction. It's not a case confined to a province.
Yes, it is national. Yeah.
Yes. And so when the national director says, I'm sending Mr. Chauke here, that's perfectly within her right because this is a charge that is falling exclusively under her office.
That's precisely why I didn't see anything wrong with that when Advocate Chauke was in the Ketomena case.
And similarly, the national director could say, Advocate Noko, this is from your province. I want you to coordinate it on my behalf. Not because you have jurisdiction, because she has exclusive jurisdiction, but because she has chosen.
Yes.
Yes. Thank you very much. The other thing I don't really understand with the theory of the case of the evidence leaders is the inconsistency within the NPA itself. I want to show you two documents which will illustrate this inconsistency. The first is the report by Advocate de Kock, which you will find at SB 3, but I want you to refer to SB 12. Somebody will open it for you.
Okay.
I'll just use the SB. All right. I'm told, Advocate Noko, that you don't have Ms. Patohi's affidavit. It looks like, Madam Chair, Advocate Patohi took the witness bundle, or someone in her office took it from where it was.
Oh.
Yes.
It's the same thing. It's the same.
Right. Well, perhaps what I should ask you is just to go to the last page, page 96 of that report. It is SB 12/283.
Yes, I see it.
Yes, I'm advised that the bundle that was provided was taken by the NPA when they left with Advocate Patohi. So whenever you refer to documents, we might share here and then borrow the witness our bundle.
Yes.
If it is not marked. A lot of scribbling in these documents.
Yes, thank
If
you.
you have a clean document, you can also assist there.
Yes, we do have some documents, but I think the witness has received the document I'm referring to. So-
Yes, I will also ask my researcher to assist. Officer, you can take the seat at the back. My researcher will sit next to the witness so that when a need arises, he can quickly go into the computer and open that document. Thank you, Dr. Marani. Thank you, Council.
Thank you, Madam Chair. So what you will have page 96 at the bottom, and then KVR 60 in the top right.
Yes, I can
Yes.
see that.
Yes. Now, this document is 96 pages long.
Yes.
It is a decision made by 4 employees, allegedly by 4 employees of the NPA, to recommend to Advocate Patohi the withdrawal of the charges. Now,
Yes.
Advocate Patohi says that a decision to withdraw, to recommend a withdrawal, is a prosecutorial decision.
Yes.
That is her thesis.
Yes.
Now, these 4 employees have allegedly made a decision to recommend a withdrawal, correct?
Yes.
Yes. Now, if you look at the first person there, this is all coming from the Ketomano prosecution in KwaZulu-Natal.
Yes.
The first person there, where does he come from?
Advocate R.J. Rodney de Kock was a director of public prosecutions for Western Cape, Cape Town.
Anything to do with KwaZulu-Natal?
Nothing at all.
Yes. Now, the second person there, which is Advocate I. Tenga, where does she come from?
Advocate Ivy Tenga is the director of public prosecutions in Limpopo.
Anything to do with KwaZulu-Natal?
Nothing at all.
Yes. The third person there is Advocate S. Riley. Who is she and where does she come from?
She is the Deputy Director of Public Prosecutions, deputy to the first one, late Advocate Rodney de Kock, in Cape Town,
in the Western Cape.
Western Cape, yes.
Any relationship with KwaZulu-Natal?
Nothing at all.
And then the last one is Advocate Mamabolo.
Yes, the late Advocate Mama Bolo, I think it's the one. Senior State Advocate, Specialized Commercial Crime Unit in Pretoria, Gauteng.
Anything to do with KwaZulu-Natal?
Nothing at all.
Yes. Now, this is the inconsistency I'm referring to. In this case, when they were deciding to withdraw the charges,
Yes,
the decision to recommend the withdrawal was made by at least 2 DPPs from outside of KwaZulu-Natal
yes,
on the instruction of Advocate Batohi.
yes,
The same person who is accusing Advocate Chauke of exceeding his jurisdiction.
yes,
But she herself has instructed 2 prosecutors to exceed their jurisdiction.
yes.
Yes.
And just to clarify on that for the panel as well, I was once tasked by Advocate Abrams when he was still the NDPP to come from KwaZulu-Natal as a DPP to come and do some project on investigations of some prosecutors here in Pretoria.
When
And-
you were
and-
the DPP,
When I was a DPP, still a DPP in KZN.
and there was a DPP in Pretoria.
Yes,
Yes.
there was a DPP in Pretoria.
Yes. So here we have 3 national directors that have done exactly the same thing. Advocate Jiba, who instructed Advocate Chauke to assist on a racketeering case in KZN.
Yes,
We have Advocate Batohi, who instructed Advocate de Kock and Advocate Tenga to assist on a racketeering charge in KZN.
yes,
And then we have Advocate Sean Abrahams, who instructed you to assist on a matter in Pretoria.
and I came with a team of prosecutors from KZN. Yes.
Yes. Now, then on this theme of inconsistency, there is another decision. If you go to B9, which is the so-called Boyson Bundle, B9 BO2199. My attorney will assist. Can you just open it? B9 BO2199. Do you have it? Oh no, they're still looking for it, sorry. 199, Madam Mabach.
Found it, Mr. Morani. It will be the Boyson's Bundle 9 of 11. And the page is B. The page is B.
BO2199, Madam Chair.
Yes, thank you.
Do you have it, Advocate Noko?
Yes, B02199. Yes.
Yes. Now, that is a decision, if you look at it, addressed to Advocate Abrahams about Silverton, case 62210 of 2014.
Yes.
Now, that case, you can correct me if I'm wrong, was a purported prosecution against Advocate Jiba
Yes.
for instituting these charges against Major General Boyson.
Yes.
Yes. Now, it is a case arising from Pretoria, which is where Advocate Jiba worked, correct?
Yes.
That's why it's called Silverton.
Silverton. Yes.
Now, who took the decision to decline to prosecute?
It's Advocate Ivy Tenga, who is the Director of Public Prosecutions when she was still a DPP in the Northern Cape.
Yes. Now, I would suggest to you that it is pervasive practice in the NPA that DPPs, I'm not talking about people below DPPs, that DPPs are instructed to play roles across the provinces
Yes.
regularly.
Yes.
Yes. Now, in your own experience, how long have you been in the NPA? Thank you for this document. It can be, yes. How long have you been in the NPA before
Since-
you?
Since the inception of the NPA.
That's what, 1995.
Is it?
Oh, could
Around
be.
there. Yes.
1998.
Yes, around there.
All right,
yes.
but it's a substantial period.
Yeah, because I was with the Department of Justice first. And then when the NPA got to be established, we were already there in the system.
Yes. I mean, have you ever heard of a case in your entire experience of a DPP being charged with misconduct for carrying out an instruction of the national director to perform functions in a different province to the one they are appointed at?
Never before.
Yes. Now, the document I referred to earlier, which is the De Kock bundle. I want to just come back to that now. Yes. Now, you will recall that I had put to you something that is common cause, that this document formed the basis for the withdrawal of the charges against the Cato Minor accused.
Yes.
That was repeated here ad nauseum by Advocate Batohi.
So this is the De Kock memorandum.
Yes, but this was the basis for the withdrawal of these charges.
Yes.
Yes. Now, I just want you to clarify something in your evidence because Advocate Chauke has a different recollection to yours.
Okay.
Apparently, on the day Advocate Batohi decided to withdraw the charges, she called a meeting of yourself, Advocate Chauke attended, and the prosecution team to announce her decision, but she did not share this document with you. Well, apparently you were not physically there, you were on the phone.
Yes, I wanted to clarify that I was not present, but I think that meeting took place, yes.
You confirmed that it took place?
Yes.
Yes. Now, in that meeting, there was a specific complaint by those that were invited
Yes.
that if she has already made a decision to withdraw the charges, she is wasting their time by inviting them to inform them of a decision without inviting their representations.
Yes.
Did you contribute in that discussion?
I don't remember what my contribution was, but I shared the same sentiment.
Yes.
I don't know exactly what I said, really. But even now, even when you've seen my affidavit, I'm complaining that no reports were sought from us. Our views were not sought. So I may have said that also. I don't remember what my contribution was, but that is my standpoint.
Yes. Now, the other thing about this document is I want to just confirm with you. Were you given two of these?
Yes.
Yes, all right. There's something I want to just check with you because it's confused me a lot when I've been preparing. But I need my attorneys to provide the panel with this version of the report.
Okay.
So if you've got the two versions in front of you,
Yes.
Have you provided some copies to the evidence leading team?
they should be given. Now, these documents, on the face of it, look the same, correct?
Yes.
Looks like it's the Cook report. Except that when you go to the last page, that page 96, just open both of them. Now, you will see the one that has KVR is signed by Mr. de Kock. Can you see that?
Yes, I can see
But
that.
the other one is signed by Mr. de Kock and Mr. Mamabolo.
Yes.
I mean, do you know how this happened?
I don't know. I was not even given a copy, really.
Yes.
I don't know how it happened like that.
But the other problem is that at least two of the authors have not signed in both reports,
Yes.
Advocate Tenga and Advocate Riley.
Yes.
But it's all presented as if it is a common report of the panel as a whole.
Yes.
But we are not told why two members of the panel have not signed.
Yes.
And we are not told why one version is missing a signature
Yes.
of Mr. Mamabolo.
Yes.
Now, this document that is KVR 60
Yes.
is attached to the statement of Advocate Batohi in these proceedings.
Okay.
Yes. And then for a full document in these proceedings.
Okay.
So both of them come from the NPA,
But different.
but they are different.
Okay.
Now, I take it you can't really explain.
I don't know really. Yeah.
Yes. But when I also look at the style of writing in the content of the report,
Yes.
I find that there are some differences.
Is it? Okay.
Yes. So it would.
Style of writing, are you referring to the font?
Yes, I can take an example. If you go to paragraph 30, just as an example, and you open the report and you see paragraph 30 on both.
Okay.
So you see in the report that's signed by two, paragraph 30, firstly, is in inverted commas and is italicized. And in the other one, there are no inverted commas and it's not italicized.
Yes, I can see that.
Now, when I was preparing, I came across 7 instances like this. And I thought maybe you would know because you come from inside.
I come from inside, but I was not part of this report, and
Yes.
I was not even given the report.
Yes,
Neither was I given to compare.
Yes, you know, Advocate Riley is coming apparently. So maybe I should reserve these questions for her.
Yes, especially that she was part of the DIGOG panel, yes.
There's discrepancies.
Yes.
Yes. Now, but I can ask
I
you.
suppose that even though you were not there, on the face of this document,
Yes, yeah.
the parts that have been drawn to our attention, it is very clear that there are differences.
Yes, I agreed to that,
Yes.
to paragraph 30, yes.
There must have been some editing
Yes,
later
yes,
or after,
yes,
either before or after.
yes.
The
But
first
there
one.
was, yes. It appears so, yes.
So thank you, Madam Chair. Because if you accept.
Sorry to interrupt. Just for the sake of our, I think we are being provided with one document here. Only the one with the signature of and I mean, this is pointed out to us now.
You may please put on your mic.
So they want
You may assist the research on Council, which version do you have?
What I'm saying is that we have just been provided with a version which has the signature of Advocate Tikop.
The one with
That's all.
case
I
60?
think, yeah, while I was raising this, now we have been given the second one.
Yes.
I just wanted to say
You have both of them now.
confirm that. Thank you.
No, we apologize to Mr. Skosan. We thought we had given them two different versions, but we've given them one.
And if you look at the last part was in relation to paragraph 30 of both. You will observe the obvious difference in relation to paragraph 30, the opening sentence. The quotation marks in one and the font is very different. One is with italics, quotation marks. The other one is in normal font without quotation marks. You see that?
Yes, thank you. As I say to the witness, I've identified 6 additional stylistic changes, which also made me to come to the conclusion that perhaps the document with one signature is then the final version, which makes the matters worse. Why the other 3 have not signed.
Yes, I don't know why they didn't sign.
Yes. Yes. Now, my Leonard Jr. points out something I almost overlooked, which is in LO4. Page LO01044.
That will be LO1.
LO4.
LO4.
I'm told, Madam Chair. So if you go to LO01044,
Please repeat the page, Council.
the page I would like the witness to look at is LO01044.
044. Is volume 4?
LO4,
Yes.
according to us. And then the document starts at LO01039.
No, I think volume 4 starts elsewhere with the 00880. That's the volume 4.
Yes, my colleague says the document that we are looking for, it starts at 039, LO01039.
It should be volume 1.
Was just found it. He's finding it.
Say 01039.
01039, yes, yes.
That would
1039.
be- yeah, that would be
Yes,
LO4,
1039.
yeah.
Yes, correct. That's LO4.
Thank you, Council.
Thank you. And Advocate Noga, I want to go to that section that says evaluation, which is under E, so that you will find at paragraph 11 of that document.
Paragraph 11 under evaluation,
Under
I see
evaluation.
it. Yes.
Got it.
Yes.
Now, if you look at the opening sentence under evaluation,
Yes.
this is Advocate de Kock telling Advocate Batoyi
Okay.
that there is no basis to charge Mr. Chauke for exceeding jurisdiction. And he says, it is respectfully submitted that Advocate Chauke has overall provided a satisfactory response to the allegations leveled against him for the employer not to proceed with a formal inquiry into his conduct or fitness to hold office in terms of the NPA Act. You see that sentence?
Yes. I see
And if
that.
you go to the last sentence under paragraph 11.1, the very
Yes.
last sentence in that page,
I see it. Yeah.
it says, it is also important to take note that Chauke got involved in a KZN matter at the instance of his senior and supervisor, Advocate Jiba, and therefore the employer. Would that be consistent with what you've been saying?
That's what I've been saying. I was not even aware of this. That's what I've been saying. Yes.
So your view is also shared by Mr. de Kock.
Yes.
Then it gets even better, because if you go to the following page in the opening sentence,
Yes.
he says, as a matter of practice and the law, NDPPs have in the past assigned prosecutors and even DPPs in matters that fell outside their jurisdiction for one reason or the other.
True. That has been the position.
Yes. So in other words, this is not just about people below the DPP. I mean, we've gone through these instances I've shown you.
Yes.
We've also now looked at the statement by Mr. de Kock. We've also now got your evidence
Yes.
that this is a pervasive practice within the NPA.
Yes.
Yes. Now, I wanted to move slightly forward when I brought these two reports to
Yes.
show you that we don't actually understand whether these reports reflected a consensus or just the view of Mr. de Kock,
Yes.
because the other persons have not signed.
Signed. Yes.
And we are still going to try and speak to the other. Well, there are only two surviving authors of these reports.
Yes.
One is Advocate Riley,
Yes.
that we were promised will be brought here.
Yes.
The other is Advocate Tenga.
Yes.
Where is Advocate Tenga right now?
She's still a DPP in Limpopo
Okay, so he's still within the
within the NPA.
service.
Yes.
Okay, that's fine. Thank you very much. Now, what I am interested in here is the process. You remember that you mentioned the issue of the process,
Okay. Yes.
that you heard about the report in the media, you
Yes.
then looked for it, and then you found it and you read it.
Yes.
Yes. Now, the decision to review a prosecution is a constitutional decision.
It is in terms of section 179. Yes. I think subsection D or something.
Okay, do you have the Constitution in front of you?
Yes. I do.
Can I ask you to open it?
Yes, I have it.
So if you go to that section 179 you are mentioning, you said subsection D, but I think you mean subsection 5.
Oh, okay.
Yes. Subsection D.
Oh, yes. I remember the D.
Yes. all right.
Yes.
Subsection 5, paragraph D.
Yes.
Can you just read what it says?
Um,
Starting with the National Director of Public Prosecutions.
or the whole 5D, from 5. Okay.
Yes.
The National Director of Public Prosecutions, subsection A, must determine with the concurrence of the cabinet member responsible.
No, I just want D.
Oh, D.
Yeah.
5D, okay. The National Director of Public Prosecutions may review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified by the National Director of Public Prosecutions from the following. 1, the accused. 2, the complainant. 3, any other person or party whom the national director considers to be relevant.
Now, thank you. Now, it is common cause here that Advocate Batoyi consulted only the panel that she set up. Is the panel
Yes.
mentioned in section 179 5D?
There's no panel mentioned in the constitution.
It is also common cause that Advocate Batoyi did not consult. Well, we know that she consulted one accused person because she invited that accused person to her office shortly after she became the NDPP in February of 2019. Major General Boyce through his attorneys.
Oh, I heard about that, yes.
Yes. But the other accused, were they consulted?
I don't know.
Yes. And then the complainants?
I don't think so.
Yes. And then most critically is the prosecution team, of which you would be aware.
Yeah, I was not consulted. I know the prosecution team told me they were not consulted as well, and Advocate Chauke as well was not, so we were not.
Yes.
I beg your pardon, Counsel. Counsel, why do you say you don't think that the complainant could have been consulted with? You said you don't think so.
I think, I don't know, I don't have proof, but then I think I heard that the complainants, some witnesses were not happy with the decision to withdraw the case. For example, even Mr. Danikas was not happy with the decision to withdraw the case. So it doesn't seem that witnesses were consulted, and neither have I seen anything to that effect in the DGOG report to say at least the witnesses or the complainants or any other person except relying on what the DGOG report said were consulted. Thank you. Thank you, Chair.
Yes. Now, you see, the situation we have right now, Advocate Noko, is an extraordinary one.
Yes.
It looks like the NDPP has violated the Constitution by withdrawing a decision outside, a decision to prosecute, outside of the parameters of Section 179 5D.
Yes, it appears so.
Yes. And if you have the Constitution, can I ask you to look at Section 2?
Yes, I'm
Yes.
sure.
Now, what does that section say about a decision that is inconsistent with the Constitution?
About the supremacy of the Constitution.
Yes, just read that section. Yes.
Okay. This Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled.
Yes. Now, if Advocate Batoyi has withdrawn a criminal prosecution contrary to the Constitution, would that decision be invalid?
Yes, and unconstitutional as well.
Yes. Now, this is what I refer to the extraordinary situation,
Yes.
that a person who is meant to uphold the Constitution has violated it.
Yes, clearly.
Yes. Now, I want to also then look at this this memorandum, the internal memorandum to withdraw these charges.
Okay.
So you said something interesting earlier in your main evidence
Okay.
when you said that contrary to what you did in the report,
Yes.
they did not go through the dockets
Yes.
and analyze the evidence inside of the dockets.
Yes.
Now, there are some portions of the report that refer to the dockets, some dockets.
Okay.
So if you can open the report, Yes. It is at paragraph 77. I'm
Yes.
told, Madam Chair, it's SB 3157.
Three.
157. It's page 157, yes.
Please bear with us.
Yes, thank you, Madam Chair. Yes, yes, 157. Yes, thank you. So if you go to paragraph 77, under the heading C, the evaluation of evidence contained in the dockets,
Yes, I see that.
and then you,
Maybe you can just clarify to the witness that this is a document that was attached to the founding statement of
Yeah.
Advocate Batoyi.
yes, thank you, Madam Chair. So this document is annexed SB3 to the witness statement of Advocate Batoyi before this inquiry.
Okay.
Yes. And if you go to heading C from paragraph 77, they purport to provide an analysis of the dockets.
I can see that.
And if you turn the page at paragraph 82, well, there's table A and table B,
Yes.
which refers to section 21F and 21E.
Yes.
And we know 21F is the management
Yes.
and 21E is the participation
Yes.
in the affairs of the enterprise.
Yes.
Yes. But the statement I was going to refer you to, just to make sure that you are not criticized later for being untruthful, is paragraph 82, which says, we also read and analyzed the evidence in the 23 dockets that the prosecution team in their PowerPoint presentation to Abrams said implicated the accused in the racketeering activities. You see that?
Yes, I can see
So
that.
they at least purported to have read the dockets.
Oh,
Yes.
I see that.
And then
Thank you.
if you go to page 27 of that document, just above paragraph 84,
Yes.
there are dockets for 2008. They are listed.
Okay. Can see them.
Yes. Now, the problem, which is probably what you were referring to, is that there is no full analysis on a case-by-case basis of the contents of the dockets, which is
Yes.
what you did.
Yes, that's what I meant, yes.
Yes, that's it. And in addition to that, there are at least 12 dockets that are not referenced at all in the report.
Okay, yes.
In fact, I can read them to you to make your evidence complete. Yes. Now, The dockets that are mentioned by name and are not referenced at all
Okay.
are the following dockets. 18 October 2008, Umkomas, CAS 253, stroke 1, 0 stroke 2008. The deceased is Mduduzi Mkhize.
Okay.
It's analyzed in your report, and there's no mention of it in the DECOC report.
Okay.
Madam Chair, if we can assist Advocate Mugaitobi, it looks like on page 27, the case is referring to is listed as number 7.
It will be helpful if you speak up, please.
I'm saying that if we can just assist Advocate Mugaitobi, the Umkomas case is referring to 235 October 08, appears on page 27 of the report at under number 7 on the 2008 dockets. I'm not sure if maybe that was a mistake on his part.
No.
Yes.
SB 3160, the table at paragraph 7.
Yes, because unless I misheard him when he said 235 of October 08.
No, you see, this is the problem. This is exactly what we are saying. They've mentioned the name of the docket. There is not a single analysis, not a single line that talks about the contents of the dockets. That's the point I'm putting to you,
Yes.
Advocate Nuku.
Okay. I know
Yes. There are 12 of them like this.
that. Yeah.
You get a point, Council?
We thought he said they were not mentioned in the report, but if we did not understand him correctly, we apologize, Chair. We now get his point when he says there's nothing said about them other than the lip service.
My understanding of Advocate Nkwentobi's line of questioning is to assist the witness in relation to what she said earlier. And he is drawing her attention to this part, to say, in the report, they did mention that they analyzed the evidence in the dockets, in the 23 dockets. That's what they say in paragraph 82.
82.
But when you look further, they give a table of those cases. But there is no summary of those cases at all. They just mentioned the case numbers. Is my understanding correct?
Correct, Madam Chair.
You remember the witness had earlier testified that when I asked her about whether she read the DECOC report, she said yes, she got it from the media. And then she confirmed that in the report, there are no summaries of those case dockets. And this is confirmed by what she is now saying, answering Advocate Nkwaitobi. And counsel is saying, other than just a table of those case numbers, there is no content. There is the summary of the dockets, the contents of the dockets.
We accept that, Madam Chair.
Are you following that?
Yes, we accept that, yes.
Thank you, Council.
Thank you, Madam Chair. So the second case is 23 May 2009, Pinetown, CAS 1000/05/2009,
Okay.
where
I may be losing you. Are you still at SB 3160, looking at that table?
at that table, yes. So that's item number 13.
13, yes, thank you.
on that table.
Yes, Pinetown.
Yes.
Okay.
The third one is the Rustenburg case, which is item 15.
Yes.
The fourth one is Kwamashu, which is item 16,
Okay. Noted.
where the deceased is Gladwell Thokozani Njapa.
Okay.
Fifth is Phoenix, 377-0809, item 14.
Okay, noted.
Item 14, under the column of 2009.
Okay.
Can you see that?
Yes, I see that.
Next one is Becky Temba in 2010, item 19, case 44/5/10.
I see it. Yes.
Sorry to disturb you. Are you cross-referencing with the cases, with the dockets that were analyzed by the
Yes.
witness?
Yes, yes.
Thank you.
Thank you. And then we skip to 2011. Durban North, 4th of July 2011. By the way, on the 4th of July 2011, it was a killing spree. They killed 3 people in different areas.
Yes. That's the one of whom was in a dustbin.
Yes,
That's-
one of
that's
them
the
was,
one.
that is Mr.
Yes.
Mbonambi, that was
Yes.
killed in the dustbin.
In his brother, yes.
Yes. Now, that would be all of the Durban North cases, 20, 21, 23.
Yes.
And then Esikaweni,
Maybe just are you deliberately speaking in two? I see you saying.
no, Madam Chair, 20, 21, 22.
Your
Yes.
mic was not on.
Yes. So those are the 3 that were killed on the same day. Yes. And then Esikaweni, item 23.
Yes, I see that.
And then I see that I've overlooked one from 2008, which is Kwamashu case 314. That is item 9.
Okay. I see it as well.
Yes, and then Tongat in 2009, case 356. That's item 11.
Okay, yes.
And then Kwadukuza, that's 2010. Yes, that's 17. Sorry, I've got it now.
Yes, I see it.
Now, the reason we had to go through this exercise, even though it is a tedious one, is that if the only thing you read as the NDPP, which is what we now know to be the case with Advocate Batohi, she would know absolutely nothing about at least 12 of the dockets. Because even her own, the best version she had, other than referring to those dockets, did not analyze a single statement from those dockets.
Exactly.
Yes. Now, if she had just taken your report, as imperfect as it is, which analyzes all 23,
Yes.
she would have actually found that it's substantive. It explains what is the case.
Yes.
Yes. So you have a scenario now where Advocate Batohi acts unconstitutionally because she fails to observe Section 179. But she also acts irrationally because she simply does not have all of the evidence.
Yes.
I mean, if she read this report, she would have realized that the majority of the dockets are not analyzed in the report.
Yes. Yes.
Now, to come back then to your earlier point that you made, that you realized when you looked at this report that these people did not read the docket. Can you contextualize now that answer again in the light of what we've gone through?
It is the same. I can see they did not. If they did, like, I don't know how, but it's not enough for an NDPP to decide based on this to say there are there's no evidence for the racketeering charges and to withdraw them based on this.
Yes.
If she got this report in addition to prosecutor's report as well, perhaps, or reading the dockets, yes, but not only on this basis. It's not enough.
Yes. But would you agree with the submission we will make at the end of this inquiry,
Yes.
that her decision, other than being unconstitutional, was also irrational.
Yes, I agree with that.
Yes. Now, I want to go further on this because it's a big part of your case to say that, look, we've got a strong case for racketeering,
Yes,
but it's being withdrawn for unclear reasons.
yes,
And you remember that Advocate Mutsweni, under the guise of clarification, tried to take issue with your analysis
yeah,
of the statements and the racketeering case against Major General Boysen. You remember that?
yes, I remember.
I want to just take us through that case. I'm going to do it by reference to documents.
Okay.
You should have cross-examination file 1 in front of you.
Okay.
Now, before we go through this, you remember the main defense that is repeated on behalf of Major General Boysen
Yes,
is the idea that in the killing of Demande and Magoje,
yes,
he came after the event.
yes.
Yes. Now, let's see if the documents support that.
Okay.
The useful starting point is page 1,
Oh,
which is dated the 5th of September 2008, and it's a letter from Sapani attorneys.
oh yes, I see.
Are those the attorneys you were referring to?
Yes, through Mr. Nkosinati, Hopewell shows.
Yes. Now, Mr. Shezi,
Please take me to that page
it's
again.
page one, Madam Chair,
Page one.
of file 1
Yes.
of the cross-examination bundle.
Is that the Sapani attorney?
Sapani attorneys, yes. Now, the gentleman you referred to is listed as the sole proprietor of the firm at the foot of that page,
Yes.
below the line.
Yes,
Ngosinati Hopewell shows.
yes.
Is that the person you are talking about?
Yes, is the one.
Now, it's important to actually go through his letter,
Yes,
and we will come back to the role of Mr. Boysen afterwards.
okay, yes.
So, the first thing he says in the first paragraph is that they represent the Mapumulo Taxi Association, and then he refers in the second sentence to the murder of Superintendent Kongo
Yes.
on the 27th of August 2008. And then he says, after that, there have been unlawful acts perpetrated by the police against the members of the Mapumulo Taxi Association, accompanied by a disturbing disregard of the rule of law and the constitutional rights of the individuals concerned.
Yes.
Okay? If you then go to the following page,
Yes.
the first thing he explains at page 2, paragraph 1, you can ignore the main paragraph, just go to where it's listed, paragraph 1.
Yes.
Yes. Where he says, on 27th August 2008, it was specifically arranged with a control prosecutor at Stenga Magistrates Court that 2 of our clients who appeared on that day, Siwayo Mkhize and Gedwane Mhlongo, would be detained at Westfield Prison until their next court appearance. This arrangement was made following extensive complaints by our clients of abuse by the police while detained in police cells during investigations. The magistrate duly ordered that our clients be detained at Westfield Prison and signed detention warrants to this effect. So
Yes, I see that.
you now have complaints of abuse in the police cells. And then you have a judicial officer who says, don't go to this particular police cell, go to Westfield.
And that kind of abuse, if I may say, it was also experienced in another case, the 466 case.
Yes.
Yeah, where Toshan Pandey and Colonel Nevin Madu were accused. The
Yes.
same kind of actions by the police
Yes.
were also alleged there.
That's why Major General Boyson wanted to be among the people who were visiting them, despite being a complainant.
Yes, and gave an instruction to that effect while he's a complainant in the same matter, yes.
Yes. Now, then this is where it really gets disturbing. Both
Yes.
detention warrants were thereafter unlawfully and intentionally altered by the police by deleting Westfield prison and inserting Cato Manor police cells as the place of detention. So there is a warrant of detention signed by a magistrate for a different station. The police then change it on their
Changed
own. Yes.
Yeah, I see that.
Yes.
It's
Now,
not surprising, really,
Yes.
honestly.
now, what then happens there is set out at paragraph 3, 4, and 5. So
Yes.
basically, they are interrogated and then severely beaten up.
Yes.
Yes. And they are also denied access to a lawyer.
Yes.
Now, that is just one instance, but it goes further. If you go to paragraph 7 of page 3,
Yes, I can see it.
now, that refers to Mr. Moses Sipodlamini,
Yes.
who surrenders himself because he hears that his name is being listed in association with the killing of Mr. Kongo.
Yes.
And then he surrenders himself.
Yes, this Mr. Moses Dlamini is one of the witnesses. His statement I've attached and referred to in my affidavit as well, and he
Yes.
explains the incident, the very
Precisely.
same torturing incident. Yes.
Yes. He is also sent to Cato Manor and then is tortured there.
Yes,
Yes.
that's what he said in his statement. Yes.
Yes, and that is set out paragraph 7, 8, 9.
Yes.
And then more people are also detained. Paragraph 10. That is now Mr. Magojela, that's Magojela and Demand, and
Yes.
Mr. Tembe.
Who were later killed near Howick. Yes.
Yes, that's the Howick case,
Yes.
where Mr. Boysen was directly involved.
Yes.
Yes. Now, but what then happens with Mr. Magojela and Mr. Tembe is that they are released after the detention.
Yes.
And they are told, when we want you, we will call you.
Yes.
But they are never wanted. And the reason they are released is because the police form the view that there is no case linking them to Kongo.
Yes.
They release them.
Yes.
But thereafter, they murder them.
Yes. So they were not being sought for having
Yes.
committed any offense. And that is the position in most of the cases.
Yes.
Yes.
Yes. And the thing about them is that they had done the exercise of checking whether they are implicated.
Or not, yes.
And then after that, they release them.
Yes.
But then they still kill them.
Yes.
Yes. Now, that you will find at 10, 11, 12. And then at 13 is a different person. That's Lindelane Butelis,
Yes.
who was killed in the presence of his wife, Thandeka Nompumelelo Sokulu. You remember that earlier on you were
Yes.
not able to trace the husband of Ms. Sokulu.
No. I know who her husband is. It's just that the statement that we now have as part of my affidavit is the one that pertains to the application by Mr. Bongani Elfas Mkhize, who was applying for an interdict not to be killed by Ketomena. But in her initial statement, just that I did not have it when I was doing the affidavit, in her initial statement, she indicates there that her husband is Lindelani
Buthelezi.
Buthelezi, as I remember, yes.
Yes, okay.
And he was killed in her
Yes.
presence. Yes.
If I may just also assist counsel, I think it is me who might have misunderstood, because in that replying affidavit, deposed to by Ms. Sikulu,
Yes.
she kept on referring to my husband. And by the way, it was an application by the late Mr. Mkhize, where she sought an interdictory relief. And she deposed the replying affidavit, but she referred to my husband. And I wanted to clarify that aspect as to who precisely was her husband. And she said it's Mr. Lindelani
Buthelezi.
Buthelezi, not Mr. Mkhize.
Okay, no, thank you for the clarification, yes. Now, this is why then this letter, when you see where it ends, it is at page 7. So they've detailed their members that have already been killed. They have also detailed that there is a hit list.
Yes.
They have also detailed that there is a torture chamber at Ketomano.
Yes, Mr. Matonzi and or Mr. Mtiani also mentioned a hit list
Yes.
where people will be killed and their names. And indeed, those people were killed by the Ketomena under the pretext of being sought for having committed criminal offenses.
Yes. Now, this is why then in paragraph 7, they say, look, gentlemen, if you want our client,
Yes.
approach us. We will bring those clients to...
Counsel, which paragraph?
Yes, now, paragraph, page 7.
Page 7, that will be paragraph 19.
Paragraph, yes, it starts at 19, correct. 19, Roman figure 1. Yes, sorry. Any member of the Mapumulo Tax Association sought to be questioned in connection with any investigation pertaining to taxi violence or the murder of Senior Superintendent Kongo is allowed legal representation at all relevant times during the questioning. Our clients have nominated our offices to represent them in this regard and will require that our office be contacted before questioning or interview is undertaken. We wish to make it clear that this applies equally to persons considered suspects and those considered witnesses, because the police have acted unlawfully irrespective of the status of the person they question. Then, if you look at the last sentence there, we wish to record that our clients will honor any subpoena issued in terms of Section 206 of the Criminal Procedure Act, and we welcome the use of this process if it is deemed necessary. Any member of the Mapumulo Tax Association who is arrested or detained, whether or not he is charged, requires to be legally represented and nominates our office in this regard. We require that our offices be contacted immediately if an arrest is made. Now, and that's how they end. They say, we are available. Come to us if you want our people.
Yes.
Yes. Now, that is a letter of demand of the 5th of September.
Okay.
Yes. Now, that is to be read together with page 9 of that document, which is the complaints written to the Human Rights Commission, IPID, the Police Commissioner, and the Public Protector,
Yes.
dated the 23rd of September.
I see that.
Now, in this letter, they repeat these events, and they say, look, we've had no joy. We are now asking you to intervene,
Yes.
these organs that are mentioned there.
Yes.
So that goes on up until page 26.
Yes. I see that.
Now, by this stage, if you look at the period between the 5th of September 2008 and the 23rd of September 2008, Mr. Magoja Landimande has been killed because he was killed on the 16th of September 2008.
Yes.
And Mr. Tembe was killed because he was killed together with Mr. Magoja.
Yes.
And the letter of demand was written precisely to avoid the killing of Mr. Magoja.
And Mr. Mkize
And
late.
Mr. Mkiza was killed later as well.
Yes.
Yes. But in between this, just within a week, they had killed one of the people that they said, please don't kill him. If you want him, we will bring him.
Yes.
Yes. Which explains why they have become so desperate now that they are reporting to the national institutions.
To all authorities in desperation.
And then no one intervenes.
No one did.
Yes. Now, inside the police,
Yes.
what was happening during that period? Because at this point, we have 5 people that the police have killed. It's common cause they were killed by the police.
Yes.
Go to page 27, where we see what's going on inside the police.
Yes, I see it.
Yes. What we then have there, we have a letter dated the 21st of October 2008. If you look at the stamp on the top right corner,
I can
see that it's 21 October.
Yes.
And then there's also another stamp, 17th of October, on the left at the top as well.
Yes, I can
Yes,
see
so I'm
this.
not sure when exactly it's signed. And there's another date, 15th of October. So that it's got 3 days, 15, 17, and 21.
I think they were received by various sections or divisions within SAPS. As you see, the 17 October 2021 was received by Detective Services. They stamped it, and it went to Auxiliary Services. They received it on the 21st of October. They stamped it.
Yes. Oh, I see.
Usually, that's how I understand many steps
way it
in
works.
a document to mean, yes.
Yes. But the person who signed it is who?
Provincial Commander, Director J.W. Boysen, Organized Crime KwaZulu-Natal.
That's Major General Boysen.
Yes.
Yes. Now, we will go later to show that he is aware of everything that has been said by Mr. Hlapane.
Yes.
Yes. But in this letter, what he is saying at paragraph 3 is talking about Superintendent Tongo, who was shot dead, and Inspector Kanyele, who was seriously wounded.
Yes.
And that the killing of Superintendent Tongo has sent shockwaves through the community. This criminal attack was seen as a direct threat against an organ of state. And then he says the solving of this case was widely reported and applauded by the media and the public alike. And then he says in the last paragraph, it is recommended that the members of the enclosed list be rewarded with a cash incentive of 10,000 rands each, as well as a certificate by the National Commissioner, correct?
Yes, I see that.
So what he's saying here is, my police have solved the murder of Tongo.
And that has been my position, even in my report and affidavit.
Yes.
And my understanding why he was managing and participating.
Yes, but he's saying so himself directly.
Yes, I've seen this document as well.
Yes. Now let's see how they solved it.
Yes.
Because solving a crime, ordinarily for people who have read the Constitution, means someone goes to jail.
Yes, legal processes are followed.
Now the solution to the crime is to be found in a document that starts at page 28
Yes.
and then ends at 242. And that is the document called Monetary and Non-Monetary Awards. Can you see that?
Yes, I can see that.
Yes. Now, if you go to page 30,
Yes,
under paragraph 3,
yes,
it says here the apprehension of 2 more suspects.
yes,
So when you read that, you think that they've arrested people
yes,
until you actually read the content.
yes.
Yes. Now, who are those people that are involved in those suspects? They are listed, the details of candidates.
Yes.
Number one,
Oh,
yes, you can, yes, please read. I was going to ask you.
oh.
Number
okay.
one,
Number one is listed as Director J.W. Boysen.
yes.
That is Major General Boysen. Number two, Captain Lockham. 3, Captain J.J.E. Van Tonder. Captain N. Eva, Inspector P. Mostert, Inspector Makanya, and Inspector Inel. And as far as I know, all of these are the accused in the Ketomena case.
Precisely. Now, he himself says these are the people that have solved the murder of Tongo.
Yes.
I am the first one.
Yes.
Yes. Then listen to the summary of the events. He explains how they were solved.
Yes.
He says, on Monday, 15 September 2008, Director Boysen, the provincial commander, contacted Inspector Mostert and informed Inspector Mostert that he had information pertaining to the suspect that had organized the hit on Superintendent Tongo. He was in Virginia in the Orange Free State and en route to Pietermaritzburg to collect some cash in Pietermaritzburg. During this time, the informer remained in contact with Director Boysen, who continued to relay the information over to the investigation team.
Yes.
So in other words, the start of this operation is initiated by Director Boysen,
Yes, exactly.
who instructs Inspector Mostert.
Yes.
The only reason he instructs him is because he is in charge.
Yes, he's managing.
Yes.
Yes.
Now, then, that was on the 15th of September.
Yes.
On the 16th, that's the day they killed Mr. Magojela
And Mr. Tembe.
and Mr. Tembe. Yes.
Yes.
On Tuesday, the 16th of September 2008, at 6:20 hours, that's the morning, Director Boysen contacted Inspector Mostert, again, read the movement of the suspect, who was near the Pietermaritzburg area in a Hyundai Tuscan 4x4 with registration NRP 3904, and that he was armed and dangerous. The investigation team consisting of the above members immediately departed to Pietermaritzburg.
Yes.
So again, the person who initiated the operation is Director Boysen
Yes.
by instructing Inspector Mostert.
Yes.
By the way, Inspector Mostert faced 79 criminal charges. All of them were wiped clean by Advocate Batoi and Advocate Harrison.
Yes.
Then, the same day, at 8:30, the investigation team, still consisting of the above same members who were in Pietermaritzburg, continued to receive further information from Director Boysen.
Yes.
And at 10:10, information was received that the above vehicle was en route on the N3 towards the Orange Free State. The vehicle was spotted near the Cedar turn-off by the investigation team, the occupants being two persons, a driver and a passenger, seated on the back seat of the vehicle.
Yes.
The investigation team, which at this stage consisted of Inspector Mostert, Nel and Makanya in one vehicle, while Captain Van Tonder, Lockham and Eva, who followed in a separate vehicle. Inspector Mostert managed to catch up to the vehicle, and in an attempt to get the suspects to pull over, the official blue light and siren was used. We know that not only did he start it, they themselves say he remained in contact with them throughout the operation.
Yes.
Yes. Then he says a shootout then took place between the passenger of the suspect's vehicle and the investigation team, resulting in the driver of the vehicle being injured in the process, which resulted in the vehicle stopping. Now, at this point, they don't explain who started the shooting.
Yes.
They say a shootout happened.
Happened.
Yes. Then they say the passenger in the suspect's vehicle during the shootout made an attempt to flee
Yes.
from the moving vehicle, which resulted in him being flung out of the moving vehicle. So even on their own version, he was running away.
Yes.
Both the suspects were fatally injured in the shootout. The driver was positively identified as Timson Magojela Ndimande and was the main brain behind the assassination of Superintendent Tongo. Now, this statement, we know it to be false because of the letter of the 5th of September 2008, where Mr. Hlapane says to them, you arrested him, you interrogated him, you released him because you had no evidence.
Exactly.
Yes.
And that is why, sorry to interrupt, that is why in the predicate offenses. One of the murders is of Mr. Magojalan Demand.
Yes, Mr. Poison is charged for the murder of Magojalan Demand.
Yes, as one of the predicate offenses.
And the second one, because you need two, and the second one is Demand. Sorry, is Tembe.
Dembe.
Yes, correct. Sorry. And then it says, the following firearms were found in the vehicle: one AK-47 rifle with loaded magazine, one, it should be Ruger or Ruger Mini 14 automatic rifle, and 2 magazines, as well as 2 9mm Noriko pistols, both with loaded magazine.
And if I can interrupt again, please. And that's where the other predicate offenses come from. Remember counts 9, 10, 11, 8, 9, 10, 11, 12.
Yes.
The first two are murders.
Yes.
That's Magojalan Dimande and Tembe.
And Tembe, yes.
And then the three, the first one is possession of an unlicensed firearm, that's the AK-47. And the second, what is this? The fourth predicate offense will be the possession of the ammunition for this very same AK-47, being the 40 rounds, bullets thereof. And then the fifth predicate offense is the defeating the ends of justice for having placed the firearm there.
I see.
So that's the 5 predicate offenses, and they meet the requirements of the racketeering charges.
Now, just to come back to the narrative of how they were not being investigated at this stage when they wrote this report. So
Yes.
they were just writing the report freely.
Yes.
But the way they explained it is very shocking. They admit that one person was trying to flee when they shot him. But in relation to the second person,
Yes.
who was the driver, they never say that that driver attempted to shoot at them. They actually say a shootout occurred. You see.
Yeah, I see that.
Now, this whole story that has been peddled for years, that Major General Boysen arrived at the scene after the shooting, given what they themselves say that he was actually the initiator and remained in contact throughout the operation and came afterwards, I mean, can that be true, or is it blatantly false?
It's not true, and this was attached to the prosecution memorandum. I saw this,
Yes.
and that is why I also supported the prosecution. It's
Well-
not true that he only arrived late. He started it, coordinated,
Yes.
like arranged everything.
Yes.
Yes.
Well, the person who actually didn't see it is Advocate Batoyi.
But it was there. I don't know whether it was given to her or not. And the DIGOG panel, I don't know if they saw this.
Yes. Well, the court panel repeats the lie that Major General Boysen came after the scene.
And turn around and say, we lied against Major General Boysen because he was investigating some people, whereas the truth is here.
Yes. Now, if you then look at here it's clear who they say were involved in the killing. They've listed them themselves: Boysen, Lockham, Fantonder, Eva, Mostert, Makanya, and Nev. It's clear who was killed. It's Ndimande and Tembe. And it's clear the method of the killing.
Yes.
It was just a spray gun approach.
The same modus operandi in all the cases, and a firearm is placed there.
Yes.
Yes.
You are now referring to the details of the candidates,
Yes, the
the
details of the
apprehension
candidates.
of the suspects.
Yes, yes. And paragraph 3, correct. Yes, paragraph 3.
It is 5:30 almost. It is 5:30 almost. I don't know whether we are interrupting your
No,
cross-examination.
this is the right moment.
May we pause here? Hopefully, we will be able to finalize the cross-examination before midday tomorrow to enable the evidence-leading team to re-examine.
Yes.
With my plea, or our plea, that we release the witness timelessly tomorrow. Oh, by the way, she has to travel
No, Madam
Yeah.
Chair, we're planning on finishing by 1 tomorrow.
by 1 o'clock tomorrow. Yes, thank you. the event, we will adjourn until tomorrow, 9 o'clock. But before we adjourn, we would like to remind you, Advocate Skosana, of the request you made 2 weeks ago when you requested that you were going to establish whether there is a conflict of interest in relation to the involvement of Advocate Halley and Junior as regards the decision of the minister. The evidence leading team has not come back to us. We cannot leave that matter hanging because we spent the whole day exchanging views in relation to that matter, and we need to know where we are in relation to the matter. The mic is on. At one stage, probably tomorrow, you would then have to indicate to us what the position is. Remember, Advocate Batoyi is still on the witness stand, still undergoing cross-examination, and you sought to apply or request on her behalf that it be found that there is a conflict after you ascertaining with whoever, so that the minister can revisit her decision. Am I correct?
That is correct, Madam Chair.
We are therefore saying to you that matter cannot be left in the limbo, because that witness, Advocate Batoyi, has not finished her testimony. And it is your witness as the evidence leading team. You should therefore tell us of the status of the request that you made 2 weeks ago. Indicate to us what you have found, what you have decided. If you would have approached the minister, do let us know, because we need to progress with the evidence of Advocate Batoyi.
Yes, we will endeavor to bring the report tomorrow, Madam Chair.
We will adjourn until 9 o'clock tomorrow morning. Thank you. You are still under oath, madam?